Hi guys! First things first, happy birthday to Adventure Erin. Hope she is having a great day. Even if she doesn't get to hang out with us today, I hope she's just enjoying whatever she's doing. For the rest of us, we are going to be looking at trial transcripts. And thank you so much to Christy for getting these together. We're not going to reread the entire trial. We are going to be looking for sidebar transcripts by looking for any time there's parentheses being used. And we'll of course have to skip some stuff, but it seems like the best way to get us to these little notations that, hey, the jury's leaving, we're going to have a bench conference, and we'll see all of the things that we didn't get to hear from watching the court feed. Tomorrow, so Monday and Tuesday, the 29th and the 30th are going to be the next, and they're supposed to be the final hearings for the post-conviction relief petition. So the state's going to present their evidence, and then we're going to have, I don't know if we'll have rebuttal, but we'll get to closings. Those are starting at 8:30 Central, which is 9:30 Eastern time. So I'm going to be live all day. Come hang out. Come see what happens. We're going to hear from Boat Guy. It's going to be a time. And I think we're going to have such a depth of knowledge from going through all of the old media coverage, rewatching the 2017 trial, looking at these sidebar transcripts, and again, going through, we just finished doing the docket deep dive for the post-conviction petition. So really excited to see like how this closes up and what the final words are before it's in Judge Bradbury's hands. And of course, I'm rooting for a new trial. So hey to everybody, Gwennon's here with a reminder to hit that like button on the way in. Leave your DNA. Thank you so much, Gwennon. Good to see you. Hey to Christy. Hey to EJF Aaron. Good to see you. Who says happy Zach and dog 4th Eve. Hey Nem. Hey Ems. Hey J Money. I love the sunshine we've got going on. Slim Life NJ is in the building. We've got Factual Lie. Good to see you. James Phipps. K Tally. We got Mary W. It was good to see you last night over at Hal's live stream. And thank you guys. When we were ending the stream here, you guys put in the chat that Happily Angry Lawyer was going live. Had no clue. So thank you guys for rushing that in when we were ending yesterday. He's supposed to go live today, he thinks, for a anniversary stream relating to Moontung. So I don't know the exact time, but we'll keep an eye on that before we end the stream today. And Nick Starrow's doing a 3-year celebration, 30K subscriber celebration, or 20K subscriber. Don't ask me about numbers. So those are two things that I'm looking forward to later this evening. Other than that, you guys, we've got Katie sneaking in and Ike sneaking in. Good to see ya. Good to see you. We're going to have 2 Chucks in the building. Very good to see you, Ike. Hope you are doing well. And this is a doozy. So let's see. The first parentheses we had here, of course, were just phone numbers. And this is starting with volume 3. So what was available started with volume 3. This is the day the trial started. So we don't actually have the voir dire transcripts. I'm assuming those were volume 1 and 2. So can't see those, unfortunately. So here they're going to say the jury was brought in. And this is in the jury presence, not a sidebar. But they're talking about how to line up the jurors. So they've got 15 people. All right, and now they're going to have a sidebar. So it looks like they are talking about the grand jurors of the state of Tennessee, duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present, that Zachary Wright Adams, Jason Lee Autry, and John Dylan Adams here to wit between April the 12th. And it says, may I approach, Judge? And the court says yes. So there's a conference at the bench that goes as follows. So Miss Jennifer Nichols, Prosecutor Nichols, says, do you want me to continue reading all 3 defendants? The court says, no. Miss Nichols says, okay. The judge says, don't read all 3 defendants. Miss Nichols, all right. The court says, just read 1. Miss Nichols, I assumed, but before I went any further, the court, she's already read all 3 of them. And then that's the end of the first bench conference that we've got. So then she goes back to the jury and she says, I'm going to start over. And let's see. Then she just says Zachary Wright Adams. So, a mess already. A mess already. All right, so next up. All right, the jury's excused. So why is the jury being excused here? The court says I'm going to take a recess. Why were they saying that? Who's speaking first? They're speaking a lot. This might be Paul Hagerman. Yeah, their own words. I think this might be Hagerman's opening statements. So maybe they're just taking a recess after that opening statement. And they're going to say the following proceedings were had. So outside the presence of the jury. The judge says, all right, let me have counsel's attention. This isn't that big a thing. I just want to make the record clear. The jury's filed out. Neither side exhausted their peremptory challenges yesterday. I'm showing that the state, there were 17 rounds. The state challenged 9 people. The defense challenged 16. So I just wanted the record to reflect that, okay? So he just calls a recess in the... Anyway. It's an odd time to call a recess to put that on the record. Anyway, so they bring the jury back in. And now the defense is ready to do their opening statements. So let's find the next sidebar. All right, this looks like they're going to take a recess. It says, I don't like to break up argument, but I've promised people that we're not going to be coming and going, except we're going a little bit after 10. So we're going to try to hold it to 15 minutes, but the bailiffs will let me know when we're cleared with the restrooms. You'll find goodies up there. Follow the admonitions I gave you at the outset. The jury can file out. The jurors, counsel, stay with me a moment. So the jury is excused from open court, and the following proceedings are had. The court says, oh, wait, this is the same thing. Sorry. I think the search took me backwards. All right, then they're entering exhibits. All right, so they're going to go to recess. This is their lunch break. 1 hour for lunch. Have your next witness ready to go at 1. All right, gentlemen that are going to guard the jury, raise your right hand. So they excuse the jury and they swear in these 4 names. And apparently one of them is supposed to be a relative of Dana Bobo. So Curtis Manfield Jr. spells out his name. Ricky Bratton spells his name. Dwayne Stanford and Mark Asbill spell their names. And then they come back after lunch. When they come back from lunch, the judge is talking about the temperature and says, be seated, please. Are you folks reasonably comfortable as far as temperature? Like I say, I'm hot-natured. I'd freeze you to death if I got it to where I wanted it. Oh, good times. All right, so that's just a witness nodding, exhibits being entered, witness nodding. And that looks like the only sidebars, bench conferences that are noted in the day that they did opening statements. So next volume. So let's go to volume 4. That was volume 3. And this is actually still September 11th. So, okay. Maybe they're breaking up the transcript volumes in the middle of the days. Yeah, and so Karen Bobo's still on the stand for these. All right, so let's look for more parentheses. So not too long into court. Court says, be seated, state and spell your name. Karen Bobo starts speaking, and then the court says, let me see counsel up here just a minute. So as soon as they have Karen take the stand, the court calls a sidebar and says, there's 2 things I want to cover at this time. First of all, I think I've made it abundantly clear earlier that there's to be no mention of polygraph concerning anybody, anything. So, Clint Bobo took a polygraph. Now I think everybody's on the same page with that. And we're going to have a motion in limine by the state concerning this witness that's still in place, okay? You know what I'm talking about? And Ms. Thompson says, yes, sir. The court says, okay, let's go. So I think a lot of this was blocking conversations that could go to different statements from the Bobo family to law enforcement relating to what Clint Bobo was doing. Oh, wait, can you guys see me? Or is it YouTube on someone else's end? Oop, did I do something wrong? Kinda, I changed it. Hold on. What is cat time? Okay, just making sure all is good over here. So let's keep going. So they've got, you know what I'm talking about? Ms. Thompson says yes, and that was the end of the bench conference. So they bring Karen up there, they call a sidebar, and just to say, just to remind you of the motion in limine, as if the court on their own is calling a sidebar to remind Jennifer Thompson, defense attorney, that they need to do what they're supposed to do as an attorney and follow the order as it relates to the motion in limine. So that's the first witness, and the court is already presuming that Ms. Thompson isn't going to have duty of candor to the court. So, let's see. Next up, I think everybody already knew what I mentioned. So they're back in court and then said, but did you spell your name for the record? Why would he, when everybody comes back in, why would he say that? Anyway, they enter in, there's going to be a bunch of exhibits. That are going to give parentheses, skipping all of them. Because remember, they had Karen Bobo, the victim's mom, identify all the personal affects until she got upset and passed out on the stand. All right, so here they're saying, let's take a recess. This is where she passes out. So can we just take a minute? I'm feeling sick. The court says, let's take a recess, and I want everyone to remain with me while the jury files out, please. Need a nurse. Member of the audience says, I'm a nurse. The court says, come on. Let's let the jury go ahead and file out. Get some lights. Lights clerk, please. Everyone else remain with me, please. All right, let's close the media down, please. No more media. And then it says, after a time off the record, the following proceedings were had. The court. All right, everyone that's in this courtroom, you are not to be on any type of social media identifying any of these jurors. That's absolutely prohibited. We've had a little breach. It wasn't a media member that did it. We're taking care of it. But I want each of you to understand, you don't identify jurors. Their privacy is very, very important. And then after time off the record, out of the hearing and presence of the jury, the following proceedings were had. The court. Defense counsel indicated that they wanted a jury out. Be glad to hear anything. So Mr. Simmons, Jim Simmons, that's defense attorney, says, Your Honor, Jim Simmons on behalf of Zachary Adams. At this point, we would make a motion for a mistrial. And I think we saw this. So the jury's not there, but we were able to watch this. I'd like the record to reflect that at the time Ms. Bobo was being cross-examined, Ms. Nichols was she wasn't being cross-examined. That was direct examination. She was being handed certain items, very personal items, and at that same time, apparently Karen Bobo suffered a panic attack. She passed out in front of the jury. She required medical attention. And under these facts, I think it's going to be impossible for Mr. Adams to get a fair trial in front of an impartial jury. I think they're so tainted at this point that the proceedings should be stopped and a new jury should be called. Court says, all right, let me say this. The witness was within 5 feet of the court. She said words to the effect of that she was not feeling well. Before I could get a recess called, and we had a little problem I was trying to solve media-wise, that I'd almost called a recess. Well, this is interesting because he's before addressing this, in between Karen passing out, he addresses the court about the potential identification, the social media post about a juror. And now he's saying, well, even before she was saying she was feeling sick, I was trying to deal with that. But the record was going, like she was testifying. So what do you mean you were trying to solve that problem media-wise before you could get a recess called? You had no problem calling a recess the second Karen Bobo took the stand to remind Jennifer Thompson about the motion in limine, probably about changing statements that the Bobos gave to law enforcement, or about her son Clint. So why didn't you just call a recess or say it when you came back from the other recess? So this is just weird. This just seems like a random excuse being thrown in. Like, oh, it's not Karen Bobo's fault that she passed out. I was going to call a recess anyway, but I couldn't call it quick enough, even though I wanted to call one for another reason. Who knows? Anyway, but he goes on, he says, but before I could get a recess called, she in fact had a medical event and she passed out cold. This chair is fixed, so they had some difficulties extricating her. The jury was in passing or filing out the door at that time. He didn't want to say the word passing. This was clearly a medical event. There's no question. This was not something faked to gain sympathy. This lady had a medical issue, a nurse came up immediately. Thank you, whoever that was. And then they've had paramedics on call. The sheriff's he's had them here arranged since day one. They won't give us an ambulance, but they will give us paramedics close. They have dealt with her. They feel that she's ready to go now. They said extremely low blood pressure when they first started, as I understand, very rapid heartbeat, the types of things that are consistent with syncopic events, okay? And I know because I've had them, and they're no fun. But this was not something that was done in an effort to achieve any type of sympathy or anything. If you want me to, I'll instruct the jury that they are not to give any sympathy whatsoever because of the fact that Ms. Bobo apparently had a medical event, but your motion for mistrial is overruled. Simmons says, Your Honor. The court, do you want me to instruct them to that? Yes, Your Honor. Okay, Mr. Simmons. I would ask also, Your Honor, after they finish their direct examination, we would like, of course, to have an opportunity for cross-examination. Because of the medical event, we would ask that we have a recess until the morning to begin our cross-examination. The court, I'm not going to do that. I will continue to watch. Basically, the paramedics have given me the thumbs up at this time. So I'm trying to march this case toward conclusion. I don't know any reason to lose that kind of time. I'll make sure that you have an adequate opportunity to cross-examine, okay? Mr. Simmons, thank you, Your Honor. The court says, all right, let me say further. There's no manifest necessity to grant a mistrial at this time. I will give a curative instruction, very short, okay? Mr. Simmons, could we approach, Your Honor? The jury's not even in here. Yeah, okay, yes. Mr. Simmons, Your Honor, the issue about the cell phone and the juror being identified, the issue about apparently, someone somehow has gotten on social media that some of the jurors that are identified and that we want to inquire to the court as to whether there are going to be contempt proceedings or how do we... The court says, that's up to the court. Let me tell you, first of all, it's more, as I understand, a violation of the spirit of the law rather than the letter. He wasn't naming names, but he was giving descriptions that in a small town would lend itself to identification. His Rule 30 credentials have been pulled. He'll not be back in the courtroom, okay? And then that's the end of that bench conference. Out of the presence and hearing of the jury, Karen Bobo returns to the witness stand, and then they continue the questioning. So... I don't know. The judge is acting like, oh, I was trying to deal with this juror issue, but then downplays the juror issue when Jim Simmons asks about it. Yeah, like Ike says, I would ask for a mistrial because the judge is handling a media problem during testimony. A judge texting while judging. And have you seen the football stuff where he's caught watching football? So, oh my goodness, just a mess. Thanks for becoming a member, Ems. Appreciate you. What a time. What a time. And hey, Kelly, good to see you. See you coming in here. Just a time this whole time. Yeah, so the judge, and we watched the post-conviction hearing, some of them, before we went back and watched the 2017 trial. And one of Zachary Adams' trial attorneys, Jerry Gonzalez, he came on at the last minute. But he testified at the post-conviction hearings about issues with the court, how the judge would stand outside in the hallway when Zachary Adams was walked into court every morning and leaving, he would leave the bench and go into the hallway and stand at the door with his gun showing on his holster, like right next to where Zach Adams has to walk by. And there was just this constant pressure. You should just be taking a plea. You're facing the death penalty. Just take a plea. Why? Just end this thing. And additionally, Jerry was like, I don't think the judge was paying attention. There were times where he was watching football. You think he was watching football? Oh, I know he was watching football. And then we watched the 2017 trial, and twice we hear, like, announcer voices blaring from his cell phone at the bench. So he's just sitting there watching football. And he's also offering the jury who's sequestered, like, favors to help them be able to watch the football games and get tickets to some local game. Just good times. Very attentive court. Very attentive court. So, just crazy. And yeah, Mary says my life is on the line and he's watching football. Yeah, not something that I personally would appreciate if I was in that position. Let me see. Where were we on the search? This is probably going to take me back up. Yeah, you see how it's going all the way back up? It's like counting these twice, so it's redoing all of these. All right, Karen Bobo returns. All right, so now they're going to call a sidebar about the Jenks material. So let's read the context before they call the recess, because they're arguing in front of the jury. There are many times where these arguments start in front of the jury, and it takes them quite a while to get the jurors out. I think this is still Karen Bobo on the stand. She was at the mall. She's talking about being at the mall. Maybe this is Dana. But is that when you learned about the remains being found? Yes, ma'am. I believe it was. That happened on a Sunday when they called and told us that they had found human remains. And they said it might be several days. But I believe they came back Monday night and told us that it was Holly. And then Miss Nichols says, I don't have any further questions. Court calls for cross-examination. And Jennifer Thompson says, Your Honor, first I'd like to ask for Jenks material for this. The court looks at Nichols, presumably, and says, anything from you? And Miss Nichols says, we've turned over, as Your Honor knows, every statement and whatnot that we've ever... The court, I asked you hopefully to do that where we wouldn't have to take after each witness breaks. Miss Nichols, yeah, we did it during the course of discovery. I haven't turned over anything today because they have it. I don't have anything else. Miss Thompson, weren't there some text messages that were going back and forth with the family? I thought there were some text messages. I'd ask for those also. Miss Nichols, I have no idea what she's talking about. May we approach text messages between who and who? So the court says, take the jury out for a moment. All right. So the jury's out and court says, state saying they've turned over all Jenks material. Any statement, at least the court reporter can spell Jenks material, unlike the judge. Any statements that this witness has made. Miss Nichols, I don't know. I honestly don't know what she's talking about. We've turned over the hard drive. We've had multiple, discovery hearings. We have, I know that we've provided the IRs that have her statement. So she'll have to tell me what text messages. Miss Thompson, well, I just want to make sure there's not any text messages that were going back and forth between Miss Karen Bobo and members of the TBI. If Miss Karen Bobo's texting them, then those would also be statements that she's making, Your Honor. I'd like copies of those. Miss Nichols, I don't have them. If that happened, then I don't have them. So the court says, okay, they don't have them. Miss Thompson, okay, well, did they exist? And I say the state has a duty to ask the agents. Also, if there were text messages. If there were text messages, they have a duty to preserve them. And I'm asking that they be turned over or that I either be given notice that they existed. At one point, there were texting going on between Miss Bobo and TBI agents, and they're no longer preserved. Miss Nichols, all of the agents that have anything to do with this case have reported to us that if they are an agent that texted with Miss Bobo, that they don't retain, text messaging from their phones. The court, I just deleted a bunch of mine today. Okay, way to back up the prosecutor here. The judge is just chiming in to back up the prosecutor. When deleting your own personal messages is not comparable to someone who's an investigator having a conversation with a victim's mother, deleting messages from that conversation instead of preserving them or turning them over. Ms. Nichols says, right. And Ms. Thompson says, well, I think, and Ms. Nichols says, if I can finish, Mr. Hagerman, I think, has gotten the report from all of them. So Mr. Hagerman, the other prosecutor, says, all TBI, all the witnesses, all the TBI agents. Ms. Nichols, oh, all the TBI agents. Witnesses? Question mark. Mr. Hagerman, yeah. Ms. Nichols, he handled that part. The court, so there are none. Mr. Hagerman, yes, the TBI agents responded to us that they did not retain any of their text messages. The court, all right. Ms. Thompson, So they destroyed them, Your Honor, and I say they had a duty to preserve those text messages with witnesses. If they've destroyed them, then I'm going to want some type of instruction to the jury about evidence that's been destroyed. Miss Nichols, for all we know, it could be text messages about, I'm coming to your house at 7 to talk to you. It should be preserved. It should be preserved if an investigator is going to meet with a witness, a victim's family member, especially since we can't trust that they're going to make reports about it. Oh my gosh. Am I muted? Okay, Gwennon says no. Okay, good to see you, blind hog searching for an acorn. Good to see you. So we've got... Oh, this is a mess. And this is while Karen Bobo's on the stand. Guys, this is the first witness that they call. So she's passed out. There's conversations with TBI agents that were saying, well, we don't have copies of them. Well, then you destroyed something that you're supposed to preserve. You didn't preserve. You failed to preserve. Oh, well. The court says, I was fixing to say, meet me at 3 at the Shell station. Miss Nichols, yeah. So, Miss Thompson, but we don't know because I can't. The court, they've given you everything they've got. Let's go. Bring the jury in. Miss Thompson, Your Honor, I'd also ask for a curative instruction. They've allowed in things that people said. It wasn't for the truth of the matter. And like a curative instruction, just to tell the jury that whatever was repeated as what people said is only to put into perspective what happened next. And they're not to consider what they said as being truthful, such as the fact that the Austin family said if people were over there, there'd be full of drug people and drug. And then the court cuts off and says, that's a legal issue. I don't think I've tried to explain hearsay to attorneys. Well, you still have to manage your courtroom. Ms. Thompson says, but I do believe, the court says, there's 7 out of 10 attorneys don't know the definition of hearsay. Ms. Thompson, I believe that there is an instruction available that says that the limited use on what those statements come in as, Your Honor. And yeah, so you turn to the jury and you could say, hey, what you're about to hear is not for the truth of the matter asserted, which means you're not going to hear something that is meant to show the truth of what actually happened or didn't happen. It's just to show you that because this witness heard this thing, it led them to take their next action. So there's curative instructions. Like, I'm pretty sure there's like model instructions for that specific issue. I wouldn't be surprised if Tennessee has a specific curative instruction for this exact issue. And that's all that Miss Thompson's asking for here. And the court's like, meh. And Thompson says, and a curative instruction with respect to what the lady at the Shell station told her. That's fine. That's nothing. A curative instruction with respect to Dylan saying, I'll give him the message. That's fine. A curative instruction as to what Zach told her, of course, would be inappropriate because that was offered for the truth because Zach is, party opponent. The court says, I can't. Miss Thompson says, I'm not talking about Zach. So, and she's right. She's distinguishing that she can't get this same type of instruction for Zach. She's understanding hearsay here. And the court's assuming she isn't. And she reiterates, I'm not talking about Zach. The court, I can't give a curative instruction on every time I rule on some type of objection. Miss Thompson, right, we could have a general one. The court, you probably shouldn't have objected because as an attorney, you should know the definition of hearsay. Miss Thompson, I do know the definition of hearsay, and she is correct. She is correct in what she explained above. Yeah, I do think the instructions are worthless, but still. No wonder Jennifer Thompson was deflated by day 1 of this trial. So she's saying, I do know the definition of hearsay, and until it comes out, I don't know if it's for the content of simply because the state says I'm not doing it for the truth of the matter doesn't mean that's not why it's coming in. And good call. Adrienne Love did the same thing. She would tell the court it's not for the truth of the matter asserted, then we got her yelled at about that phone number that she was I'm not trying to show that that's actually somebody's phone number. It's just to show what Michael Sprinkle did next. And then she has Michael Sprinkle say, yeah, and then that is the phone number. That's the phone number that you're looking for me to tell you is the phone number. So the court says, I'll tell the jury, I'll take care of it. So they bring the jury out, and the court says, all right, let me say, earlier there were some objections based upon hearsay. I'm not going to send you to law school, but I'm going to tell you generally that hearsay is an out-of-court statement made by somebody that is offered for the truth of what is being said. So everything someone else said is not necessarily hearsay by definition. If that is simply being shown to offer why someone did what they did in response to it, it's not hearsay, okay? Everybody kind of generally understand, and that's that first year of law school that you learn that. Some attorneys never learn it, so you folks are up on it, okay? Now, this is interesting because what he's doing is he's explaining the objection and the ruling, even though typically judges say, hey, jurors, you're not supposed to concern yourself with why I sustain or overrule something. And now he's explaining why he's sustaining or overruling something. But he's still missing the critical part of the instruction, which would be, you're not to consider this for whether or not what's being said is truthful. It's just to show you. He's missing that part. So then Ms. Thompson goes back into her questioning, or starts her cross-examination. What a rough way to start cross-examination of the first witness, who's very sympathetic, passed out, victim's mom. Ike, thank you for the super, says ketchup ball. At the end, would someone summarize for me the judgments rendered? Who is in jail besides Zach and Dylan, and is this case totally closed? So what we're watching on Monday is part of like a several month series of dates for evidentiary hearings for Zachary Adams' post-conviction petition for relief. He's looking for a new trial. He was convicted in 2017 and sentenced to life. He was facing the death penalty, but after the jury came back with a guilty verdict and before the penalty phase started, a deal was made, and there's a whole bunch of controversy about how that deal was made, but death penalty was taken off the table, and he took a deal for life without the possibility of parole. So he's been in custody ever since. Shortly after that, his brother, Dylan Adams, took an Alford plea and was sentenced to 30-something years. And then Jason Autry, star witness, Jason Autry, gets time served. He gets time served, no fees, no restitution, no fines. Good times all around, and he was released, but not until after Zachary Adams exhausted his appeal. So he lost on appeal, and what we're watching now is a post-conviction relief petition in front of the trial court. It's a different judge because the judge we're reading about now, Judge Creed McGinley, retired. So we're still in the trial court. It's a different judge because of that retirement. And then Shane Austin was a fourth co-defendant. He was offered immunity. The state wanted to give him immunity in exchange for him being able to point TBI to where Holly Bobo's remains were. And he couldn't do that probably because he had no knowledge of it. And when they rescinded, they rescinded their immunity offer, he's found after hanging himself somewhere in Florida. So, and again, they were all facing the death penalty. So that's the little 411 there. Jason Autry's also still in custody now because he has other charges. He recanted his statement in December of 2023, but the state says you can't trust that recantation because he was on drugs while he recanted, and his trial testimony is still truthful, and you can't use that recantation in this post-conviction proceeding unless you get him to testify at these hearings. And then the state didn't want to cooperate with transporting him, told the court he was too dangerous to transport, and then said, hey, you need to appoint him a lawyer to warn him about exposure if he were to willingly come and testify. So they get him a lawyer, and the lawyer says, nope, he doesn't want to testify. So video can't come in. Recantation can't come into the post-conviction proceedings. So that's a quick 411 there. If you have any other questions, I'll be happy to help out. You don't have to send a super. I'll just try to keep an eye and look. But it is a lot. It is a lot to digest this case. So next, we got to skip these sidebars, or maybe I can just follow the yellow bars on the side here. That might be easier than looking. Oh, okay, maybe I'm not good at where this would line up. Okay, there we go. They enter an exhibit. All right, so after a recess, the jury returned to open court and the following proceedings were had. Let's see if there's anything before this. Okay, they just say, let's take a recess, our last evening recess. No sidebar. And exhibits entered. All right, and this just looks like it's going to be some random parenthesis somewhere. All right, court adjourned at 5:33 p.m. All right, going to volume 5. Let me open up volume 5. Oh, okay, so now it's just saying volume 5. Now it's saying September 9th through September 23rd. We're going to assume this is the 12th. Maybe they tell us further down. Okay, yep, September 12th. So we can still get the date. It's just going to be further down. All right. So it looks like they have quite a long discussion. Well, not that long. So they have a discussion right when court starts before they bring the jury in. So the court says, we're about 2 or 3 minutes until 9. There's been a motion filed that I think we need to take up prior to the jury returning. It was filed today. State get a copy of it? Hagerman says, yes, sir. Court, all right. Defendant, want to be heard on their motion? Thompson says, yes, sir, your honor. The court says, basically saying my instruction didn't go far enough concerning hearsay, which is not hearsay. Hey, I said the same thing. Ms. Thompson, right. I didn't want a hearsay instruction. I wanted a limiting instruction, your honor, saying that they can't use it for the truth of the matter. That's what they heard people say needs to come in, only to put things into context. I agree with Thompson. The court says, all right, state, got any problem with me further instructing them? General Nichols says, no, sir. The court says, I will say I instructed them yesterday, gave them the definition that if something is offered by a third party, that they will not consider that for the truth of it, okay? General Nichols, well, I guess if that was going to be the instruction, I probably would want to weigh in, because sometimes things are offered by third parties that we actually are offering for the truth. The court, well, General Nichols, you know, under the court, they didn't object for some things. General Nichols, right. The court, but I am going, so the court here, like, maybe Jennifer Thompson does actually understand hearsay objections and was sharp enough on day 1 of the trial, wasn't frazzled yet, that she was doing things correctly. But you ridiculed her on day 1 in these sidebars by saying 7 out of 10 attorneys don't know hearsay, and trying to correct her when she was correct. Anyway, the court says, but I'm going to say that if something I instructed them came from a third party that was not offered for the truth of the statement, that they shall not consider it. General Nichols, will you finish it off or give them the end of it that there are going to be times when it is offered for the truth? Because otherwise, you know, all the hearsay exceptions go out go out the window. The court, I can't deal with exceptions now. I will instruct them at the appropriate time. General Nichols, okay, thank you. The court, if something falls under a hearsay exception, I will tell them they can consider it, okay? General Nichols, uh-huh. So we're going to go out of our way to say you can consider this truthful thing. This witness is really telling you what's really happening. You can consider that for the truth. That's like almost like putting a rubber stamp on the veracity of the testimony. If he's going to jump in and do that when it's necessary to say you can consider it for the truth. General Nichols, uh-huh. The court, all right, bring our jury in. When I gave them the definition, actually, I would have thought that they would have inferred that, but I'll make it clear. Bring the jury in, please. And then Thompson didn't fight this, so... So the jury comes in. Let's read what he, let's read what he says to the jury. He says, be seated, please. Let me first start out by thanking you for your sacrifice. I don't know about you, but I rest better in my own bed and my surroundings, so I appreciate the sacrifice that each of you are making in order to discharge your civic responsibilities. So I want to start out by saying that. Second thing, I instructed you yesterday concerning hearsay. That's the third party makes a statement out of court, and I instructed you that if it's not offered for the truth of that statement, sometimes it can come in because that's outside the classic definition of hearsay. In other words, to suggest why somebody did something. That statement to them is not offered for the truth of it. I did not tell you, but I'm telling you this morning, you cannot consider that as evidence. If it's not offered for the truth of it, you cannot consider it for evidence. You just cannot consider it for any evidentiary value, okay? Because that's offered to explain why somebody did something, and then we might further get into things in this trial, and if necessary, I'll go into more detail. These things are basically people get in law school. But in addition to things not meeting the definition of hearsay, there are certain legal exceptions to hearsay. And if they come in, I will further instruct you as to whether you can consider that or not. Do each of you understand that? And then the jury in unison says, yes, sir. And everyone says everyone's good. So that was a mess. That was a mess. Max says, I guess the judge is one of the 7 out of 10 lawyers. Yeah, Stimson says she was ridiculed and beat down by the judge and the crypt keeper Nichols. And I mean, I think they berated her, and like he did miss the critical part of the instruction. What they can and can't consider. They just got like a law school 101. Yeah, FFS says, I do have a question about something you said earlier. They argued in front of the jury. Yeah, oftentimes, so if you guys remember watching some of this, like these arguments would start and it would be tense, and it would always seem like the prosecution and the judge were both laser-eyed over at the defense table. So even though the jury doesn't get to hear the rest of the argument, I wouldn't be surprised if the majority of those times when they're ushered out, they have the impression that the defense attorney's doing something wrong. Meanwhile, the example we just looked at, Jennifer Thompson wasn't wrong at all. Even the slightest bit. And honestly, I know she gets wordy, she gets long-winded with her explanations, but I thought she was very clear in her explanation at that sidebar we just read, explaining like, hey, I really wanted a curative instruction, not just a definition of hearsay. So, and hey, Lynn, we are looking at sidebar transcripts from 2017. We're going to try to go through, I think we'll get through all of them. And then we're going to rewatch Doug Bates' opening statements. And that's our pregame. It's going to be our pregame for the hearings tomorrow, the live hearings. So that's where we are. And let's see. These, it's going to make me skip a few parentheses. He's instructing them. They say yes. They have a technical difficulty. Another technical difficulty, and then they play a 911 call. All right, they play this 911 call finally. They mark it as an exhibit, and then they're going to have a conference at the bench. So let's see. Hagerman says, if we may approach with regard to... let's go back a little further. And let's actually... okay, let's see what witness this is. I think this is the guy that responded to the house first, like the first guy to get to the Bobo property. But let's double check. Because now that I'm reading it, I'm not sure. Mr. Weber. Mr. Weber. All right, so he's the one that did the AT&T calls for the pings. And we were on page 41. So that's what we're talking about. And they're talking about the 911 call. So Talking about which route he took, I would imagine I took that road just because it's the main thoroughfare. Miss Thompson says, okay, if I could have one moment, no further questions, Your Honor. And then the court says, further direct from the state. Hagerman says, yeah, I have a few, Judge. Miss Thompson says, oh, I'm sorry, Your Honor. I did want to put that phone call in. The court says, I wondered. Let's put the disc in. It'll be Exhibit 37. Miss Thompson, can we have his report put in also and his handwritten notes? He recognized them. General Hagerman, if we may approach with regard to that, I would like to address the court with regard to her introducing this report. I am getting the disc from Miss Thompson presently. The court says the disc will be Exhibit 37. So the above mentioned 911 call is entered as Exhibit 37. The court says you want to be heard on this? Hagerman says yes. May we approach? The court, yes. Bring that with you. Whereupon a conference was held at the bench between counsel and the court. So Hagerman says, what Your Honor has, and what Miss Thompson is attempting to introduce, is a report that was used to refresh Mr. Weber's recollection. It's plainly and clearly hearsay. Should be. The court, he used it to refresh his recollection. So let it be entered as to the next two exhibits. So this will be 38 and 39. So they enter 38 and 39. And then, all right. They say the following proceedings continued within the hearing of the jury. So the court says, I'll tell the jury those two reports that have just been filed into evidence were introduced for the purpose of him refreshing his recollection. They're hearsay and not to be considered for the truth of it, okay? Miss Thompson says, well, which one's going to be 38? The big one was. Or the multi-page was on top, I think. Okay, and 39 is practically illegible. So Hagerman says, may I continue, Your Honor? You may. All right, so let's keep going. All right, the witness is excused. Let's see. And then General Ragland, the prosecutor we didn't hear from that much, says, Your Honor, can we have a minute to see if we can get the projector working? So they're going to have the jury take a small recess. Then the court says, everyone ready to proceed? If you are, I'm going to send for the jury. Close the door just a minute. I want to say this. I feel like everyone has been very cooperative. I said there would be no placards, no t-shirts, no stickers, things like that in support of the victim's family. I instructed the sheriff if they saw any that they were to cover those. There were some yesterday, there were some today. I don't think it's the family. I think it's well-wishers from outside. One car was Chester County, one was Madison County, so just be aware. Please cover anything. Please cover anything that would indicate support for anyone. So are they like looking at the plates, like running license plate numbers to find out where the cars are from? If you don't, the sheriff will cover it. I don't think it will be an issue because this jury is very closely guarded. They're on a bus where they can't see out and they come directly in the courtroom. But please, if you would, be cautious about that. You folks can be seated until the jury comes in. So the jury comes in. And then Mr. Scholl had a birthday, so they wish Mr. Scholl a birthday. So Mr. Scholl's in the court for this. Remember, this is Jason Autry's attorney. They say they're not going to sing and then call your next witness. So they call Special Agent Lauren James. All right. Lawrence James, apparently. Not Lauren James. Exhibits are entered. Exhibits 52 and 53 are entered. '54, '55. They pause because there's a conference between the assistant district attorneys, and then they say that they have no redirect. Next witness comes in. This is Warren Rainey. So this is the guy who tries to dig what he thinks is a shallow grave on Zach's property, tells the cadaver dog team they gotta go, but leaves the guys in the bushes with the binoculars, the citizen volunteers. Good old Warren Rainey. Let's jump down. Let's use the page scroll. Okay, so he's nodding his head a lot, so that's going to give us a bunch of parentheses. All right, so at 12:19 p.m. there was a recess. So afterwards, the following proceedings were had. The court asked the prosecutors, are y'all ready to go? Yes, sir. Everybody ready? Mr. Simmons for the defense says yes, sir. And then they send for the jury, and then they resume. This is where he asks, do we have any Hardin County Tiger football fans? And some hands in the jury are raised. Wow, we might see if we can get you folks out there in the presence of guard. You understand, you'll be isolated, but probably could put you on the visitor side. We play south side. If you want to go, there should be adequate place in the visitor side where we can put you without danger of exposure. Oh, so making sure, and then also making sure, hey, we're going to see if we can get you CBS so you can watch the game from the hotel that you're staying at while you're sequestered. All right. Witness is sworn. This is Stephen Brian Young. I think this is the neighbor that heard the screaming, maybe. No, is this the guy? I think that was the guy with the binoculars in the bushes. Oh, maybe we should make an emoji for him. All right. Chris Hill comes up. All right. Hill is dismissed. The next witnesses are the Clennys, not Courtney Clenny. Christy, and I forget the guy's name. Oh. All right. So they're asking to approach. So let's get the backing context here. So the question, were there any pictures that caught your attention? How about that? So remember, her husband was like law enforcement and started showing his wife, Christy. They're like divorced now while this trial is happening. But back then she had been walking. She saw like a suspicious guy in a truck who stopped and said something to her. And she has no idea when exactly this took place. But in 2017, she says she thinks it was like a few weeks before Holly was abducted. So it would have been like March-ish of 2011. And her husband was law enforcement and showing her mugshots after they were already looking at certain individuals. And they're asking her about being shown these pictures. So they say, were there any pictures that caught your attention? How about that? Yes, I pointed to one that I thought looked like the guy that was in the truck. And in fact, did you look through a series of pictures even after you thought that was the guy? Yes. And describe how you kept on coming back to that one picture. Well, I was looking through and I'm like, yeah, he looks like this. And then I continued to look and there were other ones that had that kind of look with the same color hair. And I was going, yeah, these have that look too. But then I said, going back to the front, that one was the one I thought looked mostly like him. Who was that person? Well, and I wouldn't have known it, but my husband was there with me and he said, Miss Thompson, Your Honor, I'm going to object. The court, she can't say what her husband said. The witness, okay, Miss Thompson, at this point, may we approach, Your Honor? So whereupon this bench conference was held. Miss Thompson, Your Honor, I've looked through the reports that I have an issue. Is she going to do a photo ID? General Hageman, no, there is no photo ID. Miss Thompson, okay. General Hageman, there's no written documentation or anything. Miss Thompson, okay, I haven't gotten anything. General Hageman, there is no proof. Thompson, okay. The court, all right. That was the end of the conference. So there are so many issues with this because this is not a proper photo ID lineup. Like, they also weren't. So the husband testifies as well, in my opinion, just to bolster Christie's testimony. But he wasn't disclosed. Like, the state didn't tell the defense that they were calling him. So they continue. Hagerman's doing the questioning. Did you say your husband recognized the guy you picked out? Yes. He was there with you, standing next to you? Yes. What was his name? My husband's name? Uh-huh. Timothy Clenny. Timothy Clenny? Uh-huh. That's it, Judge. And then they go into cross. All right, so then they end. This is the end of volume 5. So let's go on to volume 6. There are 17 volumes, by the way, you guys. And when we get to jury instructions, like the conference, we're going to read that in full. Open in new tab. Okay, so volume 6. All right, so still on the 12th. So this is the second day of trial still. Well, I guess they're calling it day 3, but we didn't get to see voir dire. That's how Paul talks. That's how Paul Hagerman talks. Very slowly and monotone. Charlie says, did they ever ask Holly's dad what color or kind of truck he was in when he rushed home? Just wondering since you have the transcript. When did they have him up? Did we pass him yet? Let's see. Oh, okay. So I was wrong. I thought Karen Bobo was like the first witness, but it was Dana, and then the boyfriend went. And then it was Karen. So that would have been the first volume. So Karen was not the first witness. I just pretty much forgot about Dana's testimony. Aside from him, there was this discrepancy over who actually put up the tape around the scene. Because Dana Bobo says he had pink tape and tried to close off the area. And the deputies were like, no, we think we closed it off. We think the scene was fine. If I go back to volume 3, and here's volume 3, by the way. All right, and they're saying he's on page 362. All right, so if I look for in volume 3 about, and this might not be, let's see. Are you the only person that was parking in the front at that time, parking your truck? And then they start talking about the tree service. And those are that's the only mention of the word truck. I think. I could try color. Color might get a lot of results. So I don't think they asked about the color of the truck. So. And then, sorry, we were on volume. Let's see. I think volume 6, right? Okay. Yep. All right, here we go. All right, so let's try Timothy Clenny. So this is the husband. Your Honor, I meant I'd like to approach again. So here's a sidebar. Ms. Thompson says, first of all, I object. They're putting in some type of photo lineup because my guess here is that he's going to come in and say she looked at photographs of different people at the police station and that he recognized his photograph as being one of Zach Adams. We don't have any kind of photo lineup. We don't know how suggestive this is. That's why a photo lineup these days are held under very strict regulations. The court, this wasn't a photographic lineup. General Hagerman, it wasn't a photo lineup. It was flipping through pictures is the way she described it at the police office. Miss Thompson, so I object. It's a photo array of things she's going to come back and say that he didn't find this person from a photograph. And photo arrays can be very suggestive and prejudicial, Your Honor. I object to them getting in through the back door. Had they presented as a photo lineup at the police, we could have filed a suppression motion on it before. The court, your objection's overruled. So then the witness is sworn in and takes a seat. So. All right, so sidebar here, talking about the picture. Was there a picture she kept on coming back to? So they're talking about Timothy. Timothy's on the stand. Yes. And who was that person? It was Zach Adams. That's it, Judge, and they say cross. And then Thompson says, Your Honor, First, I ask for Jenks material. I didn't even know this person was going to be a witness. The court, do you have anything on him? And this is still, the jury's still here. Hagerman, we do not, Judge. Miss Thompson, well, I'm going to ask if they have notes. Surely they've interviewed him. And then Hagerman, we can approach Judge if you would like. So they have this sidebar. Hagerman says, I've got nothing. I've spoken to this man one time on the phone for maybe 10 minutes, and I talked to him this morning for maybe 45 seconds. That's the extent of it. The court says, all right, you've gotten everything. And then they bring the jury back in. And then Jennifer Thompson says, Your Honor, can I just have 2 minutes to sit here and try to look through some materials in front of the jury? She's saying that. Okay, Your Honor, we have the rule. I am not sure if Miss Clenny has already left or is she in the courtroom. And then the court says, I told her she could be excused. Miss Thompson, okay, I just wanted to make sure she wasn't sitting in the courtroom. The court, she wouldn't have been allowed in, I don't think, because they're still at the door and we are observing, not coming in except during. And then they start the cross of Timothy. So we've got, let's see, there's a ton of results. Let's see how many of these are actually sidebars. They take a break. Okay, and it looks like that she doesn't, okay, short break, it looks like a little bit maybe outside the presence of the jury. It doesn't clearly indicate, it just says short break. But Mr. Simmons, counsel for Zachary Adams, says, Your Honor, Jim Simmons, on behalf of Zachary Adams, at this time, I would like to make a motion to strike the testimony of Tim Clenny in that he was not disclosed prior to trial as being a witness, and we were unable to properly prepare for his cross-examination, and also he had testified to what we would characterize as 404B evidence, because he's using a mugshot, right? The implication of which being you have a reason that someone had to take a mugshot of you. So the court says, as what? Mr. Simmons, 404B, and we were unable to characterize that. The court, all right, motion overruled. All right, let's bring the jury in. So he doesn't even like probe what he's talking about. He's just like, the what? Nope, overruled. And then Mr. Simmons says, Your Honor, real quick, Your Honor. The court says, yeah. Mr. Simmons says, I would like to confirm with the state that the witness was not disclosed. The court, he said he first talked with him yesterday afternoon very briefly, and then maybe again this morning. So they've disclosed everything they could disclose, basically. Mr. Simmons, again, Your Honor, for the record, I move for a mistrial. The court, all right, overruled. I'm going to go into a very brief description of Jenks material. And he spells it this way. We saw this. He said Jinx, and it's Jenks. So then the court defines Jenks material and spells it wrong again, Jenks. I guess the jury had sent in some questions on note paper, and they were all related to like, hey, can you define this legal issue we heard you guys talking about? Which, I don't know. Again, I always think of instructions I'm used to hearing where, hey, you're not supposed to concern yourself. If you hear them say objections, you're not to concern yourself with what that means or how I got to my ruling. But okay, we're defining all of that for the jurors. DB says, okay, finally, Simmons does something. Very procedurally moves for a mistrial and sits right back down. All right, so exhibits are being entered. Rebecca Earp is taking the stand. I'm sure we're going to have sidebars here. We're also going to have a lot of head nodding. Marking exhibits. Cell phone interruption. I think this is the football because the football happened with Rebecca Earp, right? The first time? It just says cell phone interruption. Pretty sure that was when the football announcer voice went off. Hilarious. And the court says, just trying to shut it down. All right, so let's see. Ms. Thompson says, I'm going to object to any kind of 404B, Your Honor. Because they're about to talk about the day they finally broke up. Hagerman says, Your Honor, I think the door is wide open. Ms. Thompson, I did not open that door, Your Honor. That was not the intent with that question. If we can approach the court, let's take a recess, take about 15, and then we'll continue. So the court, outside the presence of the jury. All right, let's take up the issue. Jury's out, so you can just address it from there. Ms. Thompson, Your Honor. The court, let's have some order. If you want to pass out, that's fine. Do so quietly. What? Was someone falling asleep? Or snoring or something? What does that mean? Ms. Thompson, what happened was Miss Earp said something to the effect of, well, you have to understand at that time, something like, you have to understand that time why I didn't come forward with that information. I was something about like, I was under the influence of him or I was something. And she said, I was afraid. And then I said, what do you mean? She said, well, I was afraid of him. And I said, why were you afraid of him? And then she said, well, I just was. I recognize at that time, and I don't know if we should be having this with the witness in here. So they tell Rebecca Earp, you can step out. Ms. Thompson, I didn't realize she was in here. I recognize at that time where her answer might be headed, and I dropped the subject. But the way that she first said something like, well, you have to recognize I was under the influence of something, I didn't recognize that her answer was going to be anything about domestic violence. So probably thought she was going to say drugs. The court, I don't want to get into specific issues. She has already testified she was afraid of him. I think that's enough. General Hageman, but I think there is the issue, Your Honor. During the course of this domestic incident we're talking about, where he beat her, is when he taunts her. I'll do you like I did Holly Bobo. The world will never find you. And this witness has been impeached about why is she afraid of him, so that she didn't come forward to law enforcement. The court, I don't want to get into the domestic violence, being that she has already testified that he made the statement. I'll do you like Holly Bobo. They'll never find you. General Hageman, but the circumstances where she made it become important when she's impeached about it, do you really remember this thing? The court, I think we've gone as far as we need to go, so you need to divert and go to a different direction, okay? Are you going to be with the witness a while long? Hagerman, yeah, I'd say at least 20 minutes. Probably just because of how slowly he speaks. The court says, okay, well, that's why I took a break. Okay, I'm telling you, should he testify, he can open this door. They have a short break, and then a bunch of stuff is entered as a collective exhibit, including stuff that's 404B content. And then they're going to tell them what the rule of evidence, and that we don't need to go into it. It's strictly legal grounds. All right. Let's see when they come back in. All right, so the jury comes back in and says, someone wanted to know what 404B content is. So again, this is what I'm saying. There's like these law school definitions where the jury wants to understand the legal ruling, why the judge is making, and coming to the conclusion to overrule or sustain an objection. Ike says, is there any discussion about motive anywhere in this trial? It's probably the one thing that I'm really missing. Not really. I think it's just inferred that druggie does bad thing. That's the conclusion. That's the pathway the state wants the jury to take. So, Zach Adams does drugs, bad person, did this thing. So, we've got, and did he really say that? I'm going to say yes. I'm not sure what you're asking about, though. But yeah. Yeah, the court is definitely seeming like the third chair. More than, was it Ragland, the third prosecutor? Ragland's just like a little blip in the transcripts. All right, so they have they define 404B. They say, I will tell you that's actually a rule of evidence, but it's something that concerns itself to the court from a legal standpoint. So they're not going to tell the jury, they're not going to fully explain it. So thank you, Judge, finally. It does not concern the jury. It's a determination that I must make concerning admissibility of certain evidence, okay? Then number 2, someone wanted to know what game I was playing. I don't know who did that. I hit one of those doggone videos and I did it twice. And it sounded like it was on loudspeakers up here. But I think we've got that remedied. I will tell you periodically, I will check things on this. I've got Westlaw here where I can do legal research. I have actually looked at these proceedings that are being televised to make sure that the press is in conformity with what they're allowed to show and not show. So that's some of what I've been doing up here. And I just hit the wrong button. I might have told you my tech support is my wife and daughter. I can barely get around on this thing, so I make mistakes. But we got it silenced now. Okay, all right, we're ready to proceed. Yeah, just some of the things you're doing on the phone. All right, so they enter an exhibit, jury leaves the courtroom, and then that concludes the day. So that was the end of volume 6. Going to volume 7. This is Zach's ex-girlfriend saying that Zach Adams said this to her in a closet during a fight. Yeah, and we remember Valerie Trout, TBI agent Valerie Trout she did not testify during this trial, but we learned through the post-conviction proceedings that while Rebecca Earp was pregnant with a different man, but she was apparently pregnant in the clip of the video that we were able to see, Valerie Trout is apparently threatening to have child services come take her kids because she's using drugs and engaging in things that you shouldn't be doing while you're pregnant. So, and she changed her story multiple times in her different statements. And none of these statements were part of the initial statements. So, and years had passed. So, and okay, wait, I think I have wrong volume. Volume 7. Open that up. Let me close some tabs. All right, so now we are on September 13th. So day 4 of the trial, if you count voir dire, I would have called this day 3, because to me, day 4 is Autry Day. So tomorrow's going to be Autry Day. And hold on, I didn't update you. I'll have to tell you guys my, Can we actually call a quick audible and watch Doug's opening statements? Because my landlord's got to come fix my washer. So I think I need to call him for a quick 5 minutes. So I think we'll do that. We'll call an audible. We'll watch Doug Bates' opening statements for the post-conviction relief hearings and Amy Wyrick's. It's 30 minutes, so I'll be back before it's over. But I've got to get this washer issue fixed. I found like 12 socks inside the washing machine, but none of them were clogging the drain pipe. But there were like a million things just lost inside the machine. So unfortunately, I was hoping I would just find a sock in the drain pipe and that would fix my problem, but it didn't. So let me jump on. Let me make sure the volume is good. And remember, this is going to be May of this year when this was happening. I think May 20th. Boost up the volume. Update my banner quick. Opening statements. Did I not miss 12 socks? Okay, some of them were kid socks, so they were from the renters before me. A few of mine were in there as well. But not for nothing. If I'm missing a sock, I just leave it in. I have like a little pile of socks that I wait to match. And I only take from a pile where I have matched socks. So I don't really pay much attention to it. But yeah, I opened that up and I was like, oh my gosh, that's a lot. That is a lot. The washing machine, not the dryer, eats the socks. So here we go. This volume, let's see if it's good. And I'll be back in like 5 minutes. Maybe sooner. Hopefully
the way
sooner.
The evidence fits together has taken me 18 months to understand. This will be helpful to show this is a legal nightmare. Innocent men and Mr. Adams was found guilty in this court. This is the nightmare our system tries to prevent. Lawyers failed Mr. Adams. His defense, the prosecution, and at times the court, all of which the Constitution protects and preserves this final failsafe to correct. We often think in criminal worlds that the Constitution allows guilty people to get out. We often don't think in terms of the Constitution protects the innocent from being wrongfully convicted. The court has said before, and it is very true, a lot of these facts are interwoven in multiple issues. I will say some things are standalone issues, which are constitutional rights that were violated that are now known, that were not waived. Additionally, there were constitutional rights regarding ineffective assistance of counsel. My suggestion is how I've interpreted this is wait until you find all of your facts before sorting out how the law applies to them. I want to show very briefly how all of this is going to fit together. And you're going to hear me say the video multiple times. And I'm going to get right to it to show you why it's so important. This is just a rough sketch that largely tracks exhibits that Mr. Reeves provided. I believe it's exhibit 140, where he maps out various cell phone maps, cell phone towers. 39077 is the northeast tower on the Birdsong Tower, northeast 7. That is incredibly important. There's Zach Adams' home tower, 31522, 31523 is Shane Austin's. 12572 is Parsons South Tower. I have on this, just for your understanding, in purple is the route that Marshal John Walker predicted, but due to ineffective assistance of counsel, he was not qualified as an expert at properly tracking. Mr. Adams' attorney, the night before Agent Walker's testimony, was drinking wine and flippantly preparing for Marshal Walker's important testimony that he laid out. This is in purple. Here's the important part. Marshal Walker says the victim did not move, her cell phone was not moving between 8:26 and 8:56. He predicted that's where her remains are going to be found, because that's where she was killed. He was right. Next to her, the victim's remains, is a .380. Remember that, I'll come back to it. A .380 shell casing. The cell phone then continued along a route that ended at 925, where the SIM card was thrown out along with everything else of the victim at 925 at Gooch Creek. There are two directions of travel from this route that goes in a clockwise direction leading to Terry Britt's home. Now, most of this information defense counsel knew. What defense counsel did not know is that there was a video of the Silverado in question at 11:12 a.m. And Zach Adams is prepared to say he was there. Multiple efforts, and I went into it yesterday. I'll just say this. The defense attorneys subpoenaed the bank for this video. The bank said, we've looked through our videos, we don't have it. There's multiple internal documents the state has now where the defense is told, you gotta get these videos. This is really important. The problem is Ms. Thompson was told it was a BP video. And Agent Walker said it wasn't covered by the transaction of Shane Austin was not covered by our videos. It's fair to assume nobody realized what they had. And you're going to say, well, why is it important? Because Zach Adams' cell phone was on the northeast tower at 39077 from 9:50 at 10:32 a.m. You're going to hear proof there was nothing uncommon about Zach and Jason Autry doing drugs under the bridge. We have, after realizing the BP video was the ATM video in March, we have spent enormous resources figuring out where along Autry's route the most favorable location on tower 39077 Autry and Adams could have been. What's the closest to where they have to go could they have been? We have a gentleman, Paul Dillon, who ran this route, according to Autry's testimony, as fast as he possibly can to go without real consideration for what had to take place that day, which is drop Autry off in the PT Cruiser, then pick up Austin, pick up his brother Dylan, change trucks, and get to the ATM at 11:12 a.m. It is impossible. Now let that sink in, Your Honor. This timeline is impossible. The route is not mere logistics. The route, and you say, well, wait a minute. I know from Exhibit 240, I know
all of his papers,
that Zach was at the northwest tower at 10:35, tower 39079, and 10:36 a.m. and 10:37 a.m. And then at 10:38 and 10:43, he's at tower 31522. Exactly right. In 11 minutes, he went from I-40, Birdsong Northeast, to his home
And on the interstate, it's 10 minutes away. So if you're traveling on the interstate, Your Honor, you do not have a body in the back of your truck. And if you do not have a body in the back of your truck, no crime has been committed. You're going to ask, okay, what else do you have? Is there anything else corroborated by this? Same cell phone records. Shane Austin, Tower 12572. South Tower in Parsons. He's there pinging from 11:15 to 11:52. Zach Adams, 11:16 to 12:10. This alone shows probable impossibility. But the cell coverage, and you're going to learn, it's not necessarily like a border where you feel that you're in a different cell phone the second you're in a different cell phone tower. It's not as precise. What is precise is what was mislabeled a BP video, which is the ATM video, which has them here. You have bank records where Shane was at the bank that was provided in discovery, that Agent Walker, again, of the 600 witnesses the state identified, Joe Walker was not one of them, the lead case agent. I assume because he has the records, and either he didn't know what he was looking at, or he was told to lie when he said that transaction is not covered by the ATM. There are multiple ways to show Jason Autry's testimony was a lie. Here's one, and this is just delicious. Part of this, anyone who grew up in the country knows a .32 revolver does not make the sound boom, boom, boom that Jason Autry said it made. Anyone ever been around a firearm knows that was a lie. So we employed somebody, hey, take a .32 revolver out, go under the bridge and shoot and see if it makes that sound. And it sounds like a cap gun being played in the backyard. Provide it to the state. On May 6th, the state sent their agents out to perform the same testing. And kudos to them. They brought something to read the sound. The cars were louder. That was provided yesterday at lunch, after the motion in limine on Mr. Autry's video. So that's the first point, how Jason Autry's testimony was a lie, that the state had the ability for 7 years to independently investigate, to say, wait a minute, this doesn't sound right. They waited until May 6th to do it. And kudos to General Boiano for disclosing that.
The
But the
Christian
fact that
Atkins
they
of this
tested
trial.
that, and they've never tested this route, shows me either they haven't tested it because they're putting all of their chickens in the basket of, well, maybe Zach's not at the ATM. Or two, they've run it as fast and as many times as they can, and it's impossible to beat what Paul Dillon beat. And you're going to watch Paul Dillon's route.
I wish we got to see that.
You have in this wrapped in all one. Prosecutorial misconduct for realizing, hey, even if they have Zach at 1116 in Parsons, you can't get from here to there, back, and then drive around Parsons. You have mislabeling the ATM, and here is, and Judge McGinley has been a family friend of my father's for decades. But when Jennifer Thompson requested a motion to continue, she said, she listed this, I believe, V8, which had been considered a BP video, among her motions to continue. Judge McGinley asked her, when do you want a trial date? She said, 1 year from the date Autry's testimony. Judge McGinley said, I believe the date you would select would be when pigs fly. You don't want a trial date. Now compare that to Judge McGinley saying at Mr. Autry's plea deal, your testimony was some of the most persuasive, credible testimony this court's ever heard. Judge McGinley believed Jason Autry, a man the state says is too dangerous to transport,
Innocent man walking.
over a fellow lawyer whose job was to defend Zach. You're going to hear how the state dealt with the other evidence. You're going to hear things about the TBI that's going to, you'll never forget it. You're going to hear the TBI in a letter saying that to the TBI, accuracy is not the issue. Consistency is. I didn't believe it when I read it. It'll make sense, though, when you hear the other evidence in this case. Autry's fabrication has this white truck being used and put in Victor Dinsmore's garage. And you're going to hear of Agent Brent Booth, who went to Indiana and said, I want to go over with you what Jason's going to testify and see if that helps your memory. That's 6 years after. 2011, Dinsmore's in Indiana in 2017. Booth says, Jason says this white truck was in your garage. Dinsmore and his wife on recording say, didn't happen. This is another point along the way where the state had the ability to say, okay, time out. Autry, you're lying. Accuracy is not the issue. Consistency is. So they continue on with Dinsmore. And finally, Agent Booth, and you'll hear it from him. He says, it helped me. It helped this case if we can nail all these little details down. Dinsmore asks, well, what's the chance of Zach getting out? Booth says, you never know what a jury will do. Dinsmore, on a recording that Adam's attorney never played to the jury, where
Those
she even had it
recordings are crazy.
transcribed. Dinsmore says, let's go with it. Let's put the truck in the garage. You will hear fabrication of evidence of the worst kind. So bad, Agent Booth went back to him the next day and said, hey, I just want to make sure I wasn't putting words in your mouth. Final point, now sit down. The gun. In discovery, Dick Adams had a .357 confiscated from him. that Jason Autry knew because he had had the discovery. Also, Shane Austin had a 357. One of those, or both of those reasons, is why Jason Autry told Agent Ferguson in IR 3152 that the gun employed that day was a 357. When Booth goes to Dinsmore, he says, I just want to make sure, let's talk about the gun. Dinsmore says it was a .38 revolver with an interchangeable .357 barrel. And he's 100% true. What he tells Booth, 100%. And he says, I know my guns. 6 days later, oh, one other thing. Dinsmore said, because he's a felon, years ago, my wife threw away a .32 revolver. Six days after this, they find the .32 revolver. And somehow the coordination takes place before trial, where everybody says it's a .32 revolver. Their lie had been caught. The only thing they pulled out of the ditch was Dinsmore's .32 revolver. The victim, the defect in her skull was .36 in diameter. Then Prosecutor Nichols said to the jury in closing arguments that .38 is excluded. Next to the victim's remains is a .380 pistol casing. Would you like to know what the diameter of a .380 is? .355. The gig is up on this conviction.
The gig is up.
I take zero pleasure in presenting this evidence. My obligation is not necessarily to Mr. Adams, it's to the court who appointed me and the Constitution that requires it. These things are devastating to learn can happen in the system. My family has spent practicing in since 1871. And I am sorry to have to learn this and present it. Thank you.
Thank you, Mr. Bates. Ms. Warwick?
Thank you, Your Honor.
Now, this is the state's response. So remember, tomorrow's hearing is going to start the state's case. They get to, it's their portion of the evidentiary hearings for this post-conviction relief petition proceeding. So they're going to be calling their witnesses. They have 6 on their list. One of them is supposed to be a guy who no one's ever heard from before, who's not in any of the investigative reports, who's going to come up there and say that on April 13th, 2011, he was on a boat and heard the gunshot that Jason Autry testified about. And then I don't know who the rest of their witnesses are going to be. And Doug Bates or Crystal Itu will have the opportunity to cross-examine any of the witnesses that they call. And then when they close their presentation of the evidence, we'll get into closing arguments. So just watching this set of openings after everything that we've done a deep dive into, I think is great grounding, good grounding.
This smoking gun
Which one?
that
Which
Mr.
smoking
Bates
gun?
purports to bring to the court this week, the smoking gun of this route
Subterfuge.
puzzle, the smoking gun of the time zones and the time frames and the where were they and what was going on. The smoking gun of Zach Adams and Shane Austin being in Parsons around 11:12, 11:15 until noon. Guess what? It was shot at a jury, and they didn't flinch. Everything that Mr. Bates has shared with the court this morning was shot at the jury,
No, it wasn't.
and they didn't flinch. I think everyone in this courtroom, every state agency that has been involved in this case since 2011, that horrible, horrible morning, April 13th, that the Bobo family and this community and West Tennessee will never forget. Everybody that was out there will tell you mistakes were made. This was bigger than anything we had ever seen before. And the irony of it is how truly simple it really is. When you break away from all of the noise and all of the attempts of subterfuge and smoke and mirrors, because that's what this is based upon. Zach Adams stands before this court today presumed guilty. Guilty of murder in the first degree, guilty of kidnapping, and guilty of rape. And what this court is called upon to answer are two things. Were his lawyers deficient? His 3 lawyers, who among them had 100 years of experience, some of the best and brightest lawyers in the state of Tennessee, were they deficient? And if they were, and the state submits that there is no way that prong will be satisfied. If they were, for the sake of this interesting conversation that Mr. Bates wants to have, instead of a legal factual argument based on the laws and the rules, if they were deficient, what difference does it make? Would any of this new, what the defense wants to call new, evidence make a difference? State submits to Your Honor that you are not going to hear anything in the next days, weeks, months, however long it takes. You will not hear anything that jury didn't hear. That those men and women of this community.
We heard the Dylan Adams interrogation. We heard some of the Victor Dinsmore recordings, not just with Dennis Benjamin, but also with TBI agent Brent Booth, where Brent Booth was telling Victor Dinsmore, here's what's going to be testified to. Jason Autry is going to say, Jason's going to testify to. Jury didn't get to hear any of that. This is all just a put on.
Community.
Hey, KP.
Took into account in doing their job. How easy it is for jurors when we bring them in on the first day of jury term and they start figuring out how easy it is to get out of jury duty. Oh, wait, I just have to say that and then I get excused. These men and women stood up as members of this community, raised their right hand, and promised to listen to everything. Not just a little bit, not just what Mr. Bates wants the court to hear and think about, but everything. So the state would challenge Your Honor to ask, would it have made a difference? Is it new evidence or is it something the jury heard? And if it isn't something the jury heard, the state submits that the court will not be able to find any credibility with it, that it will be unreliable and unbelievable testimony. His lawyers were some of the most prepared, if not the most prepared lawyers that anyone has battled and I submit anyone will battle in modern time. Jennifer Thompson alone, in just a 2-year period from September of 2015 to September of 2017, worked 2,600 hours alone on this case. She billed the state over $200,000 for her time and effort, and the biggest chunk of her effort was reviewing discovery, reviewing the evidence. They had a team of 16 people who rolled into Savannah for this trial. 16 people.
And it's so when we were watching this, at least I wasn't aware. I had no clue that we were going to find out that Jennifer Thompson kept saying, hey, where is this video? Where is this video? Where is this video? There's supposed to be this ATM video where it shows my client driving backwards through the ATM because Shane Austin was the passenger and on the other side of the car, and his window would have been at the little like window machine thing, so he could do his own transaction. So they drove through it backwards. I had no idea how much we were going to hear about that hot mess. And we got to look at some of the documents over the last few days. And just yesterday, we looked at a filing that laid out the timeline really, really well. And where was it? Critically. Early on, it's memorialized in a TBI report. Let's see. So early on, September 20th, 2013, TBI logged this video that was once labeled BP/Community South Bank ATM April 2011 as part of Investigative Report 1845. Later, it's renamed to just BP, which is a totally different building, right? Nothing to do with this ATM transaction. This is all removed from the file name. So if you're trying to scan it or search for it, and you have to go 9 different steps to find where this folder would even be in this discovery folder. Can't find it. So Jennifer Thompson, during this time period, is asking. And they're trying to get information. And then in an IR 2000 something, Joe Walker responds, hey, we don't have anything like that. And at that point in time, the video is just labeled BP. So then Jennifer Thompson tries to go to CB&S Bank, and the bank responds, hey, we don't have that ATM video. So Jennifer Thompson was actively trying to get access to this footage. Pretty sure she was aware that Terry Dykes had seen this footage. And Terry Dykes was the TBI agent that felt these 4 guys were alibied because of this information and the cell phone records, and TBI gave him the boot because of it. They said he was standing in the way. Him and U.S. Marshal John Walker were standing in the way. No longer want to work with them as part of this investigation. And to me, that's just crazy. Jennifer Thompson even asked for a continuance of the trial in 2017 because she still couldn't. One of the things cited was that she still couldn't access this V8 file. She had to download some type of software to open it, and it wasn't working on her devices. She couldn't get into it. Well, lo and behold, we're aware, we know, we learned from these post-conviction hearings because of TBI agent Joe Walker, not U.S. Marshal John Walker. He was directed in November of 2016 by Jennifer Nichols, the trial prosecutor, to send 2 discs of discovery just to co-defendant Jason Autry. On the reason being that other defense counsel, according to Jennifer Nichols, had informed her that they couldn't access certain files. So Nichols was aware that defense was not able to access certain things, but they only sent one of the co-defendants, the co-defendant that would end up proffering and being their star witness at trial, got his story straight with Victor Dinsmore, so it looked like Victor Dinsmore corroborated the star witness's testimony. We give him accessible files. And yet here Amy Wyrick is putting on this whole showboat with her opening statement here. It's completely disingenuous. And I think we might have to do a side story and look at the case of Nora Nora Jackson. If you guys remember the Nora Jackson case, if you're wondering, how did she get convicted? Why was the conviction overturned? Well, Amy Weirich didn't turn over exculpatory evidence in that case. So we might have to look at some Amy Weirich history before we get back to the sidebars.
Every request they made to Judge McGinley for extra resources was granted. They had a private investigative firm that billed the state $115,000 for their time. Jim Simmons worked 1,700 hours. Jim Simmons, who, if you ask anybody, will tell you is the greatest capital defense attorney in the state of Tennessee, sitting over here, representing the petitioner. Was counsel deficient? Absolutely not. They were the most dogged, relentless, zealous trio of lawyers that anyone has seen representing a defendant. But what they can't do is magic. What they can't do is keep the state from putting on the incriminating evidence that continued to pile and continued to pile and continued to pile against their client. The court also has to look to whether they had a plan. So what if you put in 2,700 hours if you're just flying without a goal? So what if you're just putting in the time and there's no quality to it, no intentionality behind it? They had the greatest defense possible, and it was delivered to them on a silver platter by the case agent in the beginning phases of this case, Terry Dicus, by the FBI agent who worked the case in the beginning phases of this case, Art Viveros, and from what Mr. Bates refers to as Marshall Walker, who worked for the Marshal Service and also was the one that went into the jail to interview Terry Britt and get a confession out of him, this seasoned law enforcement officer, and forgot to Mirandize him. That's kind of criminal investigation 101. The state would submit that when the court hears the timeline, the true timeline of the breakthrough in this case, which was 2013, 2014, Terry Dicus was off the case because he'd lost objectivity. Art Viveros was off the case because he'd lost objectivity. Marshall Walker was off the case. Those three were not on it anymore. Nothing had been done, and everything started to come together. As soon as they were out of the way, and the misguided, erroneous, destructive focus on Terry Britt took a back seat. The TBI did things in this case that they have never done before, things we only see on TV and in movies, to try to catch Terry Britt, because that's who Terry Dicus was focused on, at the expense of every other lead that was coming in. This defendant's name, Shane Austin's name, Dylan Adams' name, and Jason Autry's name were coming into the TBI in the days and the weeks that followed. But Terry Dicus wasn't having it. Terry Dicus wasn't having it. Because guess what? We got a sex offender that lives in the county. He's got to be our guy. They spent countless hours investigating him for nothing. They all got outsmarted by Holly Bobo. Most of all, this defendant. He got outsmarted by her, and he got outsmarted by his co-defendants, because they weren't all supposed to fold. They weren't all supposed to start talking. Nobody does that to Zach Adams. I run this county. I know these roads. I grew up here. Everybody's afraid of me. Nobody's gonna talk because we all raped her and we're all in on it. He got outsmarted by his drugged up foursome of co-defendants and by a tiny little blonde girl named Holly Bobo. She left scratches on him. Her test papers, she was studying for a test that morning, her test papers were found by Shane Austin's house. Her phone, her backpack, her property, her things were scattered by these meth heads in the minutes following what they had done. We may never know exactly what happened minute by minute that day, but what we do know is what came from his mouth in the weeks and the months and the years that followed. Were his lawyers deficient? Heavens no. They brought zealous representation to a new level. And even if they were, was it detrimental? Was there prejudice because of it? Absolutely not. Because what no one wants to talk about is all of the other evidence that came into this courtroom, the smoking guns that the defense shot at the jury, and they never flinched. And at the end of it all, what cannot be lost in this is they kept him from death row.
All right. Close this off. Oh, that came in loud. So, Amy Wyrick, while we are on the subject, long appeal decision here reversing the conviction of Nora Jackson on several grounds, but there's a lot here about Amy Wyrick's prosecutorial misconduct. Evidence was withheld. And I think a critical thing, I think it's like one of the first issues that the court waited on, the appeals court waited on. Let's see. I'm going to read this. I'm going to read this from the appeals court decision. And I want you to tell me if you can hear Amy Wyrick saying this. This was during Nora Jackson's trial closing arguments. So here the court's addressing alleged prosecutorial misconduct. First, the references to post-arrest silence of the defendant. The defendant argues that the state made improper references in its rebuttal argument at the close of trial. So the last thing the jury is going to hear. To her post-arrest silence, thus violating her Fifth Amendment rights and denying her a fair trial. The state responds that the trial court correctly concluded that the state had not commented upon the defendant's post-arrest silence in its issue. In final argument of the testimony of Cindy Eidson, the defendant's aunt. So we've got the opening sentence for the state's rebuttal argument drew an objection from defense counsel and their request for a mistrial. So this is the opening sentence. So for rebuttal closing, the second closing, Amy Wyrick gets up there and goes, "Just tell us where you were. That's all we're asking, Nora." Wait, can you see me? Am I not visible? What's going on with my StreamYard? All right, Lynn sees me. Oh, I was hidden by a comment. Sorry. That makes sense. So, first of all, I can totally hear Amy Wyrick saying this. And this is how she starts her rebuttal closing. Yelling to the defendant. She apparently walked over to where Nora was sitting and had her arm pointing at her while she's saying this. Commenting on her right. She doesn't have to testify. She doesn't have to speak. But yet she opens her rebuttal closing by saying, "Just tell us where you were. That's all we're asking, Nora." And there's a footnote that says the record on appeal includes a DVD of what the defendant has represented, shows the opening portion of the state's rebuttal argument at trial. However, Tennessee Supreme Court Rule 30I provides in part that film or videotape recorded by a media organization of a trial is not admissible as evidence in the proceeding out of which it arose. Any proceeding subsequent and collateral thereto, or upon any retrial or appeal of such proceeding. On August 31st, 2011, relying upon that rule, this court denied the defendant's motion to play at the oral arguments in this matter, this video recording. We have not considered the DVD in our review of this matter. So, there we go. Then we've got objection. So we have the objection from defense counsel. Court says, all right, do you want to approach? It's held on the record in the presence of the jury, but out of its hearing, and the following proceedings were had. I want a mistrial. That's absolutely inappropriate. The state. It's a quote from an aunt who testified. Defense counsel. There are enough appellate court opinions that the prosecutor ought to know that. That is an unfair comment on my client's right to remain silent, and it's a demand that she not remain silent. She can couch it in whatever terms she wants, but that was grossly inappropriate. The court. And then says, Wyrick, or Miss Wyrick, the prosecutor. One of the witnesses testified to that, Your Honor, asking her where she was. Just tell us where you were, and we'll do anything we can for you. The court. Okay, I'll give an instruction to the jury that she's commenting on testimony in the case, and I will also reaffirm, if you all wish me to the jury, that she does not have to testify today or any time during the trial in her own defense. That she's talking about the question that she was asked. And Wyrick says, by her aunt, by the lay witness. All right. And then defense counsel says we ask for a mistrial immediately. The court says, all right, you all have made your record, and what I'm going to do at some point is give the jury an instruction at this time, and I'll allow the prosecutor to proceed as long as you tie it to testimony in the trial. Prosecutor, that's what I was attempting to do. The court, and not that you're speaking to the defendant now. But she walked over. So, right, the court says they're not considering this DVD, and they're actually going to find that this was a reasonable juror could take this as a demand. So the appeals court disagrees with the trial court, saying the state was fine here. But they also don't get to see that DVD. They don't watch that DVD where Amy struts over to the defendant and points at her while she's saying it, acts it all out. And then defense counsel says, and in explaining that to the jury, Your Honor, I hope you will strongly explain to them that she doesn't have to tell anybody anything, that the burden's on the state to find out everything. And the court says, I understand. Before the state continued its rebuttal argument, the trial court instructed the jury as to the defendant's right to not testify during the trial. Ladies and gentlemen, I want to make a distinction here so you'll understand. I've given you in your jury instructions, and you will get in your copy of the instructions, but to make sure that there's no confusion, the following instruction, which I'll reread to you, which you were discussed when we picked the jury last Monday. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove her guilt beyond a reasonable doubt. She is not required to take the stand in her own behalf, and her election not to do so cannot be considered for any purpose against her, nor can any inference be drawn from such fact. Now, when the prosecutor opened her argument, she was not at all discussing or asking the defendant a question. What she is doing, and she will explain to you, is that she was quoting another witness and commenting on the proof of the case that the defendant, a witness, who testified to something about the defendant being asked where she was. It's very important for you all to understand that you cannot ever, ever hold anything against the defendant for not testifying in this trial. Also, at any time from the time of this alleged killing until today, the defendant never has to talk to anyone about anything. She has an absolute right to remain silent, and it's up to the state to prove her guilt beyond a reasonable doubt. It's not up to anyone to prove that they're innocent. Can every one of you follow that instruction? And I want to see every head. Can you, sir? The jury was polled, and each juror indicated an affirmative response. So then he says, the court says, okay. And by the way, this judge has said after this trial that, and even after the appeals, that he knows that this defendant is guilty. So this judge, in his own conclusion, was that Nora Jackson guilty. Says, okay, I'm going to allow the prosecutor to continue with this argument, but I want everyone to understand that when she says this phrase, she's not asking the defendant that question about commenting at all about her right not to testify. She's talking about proof in the case. Closing arguments, as you've realized, are different than opening statements, and that attorneys can be persuasive. They can talk about the law and how it applies to the facts. And they're allowed to draw reasonable inferences from the evidence. But the laws that we have that I have read to you and charged to you, you'll have back there. Says that you can never, ever hold it against anyone for not testifying on the stand in their trial because they have the right not to. They don't have to prove anything. During this trial, the defense didn't have to ask any questions of jurors. Other than entering a plea to the indictment, they did not have to give an opening statement. They didn't have to ask any questions of any of the witnesses or give a closing argument because they have nothing to prove. Does everybody understand that? The burden is on the state of Tennessee and never shifts. So following the court's instructions, the state's rebuttal continued with a reference to the question asked of the defendant by her aunt as to where she was at the time the victim was killed. So they're going to end up deciding that, among other issues, that they do not think that this was okay, that they still think the jury could have taken that as a demand for the defendant to testify. But then there's other issues, right? So there's cumulative errors here. There's alleged suppression of Brady Giglio Jenks material. So, like, it's long, guys. This is 82 pages, and maybe we'll do a different stream on it. But I think, let's see. Jump over to this quick timeline. So she was convicted on February 21st, 2009. In March, the jury sentenced her to 20 years and 9 months in prison. The judge here, they pulled this quote from Judge Christopher Kraft saying, "I think Nora Jackson had a very fair trial and she was obviously guilty, and I ruled she was obviously guilty," said Judge Kraft. Now jumping to 2014, August 22nd, 2014, and the Innocence Project stepped in to work on this case. In the years after Nora Jackson's conviction, her defense attorney, Corder, never stopped fighting for her. And Corder, I think Valerie Corder, maybe it says above. Yeah, Valerie Corder. So that's her here. She did the trial pro bono, and then never stopped fighting for her. On August 22nd, 2014, the Tennessee Supreme Court threw out Nora Jackson's second-degree murder conviction, saying that the prosecution violated Jackson's constitutional right to remain silent and not testify at trial. The court concluded that Wyrick broke a legal rule when she said to Nora Jackson during her closing arguments, "Just tell us where you were. That's all we're asking, Nora." The Tennessee Supreme Court said that the prosecution also withheld potentially exculpatory evidence from the defense when it failed to disclose a statement from its witness, Hammock, who they throw up on the stand, and defense at trial was like, "We weren't informed of this witness." So, just crazy. And then Hammock had written a statement to prosecutors saying he was high on the drugs the night of crime and didn't even have his phone. So, ultimately, Nora Jackson ends up taking an Alford plea instead of doing a retrial. And she's not put back into custody. So she gets out. And then after this whole fallout, because this was a major case, the press was all over Amy Wyrick. 2020 was walking around trying to interview her. They talk about that a bit here. Okay, wait, I lied. 15 months after she signed the Alford plea, she was released. So let's see. Wyrick, now the Shelby County District Attorney, was facing charges of ethical violations from the state stemming from the Jackson murder trial. When approached by 2020 about the case, Wyrick said she killed her mother and did her time for it. And there's a clip of that somewhere, but she just keeps walking. She doesn't want to talk. So just this week, these charges were dropped after Wyrick agreed to accept a private reprimand and admitted an error was made. And then New York Times had also done an article, and there's this gem where Wyrick loses her mind because New York Times is commenting on her ethics issues. So again, we are back in August 3rd of 2017, just a month before the Zachary Adams trial started, coincidentally. Let's see what she sounds like.
We had a client who
Oh,
tried
we
to
got an
handle her
ad.
case on her own. Her
Bogan
insurance
Munns and
company
Munns.
offered her nothing.
So while they say that, Wyrick is firing back at a highly critical article published by New York Times. The New York Times article focused on the Nora Jackson murder case. Jackson was 18 years old when her mother was fatally stabbed 50 times in her East Memphis home in 2005. Let's get this going while this is here.
When you read this article, especially this huge article, it's the New York Times.
Well, when I saw the headline, it was very evident that it was not about the truth. It was not about getting to what this case was about, which was a defendant who stabbed her mother to death many, 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 many times for the purpose of getting money, for the purpose of living the life that she wanted to live. So I didn't give it much thought after I saw the very erroneous headline.
And they also pick out other little things through your long career. To someone who doesn't really know anything about you or anything about the cases, you look pretty corrupt.
Sure, we all do, you know, and I think what's got to be part of the message is the truth, the facts and the truth. about not only my career, my 26 years here as a prosecutor, this office, but quite frankly, every prosecuting office across the nation. This office, since 2002, has tried over 2,500 jury trials. Every year, this office handles, meaning we touch, over 220,000 cases. Every year, this office touches over 220,000 cases. That is about 1/3 of the caseload of the entire Department of Justice. Or 3 times as much, I'm sorry. The Department
Okay.
of Justice's caseload is 1/3 of this office's caseload. We've got 106 attorneys to touch those cases. And since 1990, all right, because our office has done a lot of work in this area and a lot of research. Since 1990, 147 jury trials have been reversed because of something somebody did. Okay, that doesn't count the trials that were reversed because the law changed.
Were they
Or
reversed here?
reversed here in Shelby County.
Oh, okay.
Since 1990, 147 cases
That's a
have
lot.
been reversed because of something somebody did. All right? There were 125 of those that it was the judge's error.
Because that's what
It was
appeals
either the
courts,
judge,
like 9 times out of 10, when it's the judge's error, it still relates to the defense objecting to something that the state is doing. And then the court says, well, the judge agreed with the state on the issue and allowed something in, or allowed the trial to continue, and we disagree with that decision. So just because the judge was the reason doesn't, oh my God, this is how you hide the stats on prosecutorial misconducts causing overturned convictions.
a juror, or a deputy.
Blame the
But
judges
it was a judge's erroneous ruling.
about something the state wanted, I
14 of
guarantee
those
it.
were ineffective assistance of counsel. Defense attorneys not
An ineffective assistance of counsel could also be not objecting to something the state is doing that the state should not be doing.
fulfilling their constitutional duties in representing their clients. 8 of those were because of things that this office did or didn't do. And that's counting the Nora Jackson opinion twice. It's counting it twice. We're counting it in that column twice because one of the violations that the Supreme Court found was with my quoting of witnesses in closing argument. And the other fault that the Supreme Court found was in this statement that everybody keeps talking about.
The air quotes.
Actually, I made a copy of it so you can take it with you and read it.
All right.
That's it. 8 cases since 1990. 2 of those 8 were tried before 1986. It just happened that their reversals didn't happen until in the 2011s, somewhere in that time frame. It took that many years. One of them was Erskine Johnson, and the other was Margot Freshwater. Yes, which you remember very well. So both of those cases were tried and handled. I was still in college when those cases were handled. Had nothing to do with them. But it's a gross misrepresentation for the New York Times or anybody to so flippantly and so callously talk about prosecutorial misconduct. Those numbers I just gave you, nobody talks about judicial misconduct or defense attorney misconduct. We call it error. It needs to be called the same thing here because that's what it is. As I've said many, many times, we're going to make mistakes. When you touch 220,000 cases, mistakes are going to be made. It's why, as you remember, when the push to put body cameras on every officer became so prevalent. And the big pushback that I put up was the duties that we have as prosecutors. We as prosecutors have a higher level of ethics than any other breed of lawyer. And we have to, and we must. The system has to function like that. Everything a prosecutor does is reviewed ad nauseum. It's going to be reviewed by the trial court, who calls the balls and strikes. It's going to be reviewed by the Court of Appeals. It's going to be reviewed by the Supreme Court. And then it's going to start all over again when that defendant who's not gotten any relief from his or her conviction when that defendant now starts attacking his or her attorney. And you start with the post-conviction. And you start with that process when you go back through the trial court and back through the Court of Appeals and back through the Supreme Court. We're talking about violent offenders who are sitting in prison and don't want to be and aren't friends of this office. And they're going to go to all sorts of lengths to do anything and everything they can to get their convictions reversed.
How angry does this article make you, using you as the subject to get the point across that apparently prosecutors are bad?
It's very frustrating.
She's a good example.
It angers me in the sense that we're not telling the truth. I think you mentioned that you are going to try to talk to Judge Coffey. He's very upset with how he was quoted and what was said by him or how it was portrayed. I've been on the phone and on the email with another prosecutor from another end of the country who was quoted in this article erroneously and in an unfair and not straightforward way. They twisted his words, and he's very upset about it. So it's frustrating that we can't have the conversation and use the facts because the facts don't support this pro-crime agenda, this decriminalization of violent behavior, which is really what is being pushed here. This is a defendant who murdered her mother. You covered the trial, you saw the facts, you saw the photos, you heard. We very rarely have motive proof when we go to trial. We had motive proof in this case, not to mention reams and reams and reams.
Reams and reams and reams. Hold on. I feel like they came up with the motive like randomly. Hold on. They just decided, oh, it could have been for the estate. I think they talk about it in this article. So let's back out. All right. So Wyrick's office was accused of withholding a key piece of evidence, which New York Times said proved Jackson's innocence. Tennessee Supreme Court overturned Jackson's conviction, and she eventually entered an Alford plea. She walked out of prison after 12 years behind bars, and then Wyrick spoke to WMC Action News 5. That was what we're watching. Let's see. She's also sending a series of tweets. Amy Wyrick, or the DA's office, was using the hashtag pro-crime New York Times and offered evidence they said proves Nora Jackson killed her mother, Jennifer. One of the first tweets calls the piece a blatant effort to create sympathy for the defendant while demonizing prosecutors. Wyrick spoke to that Tuesday, perhaps previewing her very public fight back. The facts don't support this pro-crime agenda. This decriminalization of violent behavior, which is really what's being pushed here, she said. We as prosecutors have a higher level of ethics than any other breed of lawyer. Yeah, maybe for a good reason. And then I guess they put all the tweets below. Wyrick said in March of this year she agreed to accept a private reprimand from the Tennessee Board of Professional Responsibility, meaning she won't face any misconduct charges for the prosecutorial error. Wyrick released the following statement on the Twitter spree, defending the office's decision in the Jackson case. We decided to send some tweets to balance out the New York Times' one-sided effort to present the twice-convicted defendant as a sympathetic figure. The only sympathetic figure in this tragic case was the woman the defendant pled guilty to stabbing to death, her mother, Jennifer Jackson. So there was something where she, the theory became that the motive was for potential insurance money. And it was kind of just said in court, even though I don't think there was any forensic accounting that pointed there. Have a good one, Ike. Good to see you. Yeah, so I don't know. And the DNA issue, so the Innocence Project involvement, there was no DNA of Nora's, but there was DNA belonging to 2 or 3 other individuals. So that's why the Innocence Project got involved. I think they had a write-up a long time ago. I didn't really follow the case, but I remember it. Okay, yeah, so we're in 2017 here in August. New DNA testing may exonerate Tennessee woman of mother's murder. So I guess they got on their radar because of this New York Times magazine. Uh-oh. Uh-oh, no wonder Amy hates this article so much, because it's actually having a cause and effect. So, let's see. Nora was 18. Jennifer, the mom, was stabbed to death on her bedroom floor. Their Memphis home had been ransacked, and there were signs of a break-in. Only a year and a half prior, Nora's father was shot to death in the convenience store he owned, which was also ransacked. His murder remained unsolved. Facing pressure from the public to solve Jennifer Jackson's murder, Shelby County Deputy District Attorney Amy Wyrick came up with the theory that Nora murdered her mother to collect money from her estate and life insurance policy. Nora was arrested and held on a $500,000 bond. Unable to pay, she was detained for 3.5 years awaiting trial. Jesus. No physical evidence linked Nora to the murder. DNA testing of evidence suggested that 2 or 3 different people were present at the scene of the crime. At Nora's trial, her attorney called no witnesses, thinking the DNA evidence was sufficient to prove her client was not involved. The state called family members to the stand, who testified that Nora was rebellious and that she and her mother often argued, sometimes about money. Other witnesses testified that Nora partied often and consumed alcohol and drugs. The only evidence that tied Nora to the murder was the testimony of her friend. This is the witness that wasn't disclosed. Andrew Hammock, or there was a statement from him that wasn't disclosed. Andrew Hammock, who said that she called him between 4 a.m. and 5 a.m. and asked him to meet her at her house. The jury found Nora guilty of second-degree murder. 5 days later, a letter that Hammock wrote to police surfaced, in which he admitted to lending his phone to a friend and being under the influence of ecstasy the night of the murder. Knowing the admission undermined the credibility of the state's key witness, Nora's attorney appealed to the Tennessee Supreme Court. Because the prosecution failed to turn over the note from Hammock before Nora's trial, the court unanimously overturned her conviction in August of 2014. The court also found that the prosecutor made improper arguments to the jury. So there we go. That was the withheld evidence summarized there. But again, if you want to read that longer decision, and I don't know, maybe we can do a full reading of this at some point in time. There's the link to the full opinion, the 82-page opinion in the chat. In 2015, Nora's case was given over to a neighboring district attorney's office. They offered her a deal where she could take an Alford plea so she could assert her innocence while conceding that the state has enough evidence to convict them. The State Department of Corrections told her she had enough credits to be released the same day. Eager to move on, Nora accepted the deal, but soon learned she did not, in fact, have enough credits to be released right away. And still had another year left to serve. So, yeah, I think that's why I was confused. And then Nora says, I don't even know if I cried. I remember feeling sick and embarrassed and ashamed. On paper, I'm the killer, even though I maintain my innocence. That's what the cops look at. So somebody's just getting away, and I helped make that happen. And I think she means they're not looking to see who these 2 to maybe 3 other individuals were. So, and I guess Innocence Project is working to fully exonerate Nora and see if they can identify the sources of that DNA. So, James says, my friend came by while I was watching the beginning of the stream, and he asked me about why I was watching. So I gave him a 20-minute crash course. You did one of these. You turned into the Charlie meme with the conspiracy board, laying it all out. That's awesome. And then he was like, how have I not heard this before? Look, I'm hoping this picks up attention, all of the stuff going on with the Zach Adams trial. I imagine if he's awarded a new trial, there are going to be a lot of people that are like, wait, what? Because they might not know anything between the trial and they found the guy that killed Holly Bobo and what's happened between then and now. So I wouldn't blame anybody for being like confused or surprised if they were to hear something like that. But it just hasn't had the same interest. And honestly, if you search for articles about post-conviction stuff, a lot of the articles are really like Law and Crime and Court TV. So there isn't that much of like ABC News isn't jumping in on this. But I'm sure they will if a new trial comes about. I think we were on volume 7, right? We didn't actually start going into this. So there was that. Should update my banner. Sorry, but not sorry for the detour. I mean, I think it just, watching the way Amy argues in the opening statements, And I didn't really know any better. Like, I didn't follow this case. So the post-conviction hearings in November, when I saw Kathy Roussan tweet, hey, this is the first I've ever heard something like this before. Brother of defendant, who's also co-defendant, has to go live with a private investigator who's a retired cop as part of a probation condition. Kathy Roussan tweeted that on like November 19th. And ever since then, I've been like, what is going on? So when I first saw the opening statements, it seemed like what Doug was saying was honest and very important, but it was hard for me to track. It was hard for me to digest. Now I get it. And it's like, holy moly, how did he condense that down into like 20 minutes? When I watched Amy, I was like, she's yelling a lot. And I don't really think I like when the prosecutors yell a lot. But maybe she's right. Like, why would she be going so hard if she wasn't being honest here? And now I'm like, oh no, she just yells and thinks that yelling makes it true. So I thought that was a worthwhile detour there. I'm going to update my banner. I just realized I had Adventure Aaron's name spelled wrong the entire time. So let me correct that. I had it spelled wrong in 2 ways. And then we'll get back to these sidebar transcripts from 2017. Righty. There we go. Heck yeah, Mary, me too. Always learning something new. And again, the Nora Jackson case, I think that was a pretty popular case. I think there was a lot of discussion about it when it was happening. I remember the name. I know daughter killing mom, that's gonna make headlines. But I didn't really know what happened then or now. And I had no idea that it was an Amy Weirich case until I think either Trial and Error had a video about it, or maybe DB had said something about it. Maybe someone in the chat said something about it. But I was like, okay, let me go look. So let's find some sidebars over on September 13th. I'm calling it day 3 of the trial. Did they do anything before the jury came in? All right, so they're in the process of bringing the jury down. Are we dead on the back? You're dead for right now? Okay, I'll let you know when you can go up. Okay. I'm going to explain to this jury that I can't let them go to the high school football game. I had forgot. I've had enough cameras in court that I really and truly forget they're here, and my announcement probably went out to 20,000 plus people. I can't take a chance on exposure of this jury. So they're going to be told that they can follow that ball game by radio or by streaming video. So that's on me. It probably wasn't a good idea anyway. You think? But that's why I said dead mic. I am going to tell the jury that to start with, and then we'll be back up. That wasn't up to them. Press, of course, has been very cooperative. Haven't had any problems since day 1. Well, I had one little snafu, but it wasn't bad. And if you want to hear this judge define snafu, he does so during the 2020 plea hearing for Jason Autry. But it wasn't bad. They say all rise. Court thanks juror number 4. Let me thank you again. 14. You've been a gentleman throughout the process. Okay, be seated. And you notice I did not address you by name. I'm trying to protect you folks, which brings us to our first order of business. Are you folks familiar with the Latin term mea culpa? The jury, no, sir. The court, it's Latin. It means my fault, or as my kids would say, my bad. Have you heard that? I told you yesterday we were going to try to make arrangements for those that wanted to attend the football game. I forgot we were on open mic. That information went out to thousands of people. As a result, I'm not going to expose you folks to possible mischief. So as I've said, it might not have been that good of an idea anyway, but I'm trying to protect you folks, trying to protect the integrity of the trial. If we still had District Attorney Hansel McAdams and the same board of directors for the Attorney General Fund and the DTF Fund, maybe they could have used the helicopters, the DTF helicopters and airplanes and the seized golf carts to take these folks out to watch this game. They could have had better planning. If you guys missed that, we did do the civil forfeiture reading at the end of yesterday's stream. That was a good time. So, judge says, so the sheriff has already told me he's in the process of making alternative means that you can watch ball game or ball games, okay? So I hope you'll understand. And ultimately, I think this is a better way to go. And something very serious where you folks had followed my admonitions to avoid any reports or any exposure, then we need to make sure we take this to conclusion. Everybody have a reasonably good night. And as I said at the outset, it's not like your own place, I understand that. But are you being reasonably accommodated? Yes, sir. Birthday all right? A juror says delicious. Maybe they said something about cake. But I'm thinking of Doug Bates with the delicious. The court says, okay, mine probably will be a hot dog, but that's all right. Juror, I'll give you some of my cake I got left. Yeah, they were talking about food, and they just didn't transcribe it right. The court, I had a cousin of mine brought me a chocolate pie yesterday. You want to get this case to a conclusion, but here you are. Here you are. People are feeling sorry for me. This is my job. I'm used to doing it. It's a little more intense because we're sequestered and got a lot of attention to this. But I don't mind people feeling a little sorry for me. It was a nice chocolate pie. I started on it yesterday. I don't do that to make you jealous, but there's not enough for 15 pieces, so you'll just have to be on your own. All right, we're ready to get started. And actually, I was off mic during that, so I remembered that. Oh my goodness, chat. Oh, yay. I had your name spelled wrong the whole chat in the banner, Aaron. I'm sorry. But I just corrected it, and here you are. Happy birthday. Happy birthday, happy birthday. Yeah, I don't know what this judge is on about, Amber. I have no idea. Kelly says, I don't feel sorry for you, Creed. Yes, happy birthday to Aaron in the building. Hope you are having a good one. Miss Adventure Aaron, our honorable chat attorney that helps us out whenever we're like, what the heck does this mean? Is this normal? And she'll be like either throwing tomatoes to say it's not normal or like, yeah, it actually does happen sometimes. It is what it is. There we go. Lots of love in the chat. Love it, you guys. So let's find this next sidebar. Let's find more parentheses. We heard about the chocolate pie. Are you going to have a chocolate pie for your birthday? All right, Dennis McKenzie's on the stand. That's the guy that saw the vacuuming, I guess. All right, so let's see. Nothing further. Witness is excused from the stand. John Graves is called. Let's see. Lots of pointing. Lots of pointing about the roads. All right, so now we have an objection, I think. All right, so the question is, okay, so if he's put it in his report, this is Thompson. I can tell by the way it's written. So if he's put it in his report that you said you did not touch the lunchbox, the agent is wrong? Answer, I don't have any recollection of that because I did specifically touch the lunchbox. There was no ifs, ands, or buts about that. Question, okay, that's how you remember it today? Yes. Your son told people he had Holly Bobo locked up. Oh, I remember this now. General Nichols, Your Honor, objection. The court, wait. Ms. Thompson, I'm not using it for the truth, Your Honor. This is not General Nichols. If your son told people. Well, and Thompson's explaining why it's not, why it falls under here. It's not hearsay because it's not offered for the truth of the matter. So Nichols is not picking up what Thompson's saying. The court says, your son told people? Ms. Thompson, your son, General Nichols, and even if your son said anything, Your Honor, we've got John Graves here. Question, anything that John Graves told somebody, fair game. The court, if you want to call the son, you can call the son. Ms. Thompson, Your Honor, I'm not using it to prove the truth. It's a hearsay statement, but it meets an exception, and that it's something that his son said at the time, and he's very aware of it, Your Honor, because he went to school. The court says, take the jury out. So now we have the sidebar outside the jury presence. Ms. Thompson, I have no idea where you're going. Sometimes people think I know everything about the case. I assure you I don't from both sides. Well, you were certainly vouching. We've read 2 sidebars already where the court was like, well, the state turned over everything. I know they did. But now he's like, well, I assure you I don't know everything about this case from both sides. So Ms. Thompson says, okay. The court says, where are you going? Ms. Thompson, well, what I'm trying to show is that people in different The court says, no problem with the witness being present while we're discussing this. Ms. Thompson says, no, Your Honor. Okay. Ms. Thompson, but I was trying to show that the court, he'll follow the court's ruling when I instruct. Ms. Thompson, different people who, and the reason I would want to get in through him and not the son was only in 2nd grade at the time he said it. So he may or may not have been a competent witness to testify. The court says, then that's all the more reason it probably shouldn't come in. Ms. Thompson, but I'm just trying to show that there were people in the community saying things that were not true. The court says, ostensibly, what did the son say? Ms. Thompson, he said that his uncle had Holly Bobo locked up at home and they were trying to convince him to let her loose. The court says, what exception to hearsay is this? Ms. Thompson, I'm just trying to show what effect it had on him, not that it was true. The family didn't have Holly Bobo locked up. It was not a true statement. The court, it lacks any indicia of reliability. We're not going there. Bring the jury in. And then they do an offer of proof, and we were able to see all of that. So they asked the witness, and the witness says he can't recall. So then we had, do you recall that in December of 2011, Terry Dykes again came to meet with you regarding your son, Jeb? Terry could have come by. I mean, it's possible. Do you recall that there was a day when the kids were out of school due to weather, and your son had found a glove somewhere, and they were going around trying to decide who took Holly Bobo? General Nichols jumps in and says, I'm sorry, I don't understand. The kids found a glove, and the kids were going around. I just don't understand the question for Terry Dykes. Ms. Thompson, yes, the kids found a glove while they were out of school because of weather, and they were playing a little game where they were trying to decide who took Holly Bobo. You remember that, don't you? It seems like I do remember something about a glove at our office, and that, yes. Nichols says, a glove at your office, not the witness, not anywhere close to the site. I mean, it's a worker's glove that was laying on the ground, like we had nails and hammers. General Nichols, so they were playing? Right. Ms. Thompson, they were playing a game, yes. And then the court says, let her ask the question. Okay. So they were playing a game, weren't they? I assume, yes. And at some point, they were pretending like they were trying to find out who took Holly Bobo, weren't they? I assume, yes. At some point, your son just made a little playing statement about the fact that his uncle had Holly Bobo locked up. And then General Nichols says, okay, at this point, I'm just going to interject. Was he present when this statement was made? Otherwise, it's just asking to speculate. The court, were you present when any such statement was made? No. Okay. And then Ms. Thompson says, but at some point it all came to your attention and you talked to your son about it, didn't you? Really, to be honest with you, I can't recall. So something as big as everybody, agents coming to your house to talk to you about this. This isn't, you have no memory of this at this point? No. Ms. Thompson, no further questions. And then this son was only 12, is 12 now, so he was 5 then. And then judge says, makes it even more likely that that's inappropriate. And then again, Thompson reiterates that the reason she wanted to offer it is not because I think it's reliable or was trying to show that this happened. What I was trying to show was that the community was very, very sensitive at the time. So anytime anybody said anything about Holly Bobo or somebody possibly having Holly Bobo, everybody overreacted. And now what's interesting is like she doesn't end up asking Terry Dykes about this when Terry Dykes is on the stand later. So there was that. Also, hey, Docket Decoder, good to see you guys. Guys, make sure you're also checking out Docket Decoder. Let me just get the channel link here. I don't think I have. I'm not sure. I may have your channel in the description, but I'm not sure. So let me drop it in the chat now just in case it's not there. There you go. And Docket Decoder has not just commentary, but also like has uploaded portions of different testimony from this post-conviction hearings. So really easy to go and rewatch certain clips. That's where I went over and watched Beth Boswell. One of our favorites. That's the one with the stripy hair. But also has a ton of content on the Lauren Matthias saga. So if you guys are following that, another great channel to check out. Also want to give a huge thank you here. I saw future Miss Martin 2.0 turning green and then brought 20 with her. So huge thank you to future Miss Martin 2.0. Good to see you. Hope you are doing well. And if you guys don't already know, when I say future Miss Martin 2.0, that is in reference to potentially criminal, who's Sean. So that's why it's Future Miss Martin 2.0 for Sean Martin. And let me get his link here. And Potentially Criminal is, I really love to watch anytime Potentially Criminal does like Supreme Court cases, like really does a good job breaking down SCOTUS arguments and covering some more nuanced cases. I watched the Buc-ee's lawsuit over there. Buc-ee's lawsuit with trademark infringement going after someone. It was like I think it was like a veterinarian pet washing, but their logo looks similar to Buc-ee's, and Buc-ee's was like, we're not having it. So just really cool kind of niche stuff you'll get over there sometimes. So in honor of Future Miss Martin 2.0, sharing Potentially Criminal here. If you guys haven't already checked out Sean's content, An Actual Lawyer, link is right there for you. There you go, Sean the man. I think Sean is the reason I first heard about the, do you guys remember the case? There was like this saga over boneless wings. And I think it got to the Supreme Court of Ohio. And the final ruling at the state Supreme Court is that just because something's advertised as boneless wings on a menu does not mean that a restaurant would be liable if there's like a piece of bone fragment in the boneless wing. With the reason being that because a boneless wing would still come from chicken, which is an animal that needs to be processed to become a boneless wing, that a reasonable person should still be aware that there might be bones in any type of chicken that they're eating. So when I say going through like interesting arguments like that, that was a whole time. The argument over boneless wings. DV says, Sean was one of the first people to show my video trolling Jennifer Coffindoffer into reading fake evidence. I missed that, but that is hilarious. That is very hilarious. That is super funny. And thank you again, Future Miss Martin 2.0, wishing us, hoping that we all had a good holiday. Right back at you. We also had Sheriff Chuck dropping 5 in the chat, another 5. He's up to like 3 million gifted subs now. So big thank you to Sheriff Chuck, turning everybody green. And where's Adventure Aaron? I gotta make it clear here that Sheriff Chuck changed his picture back to Party Chuck because it's your birthday today. So if you didn't see the screen and you look at the screen, you'll see the Party Chuck has come out to celebrate Adventure Aaron's birthday. So thank you again, Sheriff Chuck. And we've got I think I saw someone earlier ask about the hearings. Yes, Ems had asked about the hearings. So Monday and Tuesday, starting at 8:30 Central, that's 9:30 a.m. Eastern, so that's when we'll be starting. We'll be live all day for like a million hours, 12-hour days. But their state's got 6 people on their witness list. One of them is Boat Guy, who nobody's ever heard from before. State will get to call their witnesses. That's their presentation of their proof for this post-conviction relief proceeding. And when they close, we'll get to closing arguments, which would probably fall on Tuesday. But it seems like everybody's in agreement that they don't need those January hearing dates and that they're going to wrap up Tuesday. So I don't know exactly what they're going to argue, but I imagine we're going to get like, everything was great. We fully excluded the Brits. We proceeded by the books. The only one that did something wrong was Terry Dykes because he got tunnel vision and was standing in the way of the way we wanted to prosecute this case. And 12 jurors and Boat Guy. And Jason Autry is super credible. So I think that's my primer, my guess on what we're going to hear tomorrow from the prosecution side. So there's that. Oh, when she thought the fake Google searches were real. That's hilarious. What a legend. Yes. GV says effing legendary. And it's pinned on your ex. Let me go check out a pinned tweet. Love it. Love it. So when is the ruling? I'm not sure what the time frame is, but I imagine the judge will take several days to at least weigh and consider and issue hopefully a detailed ruling and hopefully a decision that's adverse to the state and gives Zachary Adams a new trial. So I don't know the timeline for a response though, but some of his other orders, he took a few days, several days, and they were smaller issues, right? This is the big issue, the whole package coming to an end, and he's got to put the bow on it. So I don't expect a ruling right away, but of course, as soon as it's there, I'll run and hit the live button to talk about it with you guys. This whole time. What a time this last month this deep dive has been. So we've got, let's see, jury comes back in after we ask about this glove thing, which is a little bit of a side story, right? Maybe ask Terry Dykes about the chaos of witnesses coming in, and every time, just because we're hearing about people saying things in court for this 2-week trial, doesn't mean that other things weren't said out of court. So the jury, the idea that the jury is hearing these inflammatory remarks that supposedly Zach said, I'm going to do you like I did Holly Bobo. This idea, you're hearing this, but there were so many other people in the community that had these same types of claims being made against them. And if you put that in the jury's awareness, it could shift the way they receive what they're hearing that Zach Adams supposedly said, if they are aware that many other people had the same things being said about them. So, but I don't think this was an effective way for Jennifer Thompson to get into it. All right, we've got jury comes back in. They say they have no further questions. I don't think there's anything there. They enter an exhibit. This was the day we almost lost it as a chat, because this is where we're finding out that there is a crossroads for Gooch Creek Road and Horny Head Creek Road. A real intersection. 2 roads, crazy names, intersecting each other. And then they're confused. They're like, wait, this is Horny Creek Road? This would be back here? And making them repeat it. I was in disbelief that day, but it's real. All right, so they dismiss that witness. Who do they have next? Gerald Stevens. I think he found a piece of evidence. This is the pink panties witness, the guy that found the pink panties that don't even belong to Holly Bobo. All right, this little interlude says, whereupon there was a power outage and the following proceedings were had. So the reporter said, I'm down completely. Let's see. I wonder if this was one of those long breaks from Law and Crime or Law News. So they try to enter an exhibit, and then the court says, let's go ahead and kill the lights. The markings are not in the picture, Mr. Ragland. No, sir, the other way. And then the reporter says, hey, judge, my system's down. The court says, wait a second, you're down? Court reporter says, I'm down completely. Mr. Gonzalez, it's a power surge. A fuse went out or something. So whereupon there was a power outage and the following proceedings were had. The court, well, I guess this is a good time to take a break, isn't it? When I said kill the lights, I didn't mean kill all the power. Follow these instructions I gave you. We'll take a 15 at this time, get our problems corrected. So they take a short break, and then they ask for everyone to remain standing for the jury to come in. And then that break was probably a little sooner than I would have, but we were encountering some power problems. This courthouse was built in 1950 or 51. I think it's one of the prettiest courthouses or courtrooms in the state of Tennessee. And you'll remember there's like a bunch of chandeliers and everything hanging around. And then, let's see. I think it's one of the prettiest courthouses, whatever. I think we temporarily got things going. We should be able to continue. So they continue. All right, indicating, entering exhibits. All right, now Suzanne Pratt is taking the stand. Entering exhibits. All right, that witness is excused. Anisha Brasher comes on the stand. I think she's the one that found the SIM card, the phone SIM card, while riding her bike. She's excused. Larry Stone, that's the ginseng hunter-gatherer. All right, there's a ton of pointing in his testimony. All right. You can step down, don't discuss your testimony. So he's excused. Laura Hodge is called. That was the forensics. She talked about how they did the line walking 2 days later after the remains were found. All right, and they're going through all the exhibits because they had this witness like discuss where they were found. Oh, okay, so jury leaves for a lunch break. All right, let's see if they say anything. Nope, they get Ms. Hodge right back on the stand, so no sidebar or commentary. They just have their lunch break. More exhibits. More exhibits. More exhibits. And I would just search for like the word conference, but not all of the sidebar indications use that keyword. So the most reliable to find all of them and not miss any are unfortunately searching for parentheses, which pop up more often. So lots of exhibits here. Maybe taking us through the... Yep, all right, so that's the end of 7. Right, volume 8. Wait, a random mention of Adam Abate? What's happening? Oh my goodness. We'll just put some tomatoes on the stand here. All right, we've got, I think this is going to be the same day for this volume, but we'll double check. Yep, okay, so still the same day. This is what I'm calling day 3 because I'm not counting voir dire. So that Wednesday. All right, and they get right to it. So they say, we've got the jury on our way. We'll start back up as soon as they get here. And then they ask them to be seated, and they call Marco Ross. So this is the guy that discusses all the stuff with the medical information. So the defect to the back of the skull. And he ends up opining on firearms and ballistics, even though I don't think he's an expert in that. But all right, so we're going to have a sidebar here. So next witness, Marco Ross. Your Honor, can we approach? So Mr. Simmons, defense attorney, asked to approach. Jury, there's a sidebar here. Mr. Simmons says, Your Honor, this was the subject of a pretrial motion about excluding the actual physical skull if they intended. The court says, I hope we won't. General Nichols, not unless y'all make it an issue. The court, okay, I was hoping we could avoid that. Whereupon the following proceedings continued within the hearing of the jury. So they swear in the witness. All right, they're entering a bunch of exhibits and pointing. There's probably going to be a lot of pointing. All right, then they let Dr. Ross off the stand. All right, there's going to be a break. They bring the jury back in. And Crystal Rodriguez is called. And she looked at the ribs. Oh. All right, so here we're at a point where they want to approach. So there's this long paragraph. with instructions to ignore news reports. Do you have any questions prior to release for the evening? And then they say, let's let our jury exit. So the jury leaves the courtroom and the court was adjourned for the evening. Okay, I guess we just... Interesting. So this volume includes the next day. So we're going to be on September 14th now, which what I would call day 4. And let's see. Right away, General Nichols wants to approach. The court says yes. General Nichols says, we were trying to catch you before you got on the bench. The defense gave us a list of things that they need for the next witness, and we have agents pulling it. They just got it this morning. So we need like 15 more minutes. She's just been pulling a bunch of reports. So remember, this is the day that they call Jason Autry, and he's on the stand all day. But they didn't tell Jennifer Thompson the night before that they were going to call the star witness the next day. So, and we're letting the judge know, hey, we did this late. We just wanted to let you know. We've got, let's see. Do we have to delay just because of that? General Nichols, yes, yeah, because we may want it. The court says, all right. So then the jury comes in, advise the jury, it will be about 15 minutes. You can take them back upstairs. We're going to recess. Boy, I love to start the day with a recess. Not. We're going to take about 15 minutes. So they take a short break and ask everyone to be seated to proceed. And then the court says, for the purpose of the record, you had asked for some additional time to transfer some requested information to defense counsel that you thought would expedite. You've now advised that you might change your order of proof. General Nichols says, we're going to change our order of proof. I haven't seen it, but I think the evidence has been located, but the person handling that witness hasn't gone through it, so we're going to call a different witness. The court says, all right, call your next witness. Jason Autry. And they say, might be good to get the jury. Hold on. So then they bring the jury in. That's kind of an important piece of the puzzle. And then Ms. Thompson says, Judge, I'm not ready to do Jason Autry. A lot of our Jason Autry stuff is at the hotel. We brought all of this Brent Booth stuff here today. I've got all kinds of stuff at the, we don't have a place here to keep things. So we keep having big tubs that we're carrying stuff back and forth. The court says, how long do you need to get your stuff? Ms. Thompson says, probably an hour to go over and get it all together. The court says, take the jury back upstairs. Tell them we're going to need additional time. Where's your material? Hotel? Ms. Thompson, yes, Your Honor. Court says, all right, we're going to recess. Pronto, okay? Ms. Thompson says, yes, Your Honor. Pronto, the court says again. Mr. Gonzalez says, 10:20, Your Honor. The court says, yes, let's round it off to 10:30. Give you an hour and 8 minutes. So they have a short break. And then the court says, be seated, bring the jury in 2 minutes. Mr. Simmons says, Your Honor, can we approach? This is a mess. This is a mess. The court says, yes, hold the jury just a moment. Whereupon a conference was held at the bench between counsel and the court. Mr. Simmons says, Your Honor, John Reeves, our expert on telephone analysis, is here this morning sitting in the courtroom. Wanted to, the court, state have any objection to the expert remaining in? General Nichols says no. The court says same thing would go for them. Mr. Simmons, certainly. The court says, normally I allow that. General Nichols says no objection. And then the proceedings continue within the hearing of the courtroom. So the jury comes in, they say, be seated. Does anyone need additional writing materials? If you do, just ask. There we go. And then the court says, I want to apologize for the delay. A trial of this nature, sometimes that happens, okay? Might be something that we need to handle internally. Might be something that eventually might expedite the trial. So don't speculate as to why you're sitting there cooling your jets. You can take my word. You can take my word. It's necessary from time to time. That won't probably be the last time, okay? All right, call your next witness. Jason Autry. Jason Autry.
The air was just thick with animosity.
Jason Autry. All right, so next sidebar. Gotta skip a bunch of these. All right, so a lot of pointing. Attorney moves the mic closer to the defendant. I guess he is a... I guess he's technically a defendant. He is a co-defendant, but they are referring to Jason Autry here. Pointing. All right. Jason Autry's handed a laser pointer. Photographs are marked as exhibits. Pointing. Lots of pointing. Because remember, he's going through all of the, like, pointing at the maps and the riprap. And the foliage that was so tall that he couldn't see Zach Adams. I wish I could also exclude search terms, like, and just exclude any results that would contain or be followed by the word indicating. Oh, okay. So I think we're about to have a sidebar here. So the question was, so tell me after you left the afternoon of the 13th, when is the next opportunity you had or the next time you talked to any of the three of them? So Zach, Dylan, or Shane. I'm not asking for a day unless you remember. I'm more asking for, and then the answer is 2 days later. Ms. Thompson, Your Honor, I'm going to object if they're going to get into 404B evidence that's not related to these charges. The other thing is, so Thompson is aware of where this is about to go. Thompson's aware. The other thing is, I'm going to object to hearsay as to what somebody else may have told Mr. Autry and not specifically Mr. Adams. So General Nichols says, my question was simply when is the next opportunity he had. I didn't ask him what anybody said. Ms. Thompson, well, I'm just in advance, Your Honor. I am anticipating. The court says, be cautious, please. General Nichols says, I will. So Nichols continues to question. Mr. Autry, I want you to listen to my questions very carefully. If I don't ask you what somebody said, don't volunteer it. Gotcha? You understand? Yes, ma'am. All right. When is the next opportunity that you had to speak to Zach Adams, Dylan Adams, or Shane Austin? 2 days later. That would have been Friday the 15th? That's correct. On what day, which of the three of them did you talk to? Zach. And where were you? In Benton County. And they're going to go through this, you guys. So, talking about this, I believe I saw that there was a sidebar. Let's see. So they're talking about this vehicle. Remember, this is where they get into the conversation where Zach's going to ask Autry to kill Dylan because Dylan's talking. So, all right. So when you pulled up, he pulled up, correct? I was there first and he pulled in behind me. What vehicle were they in and who was driving? They were in Dylan's Chevrolet extended cab pickup. General Nichols, Your Honor, at this time we need to approach. Ms. Thompson, Your Honor, I'd ask for a jury out hearing if there's going to be any kind of evidentiary discussion so we can get it on the record. General Nichols, there will be. So the court sends the jury out. The court, has their food arrived? Let's just take our lunch recess for an hour. We're going to need him. If we're going to have the 404B hearing, we'll need him for a few minutes talking about Autry. Court says, all right, be seated. General Nichols, as Your Honor is aware, the state filed a 404B motion earlier, and we are at that portion of the trial where we are seeking to introduce evidence that could very possibly, undoubtedly, fall into the 404B category. Yeah, it's not bad character evidence, obviously, if we're just going to talk about how he supposedly, allegedly, asked somebody to kill somebody else that could have been a witness to something. It's not 404B. It is merely, another school of thought is that it actually does not. It is merely contextual for what happened in the aftermath of Holly Bobo's murder. But just in case you find it to be, fall within 404B. She's really going to argue this? She's really trying to argue that that wouldn't be 404B and it would just be contextual? Chat. But just in case you find it to be, fall within 404B, I didn't want to start it without, the court says, okay. General Nichols, so I think the better outline for you what I believe, and then I would like to put on proof through Mr. Autry. Once they were parked in the parking lot of this marathon, there was a conversation between Mr. Autry and Zach Adams. A request was made by Zach Adams, and that is a testimony I'm going to ask the witness. Right, like, it was literally charged for it. Although dropped, but charged, like... The court, okay, go ahead. So Nichols says, so Mr. Autry, lean forward, make sure the judge can hear you. When you were there first, you said, remember, this is outside the presence of the jury. When you were there first, you said, and he pulled up in Dylan's extended cab. Is that correct? That is correct. All right. Did you get out of your car? I did not. Did somebody come to your car? Zach come to my car. Okay. We proceeded to... Did he get into the car? Got into the car, yeah. Okay, he's on the passenger side. You're on the driver's side? That is correct. Did you have a conversation? That is correct. Would you tell the judge the entire conversation you had? Whenever he got in the car, I handed him a meth pipe. He took a couple of hits off of it, and I asked him, I said, what did you ever do with the old girl? He said, we throwed her out over near Kelly Ridge. He said, that's not the main reason I'm here. He said, fucking Dylan ain't been to bed and won't stop talking about it. He said, I want to see if you'll get rid of him. Kill him for me. At that time, he made an offer for me to get rid of Mr. Dylan. General Nichols, Your Honor, it is the state's position that that 404B statement of Mr. Adams falls directly into the category of his motive, his intent, his plan to get away with this crime, because at that time, because Dylan Adams hadn't been to bed and wouldn't quit talking, he was afraid, he being Zach Adams, was afraid Dylan Adams was going to implicate him and that he would be caught. And I truly don't believe it's 404B. I think truly it's a statement made directly after the murder took place and the kidnapping and the rape, but we do seek to offer it. Ms. Thompson, first of all, Your Honor, this is something that's happening 2 days later, so it is not directly related to statements directly after the murder, the alleged murder of Holly Bobo. Second of all, it's irrelevant as to whether at that point the crime, the murder of Holly Bobo, is completed. It is finished. What happens next is irrelevant, Your Honor. So it's not relevant to whether or not Mr. Adams was involved in shooting Holly Bobo. He shot Holly Bobo, he kidnapped her, or he raped her. It's independent of that. Next, it's highly prejudicial because it paints Mr. Adams out to be a killer of his own brother. That's a second murder, a second attempted murder that they're trying to pull in here. And then after that, it's just, if you give it any kind of 404 analysis, it's just highly prejudicial, and the prejudice of this outweighs the probative value of whether or not this is, probative value that it has as to whether or not Mr. Adams killed Holly Bobo. We've already heard that. The whole murder is complete. We've already heard all of the murder information, and at this point, these are just additional crimes and wrongs that they're trying to bring in. It doesn't show a pattern because it doesn't show anything about the murder. The murder is completed, allegedly, if you're going to believe Mr. Autry. The murder is completed. It's final. And now that they're trying to introduce, it doesn't go to show anything about the murder. So General Nichols says, and we, of course, the court says, it's contextual. And now part of this weighing act, when you're figuring out this balance, is it probative, is it prejudicial, is, the veracity. This is just a statement of somebody saying that this thing supposedly happened. There isn't any other proof to back this up, which should go to steer a judge to consider it more on the probative side, or more on the prejudicial side than on the probative side. But again, this judge has already concluded that Jason Autry is a super credible, persuasive witness, and he's just going to say his word is enough. So he's just going to say, well, you know what? It's more probative just because I've decided that this witness is credible. So he says it's just contextual. If it's true, then it's showing an attempt to cover a crime by further doing things to keep it from being undetected by other people. Ms. Thompson, but he's not charged with that crime, Your Honor. He's not charged with trying to cover up the murder. The court, it's part of the context, though. The court finds that it is particularly probative in this case, and it doesn't really go to a character trait. It goes to an attempt to keep something from being discovered, and the court finds that its probative value does outweigh the danger of unfair prejudice. So even if it's 404, which I'm not sure it is, I think it's contextual. The court finds, nevertheless, it would be admissible. Okay? Clear and convincing evidence, court finds. Because again, he trusts Jason Autry. So yeah, don't forget it's Sunday, guys. So while we're talking about Judge McKinley, we can all talk about our football teams. I'm a Vikings fan. YP says go Niners. Don't forget about our football, guys. Don't forget about our football. So they say, let's take lunch. After this very difficult decision, court says, let's take our lunch. Then they say, be seated. Let me say this before we get started. She said, I didn't say material. If I didn't, I certainly implied that particular evidence was material. I said it's relevant as to the... So we're missing part of the record here. we're missing part of the record, or maybe someone had a conversation with him off record. But somebody apparently went to McKinley and said, hey, but you still didn't address in your ruling whether this is material or not. If I didn't, I certainly implied that that particular evidence was material. I said it's relevant as to the entire complete story, and we got a limiting instruction. If he so testifies, I will give to the jury immediately afterwards. So then the jury returns to the courtroom, and then they bring Autry back in, and he continues. So skip ahead, jury returns, he's nodding. All right, so now we're going to have another approach. So the context leading up to the sidebar are, were you talking about the deer stand and the trail cam, or were you talking about something else? Well, let's go back a little bit more. So this is now August of 2012. So August of 2012, carry on. It was a pretty good walk in there. On the way out, we stopped and sit down where a road had been pushed through, and the bank, sit on the bank, took a couple hits of a meth pipe, and I looked at him and I said, looks like we got by with this shit. Question, were you talking about the deer stand and the trail cam, or were you talking about something else? And Autry says, talking about the kidnapping, rape, and murder of Holly Bobo. He just lays out all of the charges. I told him, I said, Dylan said, Ms. Thompson, objection, Your Honor. General Nichols says, oh no, actually, you can, this is a statement you made to Zach. That is correct. All right. Ms. Thompson, Your Honor, it's still hearsay. It's double hearsay. It's hearsay within hearsay. General Nichols, may we approach briefly? So then they have a sidebar. General Nichols, I'm offering this for the truth. Ms. Thompson, of course she is. General Nichols, wait, let me finish. No, I'm not. I'm offering it for Zach's response. The court, okay. Ms. Thompson, it's still the way that she can get in hearsay by not having done it. If she comes in and says all of the stuff, then it's a way to get in hearsay. She's offering it for the truth. She's saying that Dylan said this and that Dylan meant this, and now he's wanting to know what Zach's response is, saying that the statement that Dylan said is true. General Nichols, I'm not offering it for the truth, and I do think Your Honor ought to give them a curative instruction, but because I'm not offering it for the truth, this has crippled our case. This is Zach's response. Ms. Thompson, to say in a sidebar that anything is crippling in your case, when you've been like, we have mountains of evidence, all of the evidence. Oh my goodness. So then Ms. Thompson says, of course it's for the truth. She's trying to show through a back door what it is that Dylan said. So then the jury comes back in and the court says, all right, ask the question. And Nichols says, you want me to ask my question? The court says yes. And then they go on saying, you made a statement. Looks like we got away with this shit. That's correct. And then what did he say? And then the court gives the instruction. All right, ladies and gentlemen, as I told you the other day, this is not being offered for the truth of what he said. It's offered to as far as follow-up response. So you shall not consider what he said for the truth of it. Okay? All right. But unfortunately, that doesn't really work, because if you didn't say it at all, then there's no response at all. And the response, you're also asserting that you're also presenting to the jury that the presence of a response at all is a truthful event, that a response was in fact given, which I think is how we get back to a double hearsay issue. So it's like, if you're letting this in, sure, we shouldn't be able to consider if Dylan was being truthful or not, but it's suggesting that the response actually happened at all. So, and then General Nichols says, what did Zach, or how did Zach respond? And then Autry says, he said the real reason that we were there was to show Clint how to manufacture meth. He said, we got there early. She come outside screaming and raising hell, and we took her. So, all right, that's not offered for the truth of it. Besides that, it's allegedly a statement of the defendant, not a third party. So, let's see. This is all in front of the jury, right? I didn't miss them dismissing. So this is a great example of how these arguments just spill out in front of the jury. So then he's like, all right, he said the real reason that we got there was to show Clint how to manufacture meth. He said, we got there early, she come outside screaming and raising hell, and we took her. The court said, all right, that's not offered for the truth of it. Besides that, it's allegedly a statement of the defendant, not a third party, okay? General Nichols says, all right, and how did you respond to that information? So then they keep going on. Argued right in front of the jury like that. Let's see. Now they're going through the gun evidence, entering exhibits, going through the routes. Bunch of pointing. All right, so then they say, the court says, I'm assuming that you'll require some time for cross-examination. Yes, Your Honor. All right, let's go ahead and take a break. Take 15, follow the rules that I gave you at the outset. And so the jury leaves and they end this volume here. So next volume, let's get to volume 10. Or at volume 9. Yeah, GB, that part's crazy. I can't believe Nichols called this crippling to their case. Just dramatic, just dramatic. Also, thank you. I see Autry's fake accent is in the building. Good to see you. Good to see you. Should I run this back one more time?
The air was just thick with animosity.
Hold on, I got another one.
One lick was exchanged. Zach hit Shane. Dinsmore comes outside.
It's a good time. And don't forget the innocent man walking. I need to clip that one. And then you say, thank you for all you're doing, Kat. Well, thanks for being here. And I'll be with you guys tomorrow for the hearing. I cannot wait for the hearings tomorrow. I've got to delete some little clips back here. I have a few clipped from his testimony and some of the recordings, but I don't have room in StreamYard. I got to delete some stuff. But yeah. And don't forget, every time he talks, even though Jennifer Nichols is standing in front of him, his mouth is in this drawn down expression. Just like, I don't know, like the chart in elementary schools where it shows you all the different types of emotions and they're just like drawing diagrams of faces. He looks like a caricature the whole time he's on the stand. So thank you so much for the super and the opportunity to play Jason Autry's accent. The fake accent, not the real one. And then volume 9. So volume 9 is going to be the rest of Jason Autry, I would assume. Let's see. And it's starting right with the cross-examination. So let's see. The jury comes in after this break. The court says be seated. Autry comes back in and cross-examination starts. Let's look for sidebars. Lots of nodding. This is where he's doing some drawing, some pointing. Some exhibits are being entered. And I think Kay Riggs gave us a preview on this. I think there's a good one in here. I think there's a good sidebar in here. Oh, there's so many indications. All right, and this is where the defendant like walked to point at something. He returns to the bench. All right, there was a short break. Let's see. Let's take a break. And it's hot. He's acknowledging that it's hot and stuffy in the courtroom. He says, I'll tell you what. Let's take a break. It's stuffy in here. Hopefully it will be a little cooler up there. We will take an afternoon break of 15 minutes. They take a short break, and then the court's called to order. And then, Your Honor, I'd like to ask for Jenks material on Mr. Autry. I know the government says they've provided Jenks, but there was a proffer session. I believe it was January 18th, 19th, and 20th. It took place without any law enforcement there, but between the district attorney's office and Mr. Autry. And I would like to have copies of those notes, Your Honor, because Mr. Autry has given so few statements. The notes that the district attorney took are absolutely critical in this case because of the fact that they are material to me doing an effective cross-examination. Prior inconsistent statements is what we have to impeach Mr. Autry with. I recognize that many times notes are considered to be the work product of the district attorney's office. However, there's actually case law that says in special cases, it is possible that they would be discoverable. I say that because the district attorney's office set this meeting up without law enforcement, because normally law enforcement would be there and would write up, notes and reports from any encounter they had. Because the district attorney set it up this way, that they intentionally made their notes into discoverable material. If the court is inclined to deny having the district attorney's office turn over their notes from the 3-day proffer session, then I would ask that those notes can be redacted in case there's any work product like impressions that they have of the witnesses or anything. But if not, I would ask that those notes be filed under seal and made part of the record, so that on appeal, the Court of Criminal Appeals could determine whether or not those notes, in fact, were discoverable. General Nichols says, whether they're discoverable or not, we don't have notes. I can hear her voice. We don't have notes. The court, okay, end of it. Wow. Just shutting it down. General Hagerman steps in. To be clear, we didn't take notes. It's not like... The court says, all right, that's even more. We don't have notes. We didn't take notes. I would assume they're talking to every witness is just my feeling. I'm ready for the jury if they're ready. So now the jury is brought in. Oh my gosh. Oh my gosh. Just completely shut down. And again, the court's assuming the court knows everything and knows what's available to be discovered or turned over or not. Oh no. Here we go again. The court says, okay, be seated. Get Mr. Autry, please. Who else had a birthday? I know you did. Who else? Somebody had one this week. Who was it? The attorney? I thought there was another juror. A juror says, somebody this week. The court said, I don't have one tomorrow. A juror, you do. You get some golf balls if I can get back home. What? So the juror's trying to get the judge golf balls? The court says, not going to happen, okay? My daughter went off to school. Of course, anytime she played in a tournament, she'd win something. There were 24 Pro Vs on the coffee table, and I told her mother, I said I'm taking them with my stuff because they'll be dry rotted before she gets to play again when she's off to medical school. All right, let's continue. Oh, chat. Like, literally, what is going on? Oh my god, why have I not added what is going on to this? That needs to be here. Do I have room? I'm gonna have to kick a picture of Adam Abate out of my files here in StreamYard so I can make more room. But header number 5, my favorite header and emotion of all time. What is happening? And I don't see it say, okay, there it is. What is going on? There we go. My favorite header. Maybe I'll just like tessellate it and make a background that just like has it all over the place for when we watch the hearing. Instead of this like generic background that StreamYard has for me, I'll replace it and it just says, it's Doug Bates and a speech bubble that says, what is going on? So anyway, they continue. If we move forward, let's see. Past this birthday conversation, we've got some pointing at the drawings again, lots of writing. They're on Duck Farm Road. All right, let's see. So much pointing. The maps are added as a collective exhibit. More pointing. Okay, wait. Okay, is this the good one? I think this might be... I think we're getting to... All right, so Ms. Thompson's still questioning their... General Nichols says, with that, which is generally the way you do it without trying to introduce a mugshot. Oops. So the court says yes. Ms. Thompson says, so Mr. Autry, how tall are you? You're 6'7" tall, aren't you? That's pretty close. And how much do you weigh about? I guess around 250. And your hair is dark brown, is that right? I thought it had a little gray in it. Its original color was dark brown, is that right? Yeah, I guess so. General Nichols says, Judge, we gotta have the jury out. So the court says, all right, take the jury out. Let's give them 10 minutes. So sidebar or proceeding outside the jury presence. You guys know what I mean. If they're not standing at the sidebar if the jury's out, but I'm calling them all sidebars. Judge, I'm going to ask for the hearing to be outside the presence of the media. The court says, y'all approach up here just a minute. This is the good one, guys. This is the good one. This is the good one. So whereupon a conference was held at the bench between counsel and the court. So they do sidebar this outside the presence of the jury. General Nichols, I would like to have a hearing on the relevance, but I don't want it on television because this is a letter from Jason Autry to Ms. Thompson praising the Lord for the representation of Mr. Adams, saying that Jennifer Nichols is a hired assassin, and talking about somebody I have sitting on death row from 2011 that's fixing to be overturned because I forged documents. All of which, of course, is not, the court says that's not relevant to this trial. Ms. Thompson, it is relevant, Your Honor. The court, wait. General Nichols, before we go any further, I don't believe it's relevant, but if it's determined to be relevant, that's one thing. But if the court thinks it's not relevant, I would prefer that kind of thing not be out there because it has absolutely no bearing on this case. The court, all right. So it's a letter praising her. And Nichols jumps in and says, from him, from Autry, calling me an old snake. So she doesn't want the media to hear. So all of this, just because someone says it doesn't mean it's true. But she's so concerned she doesn't want the media to hear that Jason Autry is accusing her, hey, you're about to have a case overturned because you were forging documents, you old snake. And the court says, in criticizing you, Ms. Thompson says, it's more than that. He says, General Nichols, let the judge read it. Please take your time. The court reviews document. For what purpose are you offering? Ms. Thompson says, if I can see the letter again, maybe we can reach a solution by redacting. Yes, you did get here just in time. King Riggs. The court says, I don't see anything relevant in this letter, his praises of you, nor his assertions or criticism of her. I know that I said assertions and hearsay, the inmate that was criticizing or whatever, General Nichols, somebody that I put on death row. Ms. Thompson, he talks about the court. I don't care if he likes you or dislikes you. I don't care if he likes her or dislikes her, Ms. Thompson. But he talks about how Mr. Adams is innocent. I think that's important. He says, please allow me to thank you for your firm stance to continue to take on Mr. Adams. The court cuts her off. His opinion, whether he is or not, Mr. Thompson, it is because now he's testifying he's guilty. So remember, we are at a point where there's no notes from any of these proffer sessions. So there aren't available statements for Jennifer Nichols to use for prior inconsistent statements to impeach Jason Autry as a witness. She has this letter where there's like a slight opportunity for her to get to Jason Autry's changing statements. And not just changing statements, but potential pressure. Because if you're referencing the lengths that somebody might go to get somebody on death row and maintain that conviction, and you're able to ask Jason Autry, well, you'd already had this notice of intent filed where you knew the state was going to seek the death penalty for you, but let's line this up. You did not think that Zachary Adams was guilty. That would mean you didn't think you were guilty, but you started changing as time progressed and you were facing the death penalty and trial was set. This is like the limited opportunity because strategically the prosecution made sure that there would be no discoverable, notes from law enforcement being present at these proffer sessions, that she could get something in. And Jennifer Thompson cannot impeach this witness, the star witness, who in my opinion is an absolute liar. So And the judge is just like, so. And even worse, the jury doesn't get to see it, but the media doesn't get to see it. So really not very transparent. And Aaron says, first of all, it's impeachment material. Second of all, it's directly relevant to the motive and bias of the key witness in this case. And again, it's like very limited. It's not, there's no argument to be made that this would be cumulative because there's other ways that we can show this. So use something else besides this letter. And then Jennifer Nichols goes on. Well, Ms. Thompson says, well, it is because it's relevant because he's testifying he's guilty. Jennifer Nichols butts in and says, the solution here is to ask him, has he ever asserted all of their innocence, which he has? This is almost comical, and what I want is a copy of it. The court, his interview, I think that they smuggled into Riverbend. He was saying innocence. Innocent man walking. Miss Thompson. And that's actually where that's from. Well, that's the next thing I want to put in. The court says no. So wait a minute. So they're like, Your Honor, there's other things they could introduce. And the court comes up with an idea. And Miss Thompson's like, okay, well, I want to put that in. And then they're like, no. like, what are we doing? Miss Thompson. So at the top, he says that the court, you can ask him if he's ever said that Zach Adams is innocent. That is it. Miss Thompson. How about if he wrote to me and said Zach Adams was innocent? The court. You can ask him if he did that. This is not going to be, it can be filed as an offer of proof. Miss Thompson. Okay, I'd like to file it as an offer of proof. General Nichols. Also Jennifer Nichols. General for Nichols. Can it be filed under seal? Because I really don't want the public, the media, to get wind and start talking about how someone's death row conviction might be overturned because I messed something up, or because they might be factually innocent and that somebody thinks I'm a snake. Can it please be filed under seal? The court, it's not going to be passed to the jury. General Nichols, I don't want it sitting out there where anybody with the media can come look at it. The court, all right, it will be filed under seal. General Nichols says, for my own reputation. Now, this is where I wish Thompson objected to this. And I really think, urge the court that they need to hear from the media about this access. Because the media isn't hearing the sidebar. So the media can't say, hey, we have a right. We want to be able to see this information. We oppose this being filed under seal. And the only reason given for this ruling is, and the court made the ruling before the reason was given, but General Nichols says, for my own reputation. That's not a reason for something to be withheld from the public. So they mark it as 185. It will be filed under seal. Can you get this? Ms. Thompson says, can I get a copy of it or keep a copy of it? The court says, yeah, this is not to be disclosed to the media. Ms. Thompson, I haven't disclosed it so far, Your Honor. I've had it since 2015. The court, all right, let's get that. Just show filed under seal, and she can put an exhibit number on it. All right, you got about 5 minutes. Whereupon the above mentioned document was marked as exhibit number 85 under seal. And so again, this is volume 9, right? Let me drop a link to this. In case you guys want to do anything you wish with that, since we don't have the letter, it's filed under seal, but we have a transcript talking about it, specifically Jennifer Nichols talking about she's worried about her reputation. At least we have a transcript talking about it. All right, so they said they'll bring the defendant in and take up your motion in limine. All right, we're going to take up outside the presence of the jury. The state indicated they've got a motion in limine that probably needs to be addressed. I simply made inquiry. Do you really intend to try to bring that up? She said she did. The motion in limine will prohibit her from eliciting any response from him concerning possible membership in the Aryan Nation being incarcerated. Is that essentially... Ms. Thompson, Yes, Your Honor. I'd like to raise the issue of Jason Autry being in the Aryan Nation, because part of what the Aryan Nation is they have these 88 truths, Your Honor. And one of their mantras that they go by is that you're not to rape any white women. And so based on the fact that they're not to rape any white women, it gives Jason Autry a motive to have concocted this story just as he has, where he's concocted that he's present for the murder, he's even complicit in the murder, and a responsible party in the murder. But yet at the same time, he has exculpated himself from the rape of Holly Bobo. I say that he has a motive to do that, because being in the Aryan Nation, if he's found to have raped a woman, he would suffer these horrible consequences in prison, including possible death. So that would be his motive for creating a lie like this, Your Honor. I say that because we have a right in a criminal case. It's a constitutional right to present a complete defense. This is an element of our defense in that we have all kinds of motives for Jason Autry to do what he's doing. And because we're using the third-party defense in this case, that is, Mr. Adams is not guilty and another person has done this, we have a right to bring this information in. The court, here from the state, General Nichols says, in our opinion, Your Honor, it's just an attempt on the part of the defense to throw at Mr. Autry anything that they think will cast some light. Being a member of this horrible organization is, of course, something that is bad, but it doesn't go to his credibility. It doesn't go to truthfulness, untruthfulness. This is not a case that involves race issues in that the people accused are Caucasian. The people charged are Caucasian. She just explained why it would be a race issue, because specifically one of the mantras, the 88 truths, is that you don't specifically rape specifically white women. So to say, well, everybody in this case is white, that's not addressing the argument. That's not addressing the point. The investigators are Caucasian, and the witnesses, for the most part, are all Caucasian. I understand this leap that she's trying to make. He can be asked all these questions about, doing it, not doing it, and all that without getting into his membership or ex-membership, I guess, in that organization. This is crazy. I don't get... I mean, if I was the state, couldn't you kind of just morph that into some degree of like, well, he's willing to be truthful about everything except the thing that will cause him to face risk of death in prison. So do with that what you want. But then they'd have to admit to putting him up there and knowing that he's not truthful. Yeah, like they literally, like the whole point. Okay, and Adventure Aaron says the judge's basis for that 404B ruling, so I think back to the Dillon statement, is basically that it showed continuous scheme among co-defendants. Autry is still, at that point, Autry is still a co-defendant. So as such, Rule 607 and 608 allow me to offer 404B against Autry. Yeah, General says, it's bad for our case, Your Honor. So the court says the court deems it irrelevant whether or not he is or is not a member of Aryan Nation. Has nothing to do with the case of Zachary Adams that is on trial today. I don't see it as something that should tarnish his credibility, because you've already, oh my gosh. To even say tarnish his credibility shows that you have given him, it's like you've started off believing he has 100% credibility instead of weighing it based on what's being presented. And now you're using that to say, hey, I don't want his credibility to come down a notch, so we're not going to let this in. You can ask him to impeach things. You can ask him things to impeach his credibility, but whether or not he's a nation, that's a totally collateral issue. We're having enough trouble concentrating on this case without trying collateral cases, which is exactly what that would be. So no, it's not coming in. Ms. Thompson says, Your Honor, for the record, it's my understanding the court intends to go tonight until I finish with Jason Autry. The court, I would like to, yes. Thompson says, but I would like the record to reflect it's very hot in here. Right now, I'd say it's 80 degrees in here. I see the jury sweating, different people in the courtroom fanning themselves. The court, I'm hot too. Everybody, I've been watching this jury. They're ready to bring this thing to a conclusion. Ms. Thompson, I recognize that, Judge, and so by making us go late tonight, the jury is only going to be harboring ill feelings towards me. And we got to watch this part. The court says, I hope we don't go late at night. Ms. Thompson, well, I still have quite a bit. The court, if you continue to go through this, you do so at your own peril. Ask legitimate cross-examine questions, but let's focus. We spent, I guess, well over an hour on these maps. Fair enough, she did. She did do that. Certainly, that could have been done in a more succinct manner. Probably would have been better for the jury. But still, to keep the court late, to force cross-examination with the witness that the state did not say they planned to call today is wild. It is wild. And I'm not against you bringing up legitimate points, but let's don't be redundant. Well, you just stopped her from bringing up what I think is a very legitimate point about, on one hand, why he might not be telling the jury the truth. And although she didn't directly get into this, but on the other, the state might be aware that he's not telling the truth. So here he is. Here's Judge Creed McGinley saying, I'm not against you bringing up legitimate points. But let's just don't be repetitive. I think it's in everyone's best interest that we finish this witness today. I disagree. I do not think that that's in Zach's best interest. And quite frankly, he's the one that matters here. So they say, let's bring our jury in. Ms. Thompson says, I would like to do an offer of proof as to the Aryan Nation information, Your Honor. The court, you need Mr. Autry out to do that? Yes, Your Honor. All right, bring Autry in. So they bring Autry back in, and the judge says, all right, go. So it's going to read like testimony, but remember, this is for the offer of proof. It's outside the jury presence. Mr. Autry, you're a member of the Aryan Nation, aren't you? I was. One of the rules of the Aryan Nation is you're not to rape white women. Isn't that correct? That's true. And so if you were found by members of the Aryan Nation to have raped Holly Bobo, it could bring you great harm in custody. Isn't that right? That's correct. And so that's all my questions, Your Honor. Any follow-up? And then we have cross-examination by Nichols. Isn't it also a tenet that you're not supposed to be doing this week? That's correct. And to do so, you're doing so at your own peril. That's correct. End of offer of proof. All right, bring the jury in. And then Jason Autry stands. And then as soon as the jury gets in, the court says, be seated, please, ladies and gentlemen of the jury. I would like, if at all possible, for us to conclude the testimony of this witness today. As a result, we'll be running a little later. Defense counsel has an absolute right to cross-examine the witness to cover any areas that she feels appropriate. I've told both sides to please try and focus their examination. So hopefully we'll pick it up a little, but I would like to finish this witness. Let's see. All right, he's nodding. All right, the immunity agreement. All right, so they dismissed the jury for the day, it looks like, going into the recess. We're about an hour late than I would like to. I think they stayed till like 7:30, which is a bit more than an hour later. And then he says, let me see counsel. The court, I just don't want the press overhearing this. I don't know after this testimony if the state is willing to renew any offers. Uh-oh. We heard about this. I don't want the press hearing this. I don't know after this testimony if the state is willing to renew any offers. General Nichols, I'm sorry? The court, well, I particularly don't want the press to hear it, but after the testimony all day long on Mr. Autry, I don't know if the state is willing to renew any negotiations or if the defendant wishes to entertain any. If you do, I want no part of it, but that's up to y'all to discuss, okay? And then whereupon the following proceedings continued within the hearing of the courtroom. All right, we're in recess. Oh! All right, volume 10. All right, this is a bit shorter. It's only 133 pages. All right, and they're calling it day 6, I'm calling it day 5. All right, so the judge swears in 2 more officers to guard the jury. So they get new officers. State's ready to proceed, and who do they call in? Oh, they've got the note. That is the jury question asking about what is discovery? Where does it come from? It says something you need not be concerned with, but I'm going to give you a general explanation, kind of as part of your law school education. I bet you that wrap will come off before the day is over. A juror says, oh yeah, the hairs are sticking up now. The court, yesterday was a little muggy, so we try to start out with it cool. The law has evolved. At one time, they called things trial by ambush. This is essentially telling this jury that this is not a trial by ambush. One side did not have to tell the other side anything. As the law evolved over time, a case in its strongest, since it's a search for the truth, whether it be a criminal case or whether it be a civil case where someone has sued somebody, discovery is applicable in both of those, civil and criminal. That's where the attorneys, because of court rule, have to furnish to the other side certain material so that we do not have a trial by ambush. They have to advise them, essentially, of what evidence they intend to present, and it can apply equally to both sides. So I hope that answers your question. It's not something you need to be concerned with others other than curiosity. And I know because you've heard 404B, you've heard discovery, you've heard all kinds of things that might be outside of something that you're used to. Those are things that we must concern ourselves with. I'm doing this just simply to satisfy your curiosity. All right, call your next witness. And then Brian Vitt, it's the lawn mowing guy. Yeah, K. Rake says, question, what is discovery? Answer, something the defense doesn't have. Oh, good times. All right. All right, exhibit, a witness is sworn. All right, Brian Vitt is excused. Randy McGee is called. Got some phone numbers. All right, that witness is excused, and then Brenda O'Brien is called. Brenda's excused. Angela Scott Smith, that's Jason Autry's ex-girlfriend, sworn in. All right, witness was excused here. And General Nichols says, Your Honor, our next witness is Victor Dinsmore, and before he comes, may we approach? So, sidebar, Mr. Dinsmore, as I'm sure the defense is aware, court says, wait just a second. Are you picking this up? Okay, you're good. General Nichols, Mr. Dinsmore, as I'm sure the defense is aware, has very, very, very strong opinions about the guilt of Zach Adams. Well, he didn't used to until after his May 18th conversation with with Brent Booth. But I'm here mainly as a precautionary measure that the defense needs to be aware to watch what they ask him. I will instruct him to answer the questions, but if they get him going, we've been up there to visit, if you can. The court says, we get primarily to the point, that is, he got the gun and treat him for the drugs and where it went. Is that not it? General Nichols says, no. The court, there's more than that? General Nichols, because he witnessed the fight between, they came to him the day of. The court, okay, that's right, I remember. General Nichols, and truly what I'm up here for was just to watch him, because a lot of what he says is just, well, I heard from the world that Zach said. The court, all right, we'll try to rein and be cautious. So now the jury, they're back in the presence of the jury, and they call Victor Dinsmore. Weird little approach. Weird approach. All right, he's doing some pointing. Some exhibits are entered. He's pointing again. His immunity agreement was entered. All right, and then Victor Dinsmore is excused. They take a morning recess. The jury leaves, and that is the end of Volume 10. Oh. All right, so volume 11. Again, I'm calling this day 5, but they're calling it day 6. All right, they start off by saying, let's come to order, please. For the purpose of the record, I told the state's attorneys, as well as defense attorneys, that they need to caution their witnesses, that they don't need to be watching through television or internet the testimony that's given in the courtroom. There was some mention that someone had seen the testimony of Mr. Adams. It's not technically a violation of sequestration rule because they haven't been told that. But I'm saying, just out of an abundance of caution, I want both sides to tell their witnesses or potential witnesses that they're not to view testimony that's given in the courtroom. She said, I said Adams. It was Autry that he said he had seen. Mr. Gonzalez, this is Jerry. We knew what you meant. The court said, you knew what I meant because there hasn't been an Adams to testify. Jury was finishing up with restroom duties. They'll be here in a moment. I think we saw this. I think we got to watch this. And then Hagerman says, Your Honor, we told you we were starting with a shorter witness. She had a slight health issue, so we're just going to start with a longer witness. Court says we'll go to about 12, so we're probably going to even be breaking up direct testimony if I anticipate. Is it who you said yesterday? Yes, sir. The TBI agent? Yes, sir. Okay, I'll probably go to about 12:15 when we break it up. So the jury enters, and then they call Brent Booth. And he spells his name B-R-E-N-T, not Brett, not Brett. And then let's see. Let's find more of these sidebars. He's nodding. He does nod his head very affirmatively. He takes Brent Booth's nod, he'll like pause and go. All right, so a lot of pointing. All right, so let's see. Court says let's break for lunch. Hagerman says, yes, sir. The court says, then after that, we can go over that poster board and anything else. Yes, sir. So court says, follow the admonitions I gave you at the outset. Your lunch is waiting. I don't know what little goodies they have for you today, but they'll have something good. Take 1 hour. So the jury leaves. Don't discuss your testimony. And then they bring the jury back in. So nothing interesting here. What are we doing? So the jury comes back in and the court says, I don't think that needs to be an exhibit. It says happy birthday with a smiley face, jury. So I don't really call that a question. I don't think it needs to be an exhibit. Your well wishes are appreciated. Great way to spend a birthday, isn't it? So the jury sends the judge a happy birthday note. They're doing all of this for Adventure Aaron's birthday. Hey, Tatum. All of this birthday talk, it's because it's Aaron's birthday. Hilarious. He says, I don't think this needs to be an exhibit. All right, so the jury loves this judge. The jury loves this third chair prosecutor. So the witness comes back in. Let's see. He's doing a lot of pointing. All right, more exhibits. Oh, and they have a short break here. I think this is just where they were taking a break. So Thompson says no further questions. Hagerman has no other questions. They release Brent Booth. Oh, no, he's still under the subpoena by the defense. Court says, all right. So he's not actually released. And then Brent Booth is supposed to remain outside the courtroom and not to witness any news reports. So then they take a recess. They say, let's come to order. I want to make the attorneys aware. We've got 3 smokers. I thought it was 2, but we've got 3 smokers. In order to accommodate them, they've got some area. I'm not even sure where it is. They take them. I know it's high because they said if you've got fear of heights, they might have to decide whether they want to smoke or not, but it's fairly remote. Earlier, when they were smoking, someone drove by, and as I recall, the sheriff described it was a loud pickup truck and hollered, F. Holly Bobo. I'm assuming this is some random redneck, okay? I don't think it was any type of attempt to influence anything. Sheriff is not even sure that the smokers heard it, but I just want to make sure y'all aware of that. It's tragic. I could make some statements like he might have had a flag sticking out of the back of the truck and some other things. Like I say, just a random event. Somebody thought they were being clever. And that also makes me realize why they could not go to the ball game, okay? It's being provided for them electronically. I didn't fully think through that decision, and I particularly didn't think through it when I knew I forgot we were broadcasting. But we very well could have had a major event there, even trying to isolate them. So they're not going to be out. And I understand they're going to get the Tennessee-Florida game tomorrow. So we've got Alabama fans and everything. I guess they're just out of luck. Although I wouldn't be surprised, knowing the way the officers are treating this jury, if they wouldn't try to get Alabama game for them. I mean, they're being treated as nice as you can, which I would expect because there's a lot of sacrifice by these people. Just wanted you folks to know that. Y'all ready to proceed? General Nichols nods affirmatively, and then they bring the jury back in. So Steve Deaton is called as a witness. Oh my goodness. We've got, let's see. More exhibits. Oh, who's this witness now? All right. Servinia Braswell is on the stand now. All right, so they have a sidebar. All right, so they excuse the witness. The court says, we get her report. General Ragland says, we did enter her report. The court says, it was in evidence. I want to make sure it's here. General Ragland says 207. And then Nichols says, may we approach? Court says yes. General Nichols says, can we be done for the day? The court says, do what? General Nichols, can we be done for the day? Right now? Nichols says, uh-huh. The court, you know I get a promise when I turn out early. General Nichols says, you saw how we paid off yesterday. The court says, okay, yeah. General Nichols, I mean, this is why we're not going to finish. It's Frizzell. There's no way it's going to be done. Court says, okay, we'll do them first thing in the morning. I'm sure they're getting fatigued. It's hot. So this is the day after Jennifer Thompson can't get a break and they've got to go till 7:30 when the jury's hot to finish her cross-examination of Jason Autry. But the next day, look at how we're accommodating the state. I'm sure they're getting fatigued, it's hot, and that's probably going to spare y'all anything come Monday. I told them to have some fluff ready for Saturday if need be, but I don't think y'all will be going before Monday at the earliest, okay? So wherefore, then now we're back within the hearing of the jury. The court says, will it hurt your feelings if I send you to the motel? A juror says, absolutely not. The court says, that's what I thought. It's hot in here, and we're advising back and forth. We're probably ahead of schedule, but this is a logical breaking time. It will let you get a little rested and relaxed, and then those of you that want to watch Hardin County Tigers on the computer screen, they're going to set that up. The sheriff told me. They've had some electronics people have projection screens. You don't want to watch the Tigers, don't watch the Tigers, okay? Once again, follow the instructions I gave you at the outset. No discussion. Keep an open mind as best you can. Put this out of your minds and avoid any news reports. Don't discuss it with any or allow it to be discussed in your presence. Any outside communication is done in the presence of an officer. I think I've sworn at least 40-something, so they've got plenty of people that they're rotating in and out to make sure the rules are followed. Questions? All right. We're going to go a half day tomorrow or somewhere around that. Then we're going to take a break on Sunday. You'll get the day to yourself. They'll probably have some entertainment. I understand that potentially there'll be a worship service if you want to participate in that. In other words, our religious beliefs are very close and personal held. I'm not going to force anybody with any type of religion. I'm a strong believer in separation. If you want to, I understand somebody is coming to the inn and you may attend that. If you don't, personal preference. Got any questions at all? Thank you. So then the jury is let out. And then the court says, let me say this. What I said to her was in jest. It was just something I said the other day. I said if somebody wants to quit earlier or something, I said, they're going to have to promise me a little something on the other end, so I'm not trying to direct their case. General Nichols, I will say that we had one witness today who was under subpoena and who got sick. The court, you indicated some health concerns, I understand. General Nichols, that was one reason we had. We had one more that I hope to get here in the next day or two, and then the court, and I've told the defense kind of, for their sake of planning, they will not be going before Monday, so you can relax on that. I told them they may have some short type witnesses available tomorrow, but that's not necessary. Monday at the earliest, okay? And I got you an order of transport. All right, we'll be in recess. So Then there's a short break. Then the court says, Aaron, can you take this? Another Aaron. The reporter says, take what? The court says, nah, it's an officer I'm going to swear in. So the reporter says, oh, okay. The court says, one that's going to do the football game. The reporter, oh, sure. Mr. Scholl says, Judge, may I approach? This is Jason Autry's attorney. The reporter, do you want this on the record? Mr. Scholl, Mr. Autry is set for report and is held on a day-to-day basis. I don't anticipate he is needed anymore. I'm asking if we can be excused from the court date until we contact your office for the court. Sherry will get us something. Mr. Scholl, the state's asked me to sort of stay in contact with them, so if they need me, I will drive back from Memphis to be here. Court says, okay, I'm going to wait. This one is in the rearview mirror, and then we'll have status on the other two. Mr. Scholl, I knew we were technically on the record for him to report, so I needed to put something on the record. And then Derek Frazier is sworn in. And that is the end of day 6. They come back on the next day. We're still on the same volume. And again, this is day 6 to me, not day 7. So the jury comes in. Good morning. The jury says good morning back. Judge says, I know you folks are getting tired of me. We're going to push this through to the logical conclusion, though. The logical conclusion. So please be patient. My teams aren't doing very well. The Cardinals lost yesterday. The Hardin County Tigers lost last night. But I have hopes, okay? I have hopes. And then maybe the Titans. Who knows? We're ready to get started. You want to? I guess we are. State ready? State's ready. The court, defendant ready? Yes, Your Honor. All right, call your next witness. So then they call Debbie Doris. So, let's see. All right, now they have Michael Frizzell coming on. They're introducing a bunch of exhibits. And there might be a lot of parentheses just for phone numbers. All right, so the court takes a break after Hagerman passes the witness. They bring the jury back in. And then Frizzell's back on the stand. Oh. What? No questions, Your Honor. Maybe they don't. You're free to go. Do they call him back later? I think maybe they called him in their case in chief. I forget. So that witness is excused. And then who do they bring in next? Candace Wood. So that is the girl that is at the coon hunt. That says Shane Austin was staring at her. All right, and then they excused that witness. And then that was all that they had for today. So then the jury leaves the courtroom. And the court says, let me ask if counsel can spend a few moments just for purpose of trying to streamline. I anticipate, I don't know, as far as I know, you might have 30 more witnesses. But if we can kind of give them some estimate time frame. Nichols says Tuesday. Court says, all right, but you might be done Monday. Nichols says, I say we'll be done Tuesday, could be done Monday. The court, same as I said the other day, you might have someone waiting that I guess I would define every witness. I'm not going to call them lesser, but some of them certainly more material than others. I don't even know if you're going to put on witnesses, but for sake, you might be ready Monday afternoon, okay? Is that fair enough? Ms. Thompson says yes. Anything else? Nichols shakes her head negatively. Can she shake her head positively? The court, the minister that's going to be doing the brief service that I told is totally optional. He and his family are very gifted vocalists and musicians. I think they intend to do some music, so anyone that's going to be present with these jurors, I will be putting under oath as an officer of the court. So I want to make sure everybody understands that. I will use the same form that will be done tomorrow morning. We've already arranged to do that, but I've already got a form like I handed you the other day that's available, so I will list their names. If anybody wants to check it later on, there's nobody remotely associated anywhere that is not going to be sworn as an officer of the court, okay? Anything else? Ms. Thompson. Maybe about the jurors that possibly heard somebody yell about Holly Bobo when they were out smoking. Do we want to question the jurors just to see if they heard anything for the record? I don't know. The court. I don't think it would impact the court if they did or did not. It's just a crude, rude something. I hope they didn't. And I don't want to get into, in all honesty, despite the fact I've taken great pains and I've had a whole lot of cooperation, people have honored my request not to have placards, t-shirts, support, or anything else. And the court sees this even if it was heard as an isolated incident that wouldn't have any impact. Okay? Anything else? Ms. Thompson says no. The court says anything else? Nichols says no, sir. And then they end, and the volume ends there. So volume 12. All right, and again, they're saying day 8, I'm saying day 7. Oh, yeah, let me check on you guys over here, because when I'm reading, I can't really see what's going on in the chat. Kay Riggs says the judge cares about everyone except the man whose life is on the line. Oh yeah, so Kay Riggs, they call Jonathan Reeves, you're right, instead of Frizzell. So they don't cross Frizzell, they just call Reeves. And then we've got, just want to make sure I'm not missing any questions. EJF is checking in, saying, checking in for Aaron gang, we have another member. The court reporter. Lawnerd Amber says the optics are so bad. The day before, Miss Thompson says, please, it's hot. Judge says no. Next day, state says, please, it's hot, judge. Judge says, you're right. You're right. All right, so the court here says before the jury comes in, I'll say I've been alerted that some people might have been in the audience, might have been making facial expressions or mouthing things. This is a courtroom, folks. If you're observed doing something like that, if you don't like their answer, you don't mouth something else or anything like that. If you're observed doing that, you'll be removed. You won't be readmitted. Everybody do all right over the weekend? I'll tell you on my teams, the Titans were the sole exception. Every one of the rest of my teams got beat. Right from the high school Tigers to the Cardinals to the Vols, it's not been a good sport weekend, but the Titans did really well. I'll tell you, we continued to fight climate control problems. The sheriff got some fans, but too much noise. So he's going to try to find some quieter ones that will circulate the air. We're starting 30 minutes early, so that'll hopefully we can quit a little early when it gets really hot. The sheriff, the jury's ready, Your Honor. Bring them in. All right, he says, be seated, please. We're starting a little early, so hopefully we can finish a little early. Supposed to be a high of 89 today. We get this many people in here. This unit is under capacity. So we're going to do the best we can. I'm not going to say, did you have a good weekend? Was it reasonable, though? Let me just say that. You guys saw the Tigers get beat on Friday. You saw the Vols get beat on Saturday. The Cardinals have lost their last 3 games. I've had a pretty good run with my sports teams. Like, oh my gosh. Mister, what are we doing? I've had a pretty good run with my sports teams, but the Titans, you guys probably are not aware of this, won by 31 points. So if you're a Titan fan, you can take a little solace. But other than that, all of my teams got bounced pretty bad. Okay, we're ready to proceed. You want to call your next witness for the state? All right, so they call John Maxwell and they swear him in. What a time. All right, we got exhibits. They play a 911 call. All right, the witness is dismissed, and then they call Terry Britt. So Terry Britt is now on the stand. Court says, it's been going 30 minutes. Ms. Thompson says, Your Honor, we have quite a few materials for this person. We need a minute. Didn't know he was being called today. So I need a minute to get our materials together. The court says, it's been going 30. Let's go ahead and take a 15-minute break. Okay. So the jury leaves. All right, 15 minutes. Ms. Thompson, we have some materials in the hotel room, Judge. We need to go get those materials. The court says, okay, if we're a few minutes over, it's all right. So they take a break. The court said, I told them to hold the jury. Mr. Simmons indicated he thought that Ms. Nichols said something she wanted to take up outside the presence of the jury. General Nichols, that's correct. All right. General Nichols says, Your Honor, the next witness, of course, has a criminal history that both sides are well acquainted with, and it is my intention to ask him about his prior felony convictions, or elicit from him, the fact that he has them. What I wanted to address outside the presence of the jury is the fact that under the rule, you don't get into the facts of the underlying case because that's not an issue. And I hope to avoid me having to object on cross to that type of testimony. Perhaps the defense doesn't intend to elicit that anyway, but Mr. Simmons I didn't ask him, and he didn't confirm that, because Mr. Simmons might not know. So I thought better to address it now, before the jury comes in. Ms. Thompson says that we're not going to get into we're talking about that he had rape convictions. Is that what you're saying? You're going to mention that it's a rape conviction? General Nichols, absolutely. Both sides are entitled to get in the conviction. The court, what the conviction is. She said the underlying facts. Those convictions cannot be considered except for the purpose of his credibility. So underlying facts will not be coming in, okay? Thompson says, yes, Your Honor. And then, all right, bring in the jury. So they call Terry Britt to the stand. And he's sworn in. And then they have no further questions for him. So there wasn't another sidebar for that? That's interesting. They did argue in front of the judge for this one. They take a short break. They call the jury back in, and then they call Anthony Phoenix. So we're starting to get into the jailhouse witnesses. All right, then they call Jamie Darnell. Oh. All right, so then they take a lunch. Let's see. Oh, I think I remember this. You guys remember this? Someone says, you smell something? It smells like they turned the heat on. Somebody turned the heat on. Something's burning. We do too. Is the heat on? It's like they've turned the heat on. Smells like they turned the heater on. The heat? It smells like that back here. The court says, I smell it. What's going on? It's the heat. I think it's back on. No? Nichols says, can we take a 5-minute? So the court says, let's just go ahead and take a lunch recess until we can get our climate figured out, okay? It's one thing if we get a little warm. It's something else if they're turning the heat on. It might be a few minutes before your lunch comes in. We'll take right at an hour though. So the jury leaves. They say, okay, hopefully we'll have this figured out. You can step down. Don't discuss your testimony. 1 hour, and then we'll recess for an hour. Maybe slightly. He said about a quarter of before they were going to bring their lunch, somewhere around there. So they send for the jury. The jury comes back in, and Darnell takes the stand again. Oh my goodness. The case of burnt dust smell. Yeah, the good glow remembers. Oh. All right, the witness is nodding. All right, he steps down. Carl Statler's called. And then Corey Rivers is called. And then, all right, so that's the end of the volume. So there were arguments with some of these witnesses, but they did it all in the presence in the open courtroom. Volume 13. All right, so still day 7, or what I'm calling day 7. They call Sean Cooper. All right, and then let's see. Let's take a recess. It's right at 2. We'll resume at 2:15. Follow the admonitions I've given you from the outset. We'll try to quit around 5 today since we started a little early. They take a break. Jury comes back in. And then they call Jason Kirk. And then he's done. They offer into evidence, let's see, an identification, the Facebook post of Zach Adams. I think this was that like December picture from Facebook where he's like, who am I looking for? And he's wearing a camo shirt and appears to be walking into the woods. All right, so Christopher Swift is taking the stand. Oh. All right, the state rests. The state rests. And then the court says, all right, when they say they rest, that means they simply finished their proof in their case in chief. As I told you at the outset, they have the burden of proof. The defendant is not required to prove his innocence or prove anything, but they can present such proof as they wish or desire. We're going to take a 15-minute recess at this point, and then we'll continue. So they take a recess. The court comes back in with the jury, and Ms. Thompson wants to do the judgment for the directed verdict. The court says, do what? Ms. Thompson, I want to do my motion for judgment of acquittal before the jury comes in. The court, I thought you probably would. You haven't said a word, though. Ms. Thompson says, okay. The court says, I told him to hold the jury, so Ms. Thompson says, okay. The court, let's be fairly succinct, please. Ms. Thompson, yes, Your Honor. And then says, I'll be glad to hear you on your motion for judgment of acquittal at hold the jury out there. Motion for judgment of acquittal at the conclusion of the state's proof. Okay. And then so she makes it. All right, and then the jury comes back in. And then it's the defense case in chief, and they call Shane's mom, Rita Austin. All right, so let's see. Before this next sidebar, we're getting questions about Luke Evans. So your husband got an attorney for Shane Austin, didn't he? Yes, there you go, in 2014. And his name is Luke Evans, correct? That's right. And he's a family member of y'all's, isn't he? Yes, he is. Luke Evans negotiated with the DA at the time assigned to that case. Yes. Ms. Thompson, Your Honor, I'm going to object unless she has specific knowledge. The court, she just said yes. So then Jennifer Nichols says, and in fact, there were times when you were present at those meetings, correct? I was never present with Luke Evans and Shane Austin in any kind of discussions. Never. Did you become aware that your son provided information to the district attorney's office about, let me finish, about the kidnapping, the rape, and the murder of Holly Bobo? Ms. Thompson, Your Honor, I'm going to object. May we approach? So they do the sidebar. Ms. Thompson says, I object, Your Honor. I think she's trying to backdoor in some type of statement, some agreement and hearsay from Shane Austin that she couldn't get in directly. Whatever occurred, Shane Austin has passed away. Whatever has occurred between Shane Austin and the district attorney's office is not admissible at this point, and I object to her trying to get it in through the mother. The court, your objection's overruled. You can ask the question. Oh. So the court says, your objection's overruled. You can ask the question. Whereupon the following proceedings continued within the hearing of the jury. So we've got, do I need to repeat my question? Sure enough. Okay, did you become aware that your son provided information to the district attorney's office regarding the kidnapping, rape, and murder of Holly Bobo? So they're back. We were able to watch this. Let's see. More documents. And then the next witness is called Judy Evans. So that, I think that was the aunt. All right, and then they break for the day, but this volume continues. The jury's instructed, you know, don't look at news reports. Have a good evening. We'll start again at 8:30 in the morning. The jury leaves, and then the court says we'll try to run 8:30 to 5 tomorrow. And then that was it for those proceedings. They come back the next day, so this is what I would call the 8th. The court says, thank you, Mr. Gilkey. I never get tired of it. Probably need to get him a gavel and let him strike once. I will give this, bring another judge in, why not? I will give, this isn't really law school, this is just informational. but by and large, the number of strikes when they open court indicates the number of judges on the bench. If they strike 3 strikes, then they open. It will be a 3-judge appellate panel. If they strike 5 times, Tennessee Supreme Court. The exception, I think, is, and I haven't checked on it, but I've had the pleasure to be in the audience of the United States Supreme Court. Matter of fact, I've been there twice. Once I was introduced as a member of the bar. I don't think they strike 9 times, but generally that number of strikes has to do with the number of judges. Okay, little more information. We now know broadly about hearsay, 404B, discovery, and now the number of strikes opening the court. So, all right, we're ready to continue. Defense ready to proceed? Yes, Your Honor. All right, so they bring in Terry Dicus. And they enter in some exhibits. I don't remember if I remember a sidebar for Terry Dicus. Okay, so let's see. Thompson finishes her questions. The court says, let's take a recess, take 15 minutes. And while the jury's out, Ms. Thompson says, Your Honor, can we just make clear on the record how many photographs were in that collective exhibit? And then the court said, there's how many regular size and 1 teeny-tiny? Is that what you called it? Yes. And then Mr. Gonzalez says 5 large and 1 teeny-tiny. The court says, all right, teeny-tiny is what she said. Mr. Gonzalez says teeny-tiny. The court, you said teeny-tiny. General Ragland, that was 223? The court, a little photo, that's 223 collective. So they take a break and they send for the jury. And then that is the end of this volume. An enlightening discourse there at the end of that one. All right, so going into 14. And remember, there's 17 volumes, so we're almost there. We are almost there. All right, so they're on day 8, what I would call day 8. They just passed Terry Dicus for cross-examination, and then they start this cross-examination. I think is this where we get into the sock? The sock testimony. Let's see if we have sidebars. They're marking some exhibits. All right, they take a lunch break. They bring the jury back in. And then the court says there's more tablets in my office. There's still one up there, but you might get them and have them handy. All right, did you have a good lunch? Yes, sir. All right, given the context, they're taking pretty good care of you, aren't they? Very much. All right, all right. I know that the sheriff and his staff have gone out of their way. They realize that this is a hardship, but they're doing what they can to make it as pleasant as possible. So I commend he and his staff. Let's call our next witness, and that's Art Viveros. So he's sworn in. They call Dave Barella. He's sworn in. They enter some exhibits. And then they call Travis Dunavant. Marking some exhibits. And then they take an afternoon recess. They bring the jury back in. They call Billy Bell. Is this whole day not going to have any sidebars? All right, and then they excuse this witness and they say, Your Honor, that's the last witness we have for the day. They get them out of here early. He says, I'm not going to jinx it if I tell you. I think we'll start your deliberations. He doesn't want to tell them when he thinks deliberations are going to start, but we're moving along fairly well. Follow the instructions I gave you. Yada, yada. And then they're estimating that the proof will conclude tomorrow. Is that a fair guesstimate tomorrow? Ms. Thompson says, I would say. The court says they're saying, but don't hold us to it. It's a very important case. I've tried to allow both sides the liberty to try their case with their techniques as they felt they are led. You folks know I'm high-geared, I'm time-compulsive. Sometimes it's hard for me, but I want them to be able to fully explore their cases. So I don't want to jinx it, but we're getting to where we need to be. It's also warmed up considerably in here, although it's been better today so far. So follow those admonitions. We'll see you tomorrow. And the jury's let out, and then the court says, going to give you some instructions. They're open to debate, but this should be fairly close. And I can't tell you how forward I'm looking to reading these, not. So they're talking about jury instructions. Ms. Thompson, are we going to have a charge conference after we read these today? No, there'll be time. Ms. Thompson says, okay. The court says, I don't want to push you, okay? Ms. Thompson says, okay, I just needed to know if I needed to stick around or not. And then the court says, no, there's a lot here. So that was the end of that one. And then 15. All right, so this is what I would call day 9 is starting. So the court goes on the record. I will tell you a capital case attorney has prepared the charge. I basically cut and pasted portions I might have deleted that I did not think were appropriate. I don't think I supplemented anything. She's very thorough. There's a lot of things that are raised in there out of abundance of caution that I'm charging. This charge would be the longest charge I've ever given in my entire career. The charge, I will say, is somewhat confusing. But the adversarial nature, it's up to you folks to argue to the jury, highlight what you submit the law says, okay? In other words, it's up to y'all to straighten some of this out. Been 2 special requests filed by the defendant. One of them, special request number 1, evidence which merely casts a suspicion on the accused is inadequate to corroborate an accomplice's testimony. I have no problem giving that. And then the other one is special request number 2. I will give that with the exception that it will be read. A promise of leniency or other favorable agreement is a factor you may consider. So he's going to give this instruction, but he's going to prune the wording that the defense wanted. General Ragland for the prosecution steps in here and says, Your Honor, the state would suggest that further on in the instruction about middle way, witnesses testifying against the defendant on behalf of the state of Tennessee have been granted or offered immunity from prosecution. So this is tailoring it to ink on paper for immunity from prosecution, or at least made a formal offer, which is very different than somebody just being told, hey, we're going to help you. We're going to try to work on your sentence. Because that's not really a formal offer. So in other words, prosecution, and the court's going with it, doesn't want the jury to be instructed that they should consider those informal promises of leniency. The court says, rather than granted, General Ragland says, because Jason Autry does not have, well, Mr. Dinsmore, the court says, all right, let's, General Nichols, he didn't sign it, didn't have it. The court, let's do offered/granted, okay? General Nichols says, there was also, the court, y'all can argue that. General Nichols, there was also talk by Mr. Austin that Shane was granted immunity, but then it was pulled back, so General Ragland, he's not a witness, though. The court, yeah, that has, Nichols says, I get it, there's just testimony. The court, and I'll never understand why he was offered, but that was the prior prosecutor. So they take a shot, I think, are they going at Matt? Who are they going at there? Beth Boswell? General Hagerman says, with regard to instruction request number 1, Your Honor, it says evidence which merely casts a suspicion of the accused is inadequate to corroborate an accomplice's testimony. Yes. General Hagerman says, I'd ask that, additionally be charged with evidence of an admission by the defendant is adequate to corroborate an accomplice's testimony. Ms. Jones says, I would say evidence which merely casts a suspicion on the accused is inadequate alone to corroborate. The court says, yep, put alone in there. Mr. Hopkins, that quote is actually directly quoted from the case that's cited. That's the reason it's written that way. It's not modified in any way. I'm assuming this is like a court assistant jumping in. The court says, well, I'm going to put a loan because you'd have to get into contextual to get the entire thing. I haven't read the case, but we'll put a loan and then we'll add the slash there. All right, and I'm going to call this preliminary because this is not yet cast in stone. Prior to final arguments, we will finalize things. I think we're pretty close to where we're going, but I wanted you folks to have the opportunity. I will say on the record that the state has somewhat of a quarrel with the order of the lesser includeds. Recognize what they're saying. They're saying that facilitation, like let's just take first-degree murder. They're saying that it should be murder 1, murder 2, facilitation of murder 1, so forth and so on. To me, that's illogical. Their argument, I understand, is because facilitation, the percentage, or at least classification percentage, would make it much less time to actually be served. But the jury is not to be concerned with punishment, and I think in grading lesser included, the court should not be guided by that either. General Nichols says, if I can just add, it's not just the percentage itself makes it a less serious crime, and then as far as punishment, as far as anything, punishment is what makes it less serious. The court, but if we go by pure definition, Nichols says, the court, I didn't, Nichols says, and case law is pretty set on it. The court, I will say I consulted, we can talk among judges, I talked with several, and they're in agreement with me. I didn't call the right judges in Shelby. Well, nowadays you could call Judge Jennifer Nichols herself, but I digress. I even had one of the Shelbys said, I think you're right on that. But Judge Sexton, I called Judge Watson because I knew that facilitation would have to have been charged in the, quote, Vanderbilt rape case, and he was in agreement. Judge Morgan, I wanted to make sure that I was basically being fair and I'm comfortable with what I'm doing. Mr. Simmons, that's for the defense, says, which way are you planning to charge it then? First-degree murder, then not guilty of first-degree murder, then facilitation? The court says, yes. Mr. Simmons, that's what we're asking for. So the defense wants the jury to have to find and have a space to say, we found somebody not guilty. General Nichols says, of course you're asking for it that way. Ms. Thompson says, no. Mr. Simmons says, I don't know. Mr. Hopkins says, I don't understand what Ms. Thompson says. That's a different issue though, about what I wanted versus what they want. The order. One of the things I wanted on the verdict form, so this is the defense, because the jury instructions say they're supposed to, at each charge, they are to look at it and decide if the person is guilty or not guilty. If they decide the person is not guilty, they go to the next lower charge. The court, that's charged in there. Ms. Thompson says, so what I want on the verdict form is to reflect guilty, not guilty of each charge. She wants a space for each choice. Judge McGinley says no. Ms. Thompson, and I think the court, it lends itself to confusion. I'm comfortable with this jury. Ms. Thompson, I really am going to strongly object to that because that way, Your Honor, if they get halfway down, maybe they get hung on a lesser included, but they've already decided guilty or not guilty on some of the top ones. The court, okay, you can note your objection. I intend to charge as indicated here. General Ragland, Your Honor, there were a couple of nits I shared with Ms. Jones earlier this morning. I will put those on the record. We also talked about accomplice. There's still some language I guess we'll address later about which language to use. The court says, do what? Ms. Jones, like for example, just to point out to them that the things they have been previously highlighted under criminal responsibility, you left in. The court, yes. General Ragland, then the court says, I think it's without question Jason Autry is an accomplice, and I think that can be charged. That second paragraph there, rather than make the jury find that he's an accomplice. Ms. Jones, this is one that's still highlighted in the event the defendant were to testify. Mr. Simmons, what page is that? Ms. Jones says page 39. The court, well, they're going to have to call the EMT if he does, because I'll pass out. She'll pass out. What? Ms. Thompson says, I'll pass out. So you have the judge and Zach's attorney saying they'll pass out if the defendant takes the stand. And I understand that a defense attorney might feel that way about their client wanting to take the stand. But that is a lot to say to the judge, with the judge, for the judge to say, and for your attorney to say, while you're sitting there in the room and you're about to be asked if you want to testify. When we've already had someone pass out on the stand in this trial. So Ms. Jones says he's just indicating when he was commenting. These things still need to be. And then the court says, I told her yesterday, to charge the second paragraph rather than have the jury making a finding on accomplice. Mr. Simmons says, what page? Ms. Jones says 40. General Ragland says last paragraph. The court says yes. General Ragland says not the one before. The court says right. General Ragland, on page 43, alibi, there's been no evidence of an alibi, at least not yet. That's crazy to read when we're hearing Amy Wyrick scream in the opening statements rewatch. The jury heard everything. We shot that at the jury. The jury heard everything. And then they're concerned about whether or not there's even a reason to give an alibi instruction in the jury charges. So General Nichols says none. Let's read that again. General Ragland, on page 43, alibi. There's been no evidence of an alibi, at least not yet. General Nichols says none. Now remember, Terry Dicus has already testified. I think we're just missing Jonathan Reeves, and I don't know if they've tried. I think we're going to get to John Walker. But still, they're saying here that anything Terry Dicus testified to doesn't relate to alibi evidence. General Nichols says none. But then Wyrick and Nichols are going to tell us in these post-conviction hearings that the jury heard everything. It's crazy. Ms. Thompson says, well, there's going to be, as far as our cell phone expert, he's going to talk about where these phones are located and things like that. General Nichols says, that's not an alibi. The court, I debated. General Nichols, there is no. General Ragland, cell phone is not an alibi. The court, there is discussion that through Dicus, that Autry, that Zach was alibied by John Dillon and by General Nichols says Shane. The court says Shane. General Nichols, but he hasn't given an alibi. He may. Miss Thompson, Dick Adams. So that's Grandpa. General Nichols, Dick Adams did an alibi. He said he saw him at 10 or 11. The court, no, he didn't, like 10 at the Shell station, and doubt was cast upon that. I'm still open to that. General Nichols says, so we can discuss that one later on. So, court says, yes, I'm not begging trouble. Miss Jones, and you said you wanted to take this one out? The court, yeah, she had one cause of death. There's no question cause of death, so that doesn't go in. Miss Jones, that's page 44. General Ragland, the duty to preserve evidence on 47. There's been no evidence that the state has failed to gather, preserve evidence. The court, the only reason, and it's very collateral and peripheral, was Miss Jones, Dana. The court, Dana, I was trying to think of the daddy's name. Said he had to put up purple tape. General Nichols, that wasn't the preservation of evidence. People were already around. The court, take that out. General Nichols, he's simply, the court, y'all can argue the scene was contaminated. There's no evidence. General Nichols says, I think it was. Miss Thompson, what about the sock in Shane Austin's trailer? General Nichols, what evidence is that other than he masturbated? Miss Thompson, well, you all raised the question that it might have been something else other than the court. Then it was clarified that it wasn't. General Nichols says, yeah. Miss Thompson says, okay. The court, no, I'm not going to charge that. Miss Thompson, what about painting the trailer with lead paint? General Ragland says, the state didn't do that. General Nichols, how do we preserve that? What was preserved? That doesn't have anything to do with this. Miss Thompson says, the scene, whatever the state was implying had been covered up by the lead paint, wasn't preserved. The court, I'm not charging it. General Nichols says, no. The court, matter of fact, there's gobs and gobs and gobs of evidence that was preserved. So the court is, even though this is not in front of the jury, the court is like saying there's gobs of evidence. Like this is kind of like on the record bolstering the job that the state did. There wasn't any concerted effort to hide or not collect anything. Matter of fact, it kind of was overboard, so we're not going to charge that. And if y'all can agree to leave out anything else, I'd be happy to. General Nichols says, well, I think all of us would probably like to talk, but I think there'll be some time after all the proof has come in and before you charge and before closing that we can. The court says, okay. General Nichols, round up and see if there's anything anybody agrees to. Ms. Thompson says, are we going to charge the jury before closing? The court says, yes. I think that's very important because you, and Ms. Thompson says, I agree. The court says, if you don't, they don't know what the elements are. They don't know what the lesser includeds are. I would like to have charged it all the way on the front end, but that couldn't be done in this case. Ms. Thompson says, right. The court said, I made a stab and then I recognize that it can't be done. General Nichols says, at least the state is going to need some time anyway before closing. Before opening, closing. General Nichols says, before first closing. So we'll make time for that as well to see if there's anything else we can agree on. The court says, okay. General Nichols says, while we're here and on the record, we do want to address our motion in limine regarding keeping out the pornography that was pulled off of Mr. Britt's computer. I think Mr. Christensen is going to argue it. In a nutshell, he admitted there was pornography on his computer, didn't deny any of it. It's not relevant. The only purpose for offering it would be just trying to make him look bad. He already does, so we're not finished. The court says, can you demonstrate that viewing pornography of any type, whether it's, quote, good or bad, as I said earlier? And then General Nichols says, that didn't come out. The court says, makes one less or more likely to commit a crime. Can you, Ms. Thompson, we can argue this. We're not arguing it now, right? We're going to argue. General Nichols says, I want to argue it now because there's no point putting it out there. Ms. Thompson says, well, I need a minute to gather my materials on that. The court says, okay, well, before we call, and then Nichols says, they have a witness here for that purpose. The court says, well, before we call any witnesses, we'll need to take that up. Ms. Thompson says, was that a state's motion in limine about pornography on Mr. Britt's computer? General Nichols says, doesn't matter whether it was or not. We can make one at any given time. So now we have information that there's a witness here. The purpose of his being called is to put on a stack of horrific S&M. The court says, he's already admitted. General Nichols says, pictures. Ms. Thompson, well, he denied that he was doing searches on. Nichols says, no, he didn't. He just said, Ms. Thompson, kidnapping. General Nichols says, he said you open it and you can look at. General Ragland says, it all comes up. Ms. Thompson, but he denied specifically that he was doing a search for kidnapping, rape, abduction, and we can show that he was. The court, I don't know that he did deny that. Ms. Thompson, he did deny it. General Nichols, that's different than introducing the pornography. If we can find in the record that he denied it, then I think you can ask this person if it appeared to them that he did those searches. That is no reason to introduce the porn itself. Ms. Thompson, let me get my materials together on that. Court says, okay. So we've got General Nichols saying, but I would like to go back in the record and see if we can find whether he actually did deny it, because I don't remember one way or the other. The court, well, he said he got a lot of things that popped up. General Nichols, pop-ups, pops up. The court, that's different than someone typing in a Google search or some other search. General Nichols says, right. If he did and this guy knows it, the court says, okay. General Nichols says, no objection. Mr. Simmons, so you're objecting to actually introducing the pornography itself? The court says, yeah. General Nichols says, absolutely. The court says, yes again. Mr. Simmons, not the fact that he was looking for it? The court says, yes, yes, yes. General Nichols says, or a description of it. Here's a picture of a woman with this or that. The court says, okay, you've got 5 minutes. So then they say this is the end of the conference in chambers, and then the jury is brought back in. So then they call John Walker. So I think we might get some sidebars here. He's sworn in. Oh, and I don't think this was really a sidebar. I think this is where they do the voir dire that we watched. So they do this offer of proof, and this was on the record, so we watched this. Yeah, so that wasn't really a sidebar. All right. And now we're going to have a sidebar. So right after being told I can't comment on that, I'm not allowed. Not allowed by who? The U.S. Attorney's Office. And then General Nichols turned. Do you remember when Jennifer Nichols turned to the audience and says, "Is he allowed, Mr. U.S. Attorney?" That's what this part is. Mr. Brackstone says, "May I?" General Nichols says, "Is that a yes?" Mr. Brackstone says, "Approach, Your Honor." General Nichols says, "Sure, let's approach." So they have a conference at the bench. Mr. Brackstone says, "Just in the interest of not yelling in front of the jury, if General Nichols says, "Let me ask a question." Mr. Brackstone says, hold on. General Nichols says, "Stop for just a second." The court, "Wait a minute. First of," General Nichols, "he's not supposed to be privy to this yet." The court, "No, just a minute." General Nichols, "That's all I was trying to say." The court, "You need to identify yourself first of all. She doesn't have that." So Mr. Brackstone says, "I'm David Brackstone." That's D-A-V-I-D, spells his name. Assistant United States Attorney in the Western District of Tennessee. The court, "All right. Mr. Brackstone, if the question is whether he was part of the investigation in 2013 or later, then he can answer that question." The court says, "Okay, I think that's what the question was." Mr. Brackstone, if the question is, have you heard rumblings through your time just working in the department, then that would be off limits. So to General Nichols says, "That wasn't my question." Mr. Brackstone, so I understand the confusion of your question. Just were you on the case? That's totally fine. The court says, "Okay." Mr. Brackstone says, "But if it's getting into, what were people talking about then that would be a..." The court says, "Okay, we're good." Ms. Thompson, can he explain that to his client then? The court, "Yes, I think rather than client, it's supervisory capacity." All right. So now back in front of the jury can hear again, and then they ask this question. Let's see. They don't make it all that far. And then, let's see. A lot of this is a longer argument while the jury was listening before they come up to the bench. So this is Thompson saying, "You performed a lot of other activities in this case. Is that right?" "Yes, I did." "Interviews?" "Yes." "Analysis?" "But those items were not requested that you testified about them." "No, they were not." "So you're not authorized to say what else you knew about the case or what else you did in the case, right?" "That is correct." "Had that been requested?" Nichols says, "Your Honor, I'm going to object to relevance." The court, it wasn't requested, and the last bench conference, we covered some things." "I know, but," the court says, "you don't need to open the door to what we covered in the bench conference with his superior." Ms. Thompson, "Right, but my point, Your Honor, is," Jennifer Nichols says, "I'm going to object to relevance to anything he hasn't testified about. How can anything that he was asked to do or did, if it's not being testified to, be relevant?" Ms. Thompson, "She just went through such a long fuss with him about what he did know about the investigation, what he did do about the investigation. I can't cross-examine him about all the rest of the investigation because he's not been authorized to testify to it, Your Honor." The court says, "Let's move on." Thompson says, "Okay, no further questions." Court says, "Done." Nichols says, "Nothing." And then the witness is dismissed. He's free to go. And then Simmons asks to approach before he's excused for a break. So the court says, "Well, hold on, Mr. Walker." The witness says, "Yes, sir." So now they're at the bench or at the sidebar. Ms. Thompson says, "Did his attorney leave? Can we grab his attorney out the hall?" The court says, "Wait a minute, yeah." Mr. Simmons, "Jim Simmons, Your Honor, for the record in this case, to be clear, right now it is clear he has knowledge of other areas that he would have been asked about, but his attorney or the Department of Justice has advised him it's outside the scope of the 2E letter. I would like for the record to be clear in an in-camera discussion or hearing as to exactly what is being excluded from this record and why. We shot everything at the jury. The jury heard it all." I want the record to definitely be clear about an agent who has additional knowledge and is being precluded about testifying to that knowledge, just for the record. General Nichols, he's testifying within the scope of what the defense requested, so it's not being excluded. Perhaps he would have been approved to talk about other things. So General Nichols is pointing out, well, they didn't send this 2E letter. So they could have tried to make this permissible, but she says he's testifying within the scope, and we rested. I don't care if something is put in camera, but not in front of the jury. Mr. Simmons says that's exactly what I'm going to ask for, to be in camera on the record. We don't know the interpretation of the TUI request. The record needs to be clear in this case. General Nichols says, indiscernible. TUI letter filed it and have it filed. We can, indiscernible, do TUI letters. Mr. Simmons, I think we need this testimony to be clear, the reason that it's being excluded. The court, it's not being excluded by me. He's been prohibited. Mr. Simmons, that's correct, and that's why we need the record to be clear about what's going on. General Nichols, can we do that later? Mr. Simmons, yeah, that's what I said. We can do it later. General Nichols, he doesn't need to be here, the U.S. Attorney. Mr. Simmons, I think we may need him to be here. The court, do what? Mr. Simmons, I think he made the witness may need to be here. General Nichols, the U.S. Attorney. The court, needs to be in camera. Mr. Simmons, it does. I agree with that. So Mr. Braxton comes up. He says, Your Honor, David Braxton again. I'm happy to consult with Mr. Walker again, but my understanding is that the information that he may have would not otherwise be admissible. It is not indiscernible, came out, but what he was concerned about discussing and not came up as pertinent in the investigation. So it says, whereupon the following proceedings continued within the hearing of the jury. So they say, let's take a recess. The jury leaves. They say 15 minutes. And then the court says before the jury comes back in, we're going to put some matters on the record during the lunch hour regarding the U.S. Attorney and TUI issues. So we'll do that so that we can keep moving with the jury. But U.S. Attorney did tell me, he's present, that the witness, Mr. Walker, has testified as far as he can testify, and he will cover other issues in chambers, okay? Stay with us, I apologize. All right, let's bring our jury. Do we have, that's all they put on the record there? So they bring out Garnett. The jury comes back in. Oh, and they call Christy Gutskell. I forget how to actually say her name. Well, that was a lot. All right, Jonathan Reeves is called. He's entering some exhibits. All right, and then... All right, they're looking for a spreadsheet that they compiled. Thompson's saying, I don't know if it was printed or not. If I can have a minute to find it, Your Honor, there's a spreadsheet, and I'm looking for all these papers. I can't find it right now. And then the court said, I think he said he wasn't sure it was published. Ms. Thompson says, no, it was the witness. I know I've prepared and emailed it. I don't know if I ever printed it. The court says, okay. Ms. Thompson says, okay, I think I need to print it. It's close to lunchtime. Would it be possible for us to take our lunch break now? The court says, we can do that. Usually they bring their food in about this time, so we'll go ahead and take our lunch recess. You folks take about an hour. We'll call for you. So follow the admonitions I gave you at the outset. So the jury leaves. The court says, Mr. Simmons, you want to take the matter up in there? Mr. Simmons says, yes, sir. The court, so I'll need the state attorney concerning the TUI issue. General Nichols, okay, we're going to do that now. The court, I'll need the court reporter. Why don't you just stay put? We'll clear the courtroom and shut the cameras down, and we can just do it here. So let me ask everyone to be excused. Camera down, cameras down, correct? All right, thank you. All right, you ready to go? Says, okay, you can put anything on the record you want, Mr. Simmons. So Mr. Simmons says, Your Honor. Jim Simmons, my concern is given the TUI restrictions by the federal agent that the record in this case is incomplete, I think, in two respects. And the first is as to Mr. Walker's, I believe it was during the out-of-court offer of proof, which he was not allowed to answer. If I remember correctly, certain questions regarding to, number one was the devices and his training, which enabled him to capture the information that he did. And the lack of that information, the training and expertise, I think is the basis for the court's ruling that he could not be qualified as an expert. So what we have is a ruling by the court based upon the lack of information, or potentially the lack of information, which was precluded by the attorney for the United States advising Mr. Walker that he could not testify as to those areas. The court says, let me say this, maybe we can cut to the chase. If the court had allowed him to testify, is that not the same information we're getting from Mr. Reeves at the present time? Then Ms. Thompson steps in. So Jim is spelling it out. Jim Simmons is spelling it out. The court says, If Mr. Walker came in, wouldn't it be the exact same thing as Mr. Reeves? So what would the jury be missing? Ms. Thompson's like, it is similar, yes, Your Honor. This, to me, screams ineffective assistance of counsel. This is worse than her failing to qualify him as an expert. This is her saying it would have also been cumulative. In a way, acknowledging incorrectly that Walker's analysis and the work that he did was the same thing. So yeah, this to me is just wholly ineffective assistance of counsel. It is similar. And then the court goes, so it would be cumulative at any rate. So even if this is not a proper reason to keep it out, well, then you're conceding that it's proper to keep out because it'd be cumulative. So this is something that I'd seen earlier. I think I might have tweeted about it or put it in the Discord. I don't remember. But I looked at this and I was like, oh no. Oh no. Then General Nichols says, if I may just add in, it's actually, the information he gathered is actually almost identical to the information that Frizzell testified to. This guy, and I forgot his last name. I'm sorry, I think they're dry vacuuming or drilling, if you guys can hear that in the background. So sorry if it's loud. This guy, and I forgot his last name, Reeves. The court says Reeves. General Nichols says, I'm sorry, summed it up at the beginning, saying he had a more nuanced and detailed approach. Unequivocally, nobody is going to dispute that even though he's not an expert, Walker did not have this additional information. He had less information. So, but the court says, but would it not be, General Nichols, he's still not an expert. The court, at best cumulative. General Nichols, the phone part of the cumulative, what Reeves is adding now is not. Wouldn't be cumulative because he has more information, but he's an actual expert and we stipulated to it. Nobody's trying to keep the information. Court says, all right. General Nichols says, from the jury. The court, but a U.S. attorney is present, and he had made the statement earlier that concerning the other things that were elicited, that they wouldn't be allowed into evidence at any rate if I understood you correctly. Mr. Brackstone says, yes. Good morning again, Your Honor. David Brackstone from the U.S. Attorney's Office. I have spoken with Mr. Walker, and beyond very specific details, which would be law enforcement privilege, and sort of outside the scope of the TUI discussion, there are two areas of information that Mr. Walker may have that were not covered here. Were not requested by either the prosecution or the defense in their TUI request. So there are different areas that would not be cumulative, but nobody asked for it. One of those areas of information, in my estimation, would clearly be impermissible in court, and it's essentially what he heard in the hallways of the Marshal office or the FBI office, just people talking about the case. So the court says it would be hearsay. Mr. Brackstone says no, hearsay and lack of personal knowledge and potential privilege issues. The second area of information, is it? So because it's an FBI office, is there an expectation of confidentiality in the hallway because it's in a particular office? Because that's kind of an interesting reason. The second area of information that gets to what hasn't been raised yet, but was raised at the conclusion of his proof, that perhaps he had additional information about the investigation. That information is what Mr. Walker gathered from interviewing other potential parties of interest, shall we say. There's been no request, again, for testimony about those interviews. And frankly, without having that request in front of us, the time to discuss that potential testimony with Mr. Walker, with his superiors, look at the underlying records, we're not in a position to determine whether that testimony would be authorized. And so with the respect to the technical aspects, there's some details of exactly what was done that Mr. Walker wouldn't be able to testify with the extent, or to the extent that it was about his knowledge of the investigation. Certainly half of it would be impermissible, and the other half we just haven't had a chance to analyze. So Nichols says, and with respect, the court says, well, he was allowed to go into great detail concerning the interview with Terry Britt, and he did so. Mr. Brackstone, correct, Your Honor. But when you bring in semi-random third parties that haven't been made an issue in this case, it does become more complicated. The court says, all right, you want to put anything else on the record? Mr. Simmons, says, yes, Your Honor, that's the basis of my request for a hearing was. It does become more complicated and is not on the record, because for appellate purposes, it's going to be a blank record as to what those issues are and what his knowledge was. And based upon his knowledge of what they were, then you can speculate. The court says, but if we bring him back in, he's going to claim privilege. Mr. Simmons says, that's the court. So we can't get it on the record. Simmons says that's the basis of my objection or my request for a hearing is the record is going to be incomplete. And without a complete record, the appellate court has no way to review what may or may not have been testified to based upon his inability to answer it because of his position with the United States government. General Nichols says, I would like to add at this point that there has been extensive testimony elicited by Ms. Thompson regarding not just the number of other people that were looked into, but also by name. So it is clear to the jury at this point that many, many people were looked at. So that part has come in. And that, it's not as though the record is silent as to the fact that the court says, court rules it's, General Nichols says, yeah, cumulative. Court says, let me ask you, do you know who Bob and Leanne Toohey are? Mr. Brackstone says, I do not, Your Honor. The court says, do the rest of you know? Nichols says, the Tooheys? How does he get football in every way? The court says, did you see the movie The Blind Side? General Nichols, yeah, I was like, I know who the Tooheys are. The court, about Michael Orr? General Nichols says, yes. They were the parents. Mr. Brackstone, well, as a Memphian, I feel like I have derelict in my... The court says, well, you need to go. Brackstone says, in my local knowledge. The court says, watch The Blind Side. It's a great movie. Miss Thompson, it's a great movie. Yeah. The court, great movie. Okay, let's take our lunch recess. So they end with a football note. General Nichols says, Judge, before we go off the record, I provided, if I can have my sticky back, I provided the defense with information I got regarding the pornography that they sought to introduce. She keeps framing it like they want to play the videos for the jury. I found out from the agent that there were 3 searches, and I'm going to read you what was given to the defense. Britt searched nudevista.com for the term rape, abducted, and kidnapped on January the 12th, 2012. The second thing is there is an image file named abducted in 2009, an image file. And another search for the term abducted on 8, it says abducted videos. I think they're looking for on August 1st, 2011. So I told the defense that it is the state's position that any search done after the disappearance of Holly Bobo would be irrelevant. The search done, the image file done before would not be. And that was our position. Our position, the court says, in other words, you have no objection to them asking what he searched for prior to her abduction. General Nichols says, correct. Ms. Thompson, well, Your Honor, the purpose of this information is Mr. Britt got on the stand and said no, he had never done any searches on those terms. And that's not true. He has done searches on those terms. We're willing to not put in the pornography pictures. The court says, we're not going into the specifics. You can ask as to all of those. You can show a continuing course of conduct or in furtherance of covering something up. So I'm going to allow you to ask to all of them, but we're not going into the specifics, okay? Ms. Thompson says, well, okay, I'm sorry. I'm not clear on. The court says, you may ask them. I think Thompson's shocked that she got a ruling in her favor and that Nichols isn't winning this one. At least on that very specific what's left over. So the court says what they recovered, and they're going to testify there are 3 specific things. 2 prior to Holly's disappearance, 1 was after. And then Nichols corrects and says 1 prior and 2 after. The court says, okay, beg your pardon. Nichols says, it's all right. The court, I had it reversed, but I'm going to allow you to ask all 3 of those. We're just not going to get into the images. Thompson says, that's fine, we don't. The court says, or anything else. Just the fact that the search was occurred. What was the subject of the search? Ms. Thompson says, yes, Your Honor. The court said, and he's probably heard all this he wants to hear. Mr. Brackstone says, Your Honor, I was just waiting for you to break and conclude that you can be excused. All right. So Mr. Brackstone, and that also Mr. Walker is, the court says, yeah, he can be excused as well. Mr. Simmons says, Your Honor, before. The court says, yes, yes. Mr. Simmons, I guess I need to make an objection for the record as to not being allowed to thoroughly examine Mr. Walker and for the reason stated. The court, he's saying that he couldn't testify to that. Mr. Simmons, and my objection, the court says, okay, Mr. Simmons, would be overruled because there's, and the court says, I'm also saying that based upon what I've heard here, the other witnesses and other things, it would be cumulative anyway. And you got somebody that is qualified as an expert on cell phone technology that's going through all this material. So it's cumulative. All right, take your lunch. So the court says, all right, I've sent for the jury. They get the witness back in and Reeves, they bring Reeves back in. All right, okay. So there we go. They get Reeves back up there. That was a long one. That was a long one. Okay. We've got some exhibits coming in. And that was the end of this volume. So we've got 2 more volumes to go. And we're going to speed through them, but they are like tearing apart my appliances. So just so you know, when we get done with these volumes, we're going to zip out of here. This is set to redirect over to Nick Starr, who I know is starting at 5 p.m. So in about 2 hours. I have no idea. I have not been able to check any messages. But I know Happily Angry Lawyer also mentioned he wanted to do a stream on Moonktünk. So let me check real quick. I don't see anything scheduled on his page currently, but just so that's on your radar, you guys. Let's do this volume 16. Oh. All right, so this is cross-examination of John Reeves. All right, still entering exhibits. Okay, wait, what? Do I remember this? I don't know if I remember this. So they're talking about the drive tests. Hagerman says, that's it, Judge. Oh, wait 1 second. I just want to correct a typo with him. The witness says, did I miss one? Hagerman says, there is. And witness says, or 2 or 10. Hagerman says, page 12, I think I asked you to write that number, the page number down. Yes. Hagerman says, can I approach with this? Court says you may. Hagerman says, exhibit, Judge, it's just not trying to trick anybody or anything like that. And then there's a note here that says, whereupon the attorney and the witness stand whisper, whisper at the witness stand. So Hagerman says, I'm going to, with your honor's permission. It's just a typo. It's not intentional or anything like that. At the top of the page, 12 of this exhibit, I'd like for the witness just to change the time to what's actually correct. And then he says, I incorrectly wrote 8:23 instead of 9:23 a.m. All right, so that was sort of a witness sidebar, whisper, whisper. All right, so they let him go, and then Mr. Garrett is called to the stand. So James Garnett. And we're almost through this volume. So he's excused. And yeah, there we go. Jury is dismissed. Jury leaves the courtroom. The court says, be seated. All right, Mr. Adams, have your attorneys advised that I want to discuss with you your decision whether or not to give testimony? The defendant says, yes, sir. All right, stand up, raise your right hand. By virtue of the Constitution, we all have certain rights. One of those rights is you can't be compelled to give testimony. You were present when I read that to the jury at the outset. Said if you do not take the stand to testify, that they can draw nothing from that, that's constitutional right. Also, you have a constitutional right to give testimony if you wish or desire. You can take the stand. If you do, you would be subject to a cross-examination and your credibility would be judged by the jury by the same standards I've already charged them. This is your decision, okay? You can make it having consulted with your attorneys. I would expect you to consult with your attorneys, but this is not their decision. This is your decision. You're standing there between two of your attorneys. Mr. Gonzalez came on the case late, but you've had ample opportunity to discuss it with Mr. Simmons and Ms. Thompson. Is that correct? Yes, sir. Having said all of that, is it your election not to give testimony? Yes, sir. That's right. Correct. Are you doing this freely and voluntarily? Yes, sir. You don't feel you've been pressured either way? No, sir. To give or not to give? No, sir. This is your decision? Yes, sir. All right. The court says, want to address anything further? Thompson and Simmons say no. Court says you can be seated. There's no reason the attorneys have to feel that Mr. Adams can't make an informed decision, like no type of mental illness or disease or anything that has arisen during the course of this entire time that you feel like would make him unable to make that decision. Mr. Simmons says, no, Your Honor. And then the court says, all right. The other thing, you want to renew your motion. Mr. Simmons says, all right, at this time, Mr. Adams would renew his motion for judgment of acquittal pursuant to Tennessee Rules of Procedure 29, would simply indicate that the state has failed to carry their burden of proof as to all counts. The court says, all right. We went into more detail at the conclusion of the state's proof concerning corroboration of an accomplice and some other things, but those factors still apply, and the court feels it's a jury question, okay? Earlier, there were pretrial motions to dismiss certain counts, but by this court's actions, obviously, I'm not dismissing any counts. You understand that? Mr. Simmons says, yep, Your Honor. Court says, all right. The state has indicated that they do wish to present a rebuttal. So let's get our jury in. And I've told counsel that a trial is a search for truth, and rebuttal testimony should be confined to rebuttal. It's not just an attempt to see who can hit the ball last. I think that's the analogy I gave earlier, but I expect you to confine your proof to the rebuttal or surrebuttal as it might be. All right. So then the jury enters. And let's see. Did we get any sidebars with the rebuttal? Getting an exhibit. Got Jack Van Hoosier. He's excused. And then no surrebuttal from the defense. All right, they excuse the jury, and then the court says, early morning charge conference, I told the parties what I was charging, so I don't see anything changing on that. I'm going to go get the charges ready to be placed into the notebooks. If somebody notices something overnight, and don't start looking for stuff because it becomes very difficult to substitute it in. We ran into that earlier. So if it's something material, yes. Jennifer Nichols says, you indicated that you left open. Actually, maybe we approached because we had that conference back in chambers today, but there was one that left open in case something changed, but I don't believe it has. So they go to the bench. The court says, we'll be adding where I define what a stipulation is. Nichols says, okay. You indicated this morning that you were not inclined to charge alibi, but left it open in case they put something else in the proof, but there's been nothing else. The court said, the only alibi evidence was supposedly the 3 co-defendants. You can certainly argue that he wasn't there, but I'm not going to give an alibi charge, okay? So they saw all of it. They saw all of this alibi evidence, this subterfuge, according to Amy Wyrick in these post-conviction proceedings. But here they are again, not only after the defense has stopped presenting proof, but we've had the rebuttal and no surrebuttal. The close of evidence has happened. No more evidence will be introduced to the jury. And you have Jennifer Nichols still saying there's been nothing else. And that the only alibi evidence was supposedly the 3 co-defendants. But now in the post-conviction proceedings, they're saying over and over, the jury saw everything. All of the alibi stuff, none of this is new. And the jury's still convicted. This seems to not work. You can certainly argue that he wasn't there, but I'm not going to give an alibi charge. Okay. And then Mr. Simmons says, note our objection. The court says, okay, all right, we'll be in recess. And then there's one more volume. I don't imagine there were really sidebars during like the reading of the charges to the jury. But was there stuff in closing that went to sidebar? Let's see. Let's open this up. And let's see what, if anything's said right when court starts. All right, so they have a conference held in chambers between counsel and the court. So this is starting the day that they're about to do closing arguments. The court says the only purpose we're here, I'm modifying what I charged. She sent you an email yesterday. I will charge alibi. Upon further reflection, I said I wasn't inclined to do it. That's when the three of them were alibying each other. I forgot how dicus, it was rubbish or trash or whatever, that I would not really consider alibi. But when I got to thinking about Reese's testimony, I'm concerned the location of Adam's cell phone at the Bobo kidnapping, they didn't join until like after 9 o'clock. So at least as to kidnapping, some of those, I think it could be considered, doesn't have to be, could be considered by the jury as potential alibi. I will tell you, I would charge alibi if we were charging Autry. This guy loves Jason Autry. I will charge alibi with Adams. The other two I would not charge alibi, okay? That's just, I wanted to give you the benefit of my thinking, okay? Everybody good to go? They say, here's what we'll do. I'll charge them, and God, I dread this. I will charge them. We will take a short recess. We'll get the state's opening statement. Defense said they want just a few minutes to make sure the machinery is working before they do theirs, and hopefully we'll get all the until lunch after that. Okay, everybody good? General Ragland, yes, sir. The court, everyone feel good today? Hagerman says, it's all good, let's do it. Mr. Gonzalez, we'll feel better after. The court said, hey, I told the attorneys in a civil case one day, I said, I feel really good, don't screw it up, so I'm pretty good shape. Like I said, this charge is just a booger bear. Oh, not a booger bear. It couldn't be anything else with 8 and all the lesser includes. You folks all know my view on concerning facilitation. I don't like to charge it. I feel like it's absolutely necessary, so it's being charged, okay? So it's up to the parties to focus the jury on what they think the jury should do. It's not up to the court. I just put it out there. Buffet. All right, ready to go? Let's do it. So then they bring the jury in and they read the instructions. Let's see. Sidebars. Long reading. All right, so they now, let's see. They take the recess. Well, that's weird. Is this? It says end of volume 16 here, but I thought we were reading 17 and then it continues. So, okay, I think it was spliced up kind of weird. So then, all right. They come back. The court says, I mentioned to the attorneys yesterday, both sides, I'm not putting time constraints on you. Hope that you'll be mindful that the jury, this is the 10th day, ? And be reasonably succinct. But I realize that we've got 10 days of evidence. It's going to take a little bit of time, but I don't know that I've ever seen a closing statement too short. I've seen some that were too long and had adverse effects. So I might just tell you that you're to your own device and do so at your own peril. So the jury enters the courtroom. Let's see. All right, they're going to start with closing arguments, and Hagerman starts whispering to open up. All right, and then when Hagerman finishes, they do a 10-minute recess to check electronics. Are you all good on electronics? Gonzalez says, yes, sir. The court says, okay, the bathroom facilities are limited up there also. I'll tell you. I love my 1950 courthouse, but it's not prepared for these kind of electronic onslaught, nor the restrooms. And something that's ironic is they actually consulted the lawyers when they built this, and they moved that was before air conditioning, they moved the courthouse from the front out where the main road was to back here. Now we've got the bypass with more traffic than it would have had over there. But we've got the window shut. They redid the courthouse at Decatur County, and I don't think they consulted with the lawyers or judges or anybody. We're going to try to conclude unless something gets out of whack. I'd like for you to be prepared to follow it. It might. General Nichols says, I am. All I'm doing is switching from PowerPoint to overhead. The court says, what I'm saying, even if it's late getting the lunch hour, I kind of would prefer that if we can. Nichols says, no problem, and we'll be drawing the 3 alternates when we send them out for their lunch and to start deliberations. Those alternates will be kept separate and apart. They will still be sequestered. I'll let counsel know who they are, but I'm not going to announce it to protect their identity right now. I haven't done it yet, so. And then Nichols says, Judge, can we approach for a moment? They say yes. Nichols said, I said, sure, no problem, getting it before lunch, and then I asked Mr. Gonzalez how long. The court said, do what? Mr. Gonzalez, it's just that if we go past the lunch hour, she may want to break before she starts her rebuttal, and we predict that Jennifer will go past the lunch hour. The court says, I was hoping not, but we probably will. Mr. Gonzalez says, so take a break before rebuttal. The court, if I was her, I'd rather keep it short and get all of it done, but it's your option. If we get into lunch, I'm not going to punish these people. Whereupon the bench conference ended with the jury returning to the courtroom, after which the following proceedings were had. So closing statements start, and I wonder what it would be like to read her closing statement on paper. But, you know. All right, so Ms. Thompson's delivering her closings. She's playing the audios. Oh, she was running back his testimony, like clips of his testimony. All right, and then let's see. So the court says we're going to take lunch. And then jury leaves and the court says, I orally charged when we were trying the case, but I'm going to supplement just one brief thing concerning out-of-court statements can't be considered for the truth of them. She'll show that to you if you want to look at it. Fairly short, but somebody had mentioned that Shane Austin had said, and words to the effect, that you didn't need to kill him or whatever. I think that was what the statement he came through was. Came through the... General Nichols says it came through the defense. The court, defense counsel. Yeah, but still. General Hageman says, is the instruction clear, though, that out-of-court statements by the defendants? Why is this written weird? I feel like all of this is reading weird. The court says, yeah. General Nichols says, and other people. I mean, it's not all out-of-court statements. The court says, just read what we've got. General Hageman says, we'll read it. So General Nichols says, okay. The court says, it's not complex. If either side objects, I will not give it, all right? The defense actually raised it. If either side objects, I won't give it. So then they have a lunch break. The jury returns. And then the state starts with rebuttal witness. And Jennifer's like whispering to the jury. Sweet, tender whisperings. All right, so then they finish with the closings. Sending them back. Jury leaves the courtroom for deliberations at 3:08 p.m. The court says, y'all approach, I'll show you. Got that? Attorneys review a document. It's not going anywhere. Did you get these? Did they say what this was? Oh, so I'm going to give Frank, I think this is for the alternate jurors. Return these cards to me when you get everything. And then Ragland says, can I say one other thing about the evidence? The court says, yes, sir. General Ragland says, I understood from Miss Angel and Miss Jones that some of the items that are in the evidence bags, the items themselves were tagged. They've since gone back, and I understand they've tagged the evidence envelopes as well with an A. The court says, yeah. General Ragland says, okay. The court, that's so they can be preserved. There might or might not be other trials in this case, so we don't want to destroy the chain of custody. They simply will be adding the letter to it. So the bag, no sense in sending the bags out, but we're trying to preserve that, okay? General Ragland says, yes, Your Honor. The court says, okay. Ragland says, Miss Jones mentioned that to me, and the need to put it on the record. The court says, okay. General Ragland says, thank you, and there's a short break. So General Nichols says, may I ask a question? The court says, yes. General Nichols, the family has inquired, do they need to stay? Not that we're expecting a quick verdict. They want to know, will you give them time to get back? The court says, yes. General Nichols says, how much time? The court says 30 minutes if it takes it. General Nichols says, okay, so they can go sit somewhere else? The court says, yes. Nichols says, okay, and then they take a break. So they bring in the jury, the original 12. We'll be moving 2 seats down the back, 1 on the front, and then the alternates that are being kept separate and apart, they're now actually in my chambers. We'll also put them in the box because I want them to listen to some of these admonitions as well. They're being kept separate and apart though. Matter of fact, I kind of feel sorry for those 3. Nichols says, I do too. Hagerman says, me too. Miss Thompson says, no device, and sitting there looking at each other. The court, maybe they got a book at the hotel or something, and then they can delay bringing them in tomorrow for a while, you know. So the jury returns, and then they rearrange their seats. Someone says, hey, you can't pick that up. The juror says, I was fixing to say. The court says, all right, let's bring our 3 alternates in. So they come in. And the court says, no, you put the 1 on the front and then the 2 on the back. That's all right. Feel sorry for the 3 of them. They're more isolated than you folks are. All right, be seated, please. We're fixing to recess for the evening. He told me, I told him originally 5:30 or 6. He said you folks elected to work until 6, and then you want to go back to the inn rather than some alternative arrangements that they had for dinner for you. I want to remind you, don't make up your mind. You're following the same admonitions until you reach agreement after your deliberations. In other words, put this matter out of your mind. No discussion with anyone. And the 3 of you that are now alternates, you can't discuss with the other people. You'll be kept pretty separate and apart. But there could be no communication from the 12 to the 3 of you. You were drawn at random. So I hope you can appreciate that. Matter of fact, hopefully, they can give y'all a delayed reporting time tomorrow because looking at 4 walls is no fun. And they'll be using separate transportation. So y'all can spend a little more time in your hotel room or leisurely breakfast or whatever. Because I realize it's probably harder on y'all than it is the 12 of them. So I appreciate that. Do we have any other questions prior to breaking? And the jury shakes their heads negatively. All right, so the court's gonna, when you reach a verdict, knock on the door. Any other questions? No response. I appreciate your patience. I appreciate your devotion. I can tell that each of you have viewed this very seriously, which it needs to be. Needs to be viewed seriously. But you've been excellent jurors. I've watched. You've paid attention, and thank you for what you've done so far, okay? So you folks are all free to go at this time. Sheriff, you want to take care of them? And then so the jury leaves. And then the court says we need some place they can leave their notebooks. I told the others to leave their notebooks upstairs and the evidence. That room would be secured. Well, you can put them in my chambers. They got their names on it. I promise you I won't go through them. All right. Madam Clerk, you got the contact phones, right? Clerk says, yes, sir. Court says, so y'all just be available, I guess is what I'm saying. Miss Thompson says, so we don't come back in the morning? And the court says, you don't need to until you're contacted. Miss Thompson says, very good. General Nichols says, starting back at what time? The court says, I told the sheriff whenever they want to start. He thought it'd probably be about 9. Nichols says, thank you. And then they adjourn at 6:08 p.m. So they have a note. All right. So we get to hear about a note, I think. Is this where they read the verdict or did they have a question? I think they had a question. So they come back the next day. Court says, all right, hand me my note. What I'm going to do, I'm going to read the note. The court reporter is present. It's something that I can't answer because it would be a comment on evidence, which is inappropriate. So what I'm going to do, I will make a notation, send it back to them. First of all, I got a copy of the note as given. Then after I make notation on this, we'll make a copy of that, so it will constitute part of the record. The note reads as follows. Concerning count 5, element 2A, if the rape is, quote, closely connected with the other crimes, does the presence of a weapon later in the day matter for the duration of the rape? The kidnapping lasts much longer than the rape, and there's testimony of a weapon after the rape. And then that's the end of the quote, the end of the note. I can't comment because it's a comment on the evidence. I will put, the court cannot comment on evidence. The court is prohibited from commenting on evidence. You must refer to your judgment and your instructions. That will be it, okay? General Nichols, are you going to bring them in or just send her an answer? The court says, I'm just going to send them an answer. General Nichols says, good. The court says, that's why I'm writing both ends where you can see the question without the answer. Then you can see actually what I said to them, okay? General Nichols says, yes, sir. The court, and I can't write as good as whoever wrote this. Mr. Gonzalez says, pardon me, what was the last part? The court, I said I can't write as good as the person who wrote it. It's very good printing. So the conference ended, and the following proceedings continued within the next hearing of the courtroom. So, okay, You may be seated. I've met with the attorneys. I've told them we've got a second question. The first one I answered on the sheet of paper that they sent. I told the attorneys what it was. The question itself, and then the question plus the answer was filed as an exhibit just so the record would be complete. I've now got the second one. And I really feel that I owe the jury some explanation as to the fact that I'm not able to do a whole lot. As the attorneys know, the court's extremely limited once the jury starts deliberating and answering questions. Because first of all, it's absolutely prohibited for the court to make any comment on the evidence. Second of all, the jury, they've got the charge. Each one of them has their copy of the charge, and they are the sole and exclusive judges of the evidence and the exclusive judges of the law under the direction of the court. I've charged them. I can't go into further explanation. The question even mentions if I could go into layman's terms. I can't do that. So I want everybody to know what we're doing. But at the same time, I didn't want the jury to think that we're down here ignoring them. So I'm going to bring them in, and I'm going to ask who the foreman or forelady is, and then I'll go over the question with them, and then send them back out for deliberations. I will probably make a simple inquiry, but I'm not going to ask them but if they're making progress on the case. They're going to ask them if they're making progress? So whereupon the jury returns to the courtroom, and the following proceedings were had. The court says you can sit anywhere. I'm not bringing those alternates back in for right now. It's not necessary. You can be seated. Okay, I brought you back in because I feel like sent a question earlier. Her writing's better than mine. I had her write the response, and then I put my initials and dated it. That was my response. And we've now got a second question, and I don't want the jury to think I'm ignoring you. All indications are you're very deliberate. You're working hard, and for that I appreciate it. But I've now got the second question, and so I want to tell you why I'm extremely limited in what information I can furnish. Do we have a foreman or forelady? Yes, sir. All right. Mr. Cromwell, that's you. Oh, they said the name? I'll address this to you in the presence of anybody. The second question says, reference your guidance on page 8, paragraph 9, which is part of the charge, concerning what evidence is entirely circumstantial. There's a whole paragraph there, okay? And you have to be guided by this charge. But I'm going to read you something else, and I'm not doing it to emphasize this particular thing, but this part of the preliminary instructions. I'm doing this to try to explain why I'm very limited in what I can answer. Oh my God, just explain it. It's on page 4 if you want to look at it when you get back up there. Quote, you as jurors must base your decisions solely on the evidence you hear in the courtroom. Went on and said, you are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in the light of your own observation and experience in life. The reason I read that, it's impermissible for the court to comment on evidence. That's your sole prerogative. And then, as I said, you're also the exclusive judges of the law under the direction of the court. I've given you everything that I can give you as far as that's concerned. You've got it in your notebooks, and it's up to you what that says, okay? The foreman says, yes, sir. And so I brought you down because I don't want you up there thinking, well, he's just kind of blowing us off or whatever. I'm not doing it. I take my oath very seriously, and I try to follow the law. So I'm just simply explaining to you. Does that take care? The foreman says, yes, sir. All right, you'll understand that? Yes, sir. Anything further? No, sir. All right, let me just ask you, and I'm not asking particulars, but is this jury making progress? The foreman says, yes, sir. So are they not going to read the question? The court says, all right, that's all I was asking. You probably discovered yesterday that I essentially give in to you as far as your time, so forth and so on. So we probably want to operate close to the same time frame, but I'm willing to yield to you based upon what this jury feels is appropriate. Does that make sense? Yes, sir. In other words, I'm letting you set the timetable on this within limits, all right? The foreman says, yes, sir. The court, anything else? Thank you so much for your continued dedication. So jury leaves. The court says, I'm just going to add this to the other as cumulative. We probably won't get any more now. We might have saved some of that based upon, I basically tell them I can't tell them anything else. I've told them all I can tell them. All right. And this really bothers me because there are times where I've read appellate decisions where the appellate courts say, hey, when it comes to, we think there was an issue, we think a matter was important, they'll say, well, one of the juror questions pointed to this specific thing. So by curbing, and he's kind of bragging that he curbed the juror's likelihood of asking additional questions, you're reducing something that appellate courts could rely on and have relied on. So that's a whole time. So they mark it as an exhibit. They do make the question an exhibit, and then they have the verdict. So, and we know where that goes, chat. So I think that's it. I mean, I don't know if we get anything for sentencing on sidebar. Let's see. All right, so they're approaching sentencing phase. General Nichols asked to approach, and then the court says yes. They pass the document. The court says I was approached by attorneys at that time saying that if I could give them additional time, potentially there might be some agreement that could be reached. I think an agreement has been reached with a certain degree of reluctance, but nevertheless, the parties have indicated to me they're in agreement. So who wants to announce? So Nichols announces, I probably need the papers back to make sure I get the consecutive and concurrent. And then, all right, generically, the agreement is they're agreeing to sentence. The 3 murder counts would be merged in count 8. The agreement on sentence with the parties would be life without the possibility of parole. The rape counts would be merged for a 25-year consecutive sentence at 100%. The kidnapping counts would be merged for a 25-year consecutive at 100%. Now that generically is the agreement, is it not? Nichols says it is in a nutshell. It will be life without the possibility of parole plus 50 years at 100% to run consecutively. So, and I think we actually saw this play out. And then the court says, Mr. Simmons, as I understand and have understood, essentially you were designated by the defense team as the attorney that would handle the sentencing issue or that phase of the trial. Mr. Simmons says, yes, sir. The court, as has been announced by the court and further announced by the district attorney, is that correct? Mr. Simmons says that is correct, Your Honor. The agreement is life plus 50 years. The court says, all right, life without parole plus 50. And the court says, I told you that I would be addressing your client as to voluntariness. So I want you to stand. And yeah, he says yes, sir, to all of this. So then they bring the jury in. And we heard all that. The jury is dismissed. And then they have, remember, Karen Bobo. It was a stipulation that she'd be able to speak at the sentencing. Namely, speak at the defendant and not at the court. So there we go, guys. We got through, I mean, unless there's something I'm skipping here, but I think we got through anything that would be like an off the record, well, an on the record, out of the presence of the jury or in chambers event. So, yep, so that's all the stuff about the questions. Yep, alrighty. So there we go, we did it, chat. Now we've got hearings tomorrow, you guys. So remember, it's 8:30 Central that they're starting up because they're over in Tennessee. That means 9:30 Eastern. So that's about the time that I start usually. I've been starting at 10. So half an hour earlier tomorrow. We'll start on time. And we'll go until we don't go anymore. So tomorrow and Tuesday, prepare for that. I've been waiting for this all month, and I think all of you guys have as well. I see a super sticker here. Thank you, Derek. Good to see you, Derek. Missed you for the earlier parts of the chat. There was some craziness going on in these sidebars. So I hope you're doing well. Thank you so much for the sticker. But yeah, Trakisha says we are beyond prepared. We are ready. We are ready. I'm hoping for a new trial through and through. Christy, thank you again for having these transcripts. And you are welcome for going over it all. I can't wait to get a refill, drink something, because my throat's a little scratchy. But I'm excited, you guys. So I know Nick Starrow has a live coming up at 5. I don't know what Happily Angry Lawyer is doing or not doing, but you know, make sure you just hit that bell that lets you know when he does go live, in case he does go live. And then, yeah, because I don't see an update from him saying, but it's something he mentioned yesterday. So Mavhawk says, I've been listening in the background. I feel super prepared. Heck yeah, we're going to be there. And it is going to be Amy and Matt Boiano calling their witnesses, but Doug gets to cross. So we get to watch cross-examination by Doug Bates. So very excited for that. And other than that, that's going to wrap it up. I'm going to go see what's going on with my washing machine. Mavhawk says I'm more ready for this than I was the SATs. That's hilarious. Oh, love it. Max says preserve your voice. I think it's gone. And luckily, when we're watching stuff, I get to rest a little bit tomorrow since the court will be going. So with that being said, and there might be some guests in the morning, if we do have to pause the proceeding, I promise you we'll get caught up to the proceeding because they're going to take their lunch breaks and we'll get to skip that. But I'm looking forward to having some people share their thoughts on this whole case throughout the day tomorrow and or after court tomorrow. So hoping to see you all there. See you guys somewhere, Nick's this afternoon or in the morning. Everybody hope have a good rest of your Sunday and see you tomorrow. Bye guys.